Mr. Piazza?
Thank you.
He's not been sworn in yet.
Okay.
You may call your first witness.
Okay, I call Chad Carter.
Mr. Carter, raise your right arm. Do you swear to tell the truth, the whole truth, and nothing but the truth? You may be seated. Mr. Piazza?
Thank you. Mr. Carter, would you state your name for the record?
Chad Carter.
And Mr. Carter, did you file written direct testimony in this matter?
I did.
And is that marked as IUOE Carter-1?
Yes.
And sir, is this your sworn testimony?
It is.
And do you have any alterations or modifications to this testimony?
Yes, I do. On question 18, at the time of this testimony, this statement was true, but as of right now, I would like to change the answer to, I reviewed Dakota Access LLC's petition for hazardous liquid pipeline permit. I'd like to delete and all attachments, exhibits filed with the IUB by Dakota Access LLC, which is part of this record. I want to delete that.
And that's found on page 8,
8.
answer 18.
Yes.
And then additionally, you'd like to insert the word some.
Some in between reviewed, some information.
And is that because you have not had a chance to look at all the exhibits that have been filed since this hearing has
After
begun?
my testimony was written, correct.
Very good. Without further ado, we would submit Chad to cross-examination.
Thank you, Mr. Piazza. Mr. Taylor?
No questions.
Mr. Murray?
No questions.
Mr. Sandgren?
No questions.
Mr. Puntney? No questions. Mr. Zakrasik?
No questions.
Ms. Sorensen?
No questions.
Mr. Wells?
No questions.
Mr. Pauly?
No questions.
Ms. Jacobs?
I have no questions.
Mr. Wagner? You may step down. Mr. Blinsky, you may call your next witness.
Thank you, Your Honor. Dakota Access calls Joey Mahmoud.
Mr. Mahmoud, please raise your right arm. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. For the information of all of the parties before Mr. Blinsky starts, we're planning on going to right up to 11:30, 10 till. We'll break for 45 minutes. We'll come back and we'll do Mr. Lashir. And then we'll return to Mr. Mahmoud. Mr. Dublinsky?
Thank you, Your Honor. Good morning, Mr. Mahmoud.
Morning.
Are you the same Joey Mahmoud who caused to be filed in this case Mahmoud reply testimony and exhibits?
Yes, I am.
And am I correct that you are adopting in part the testimony and exhibits pre-filed or caused to be pre-filed by Mr. Hoyer?
Yes.
And do you have, it's my understanding that you have corrections or at least updates to some of that testimony this morning. Is that correct?
Yes.
If we can turn to Hoyer Direct, page 2, lines 7 through 13. Do you have a correction or update to that testimony?
What page?
Hoyer Direct, page 2, lines 7 through 13.
Yes. Line 7, the route crosses 1,294 tracts instead of 1,295. and we are roughly at 75.2% closed on tracts as opposed to 63% closed.
And in
I'm,
Mr.
I'm sorry, could you repeat that? I just missed it.
Sure.
Sure. Line 7, page 2 of 8, it says the route cross is 1295. The actual number is 1294. And then on line number 9, it says 63%, and it's 75.2% as of yesterday.
And if we turn to Hoyer reply testimony, page 2, lines 5 through 10, do you have an update on the status of the rail crossings?
Yes, to date, we have 13 rail crossings. We have closed 11 of the 13. 2 are outstanding. We're in final negotiations on those.
And if we turn to your reply testimony, Mahmoud reply at page 7, line 1.
Line 1, where it says Sunoco blends more than 42 million gallons, it actually is 54.2 million gallons of ethanol into gasoline per month.
And then finally, Mr. Hoyer had an exhibit, RLH2, regarding the status of the DOT permits. And am I correct that you have now caused to be filed an exhibit JM3 that updates the status of the Iowa DOT permits?
That is correct. We have secured approval of all the DOT crossings and the permits. We've been indicated that the crossing agreements will be signed and approved upon the issuance of the IUB certificate.
And do you have any other corrections or updates to your pre-filed testimony this morning?
No, I do not.
Your Honor, with the understanding that the Hoyer and Mahmoud testimony and exhibits have been admitted, we tender the witness for cross.
Mr. Dublinsky, on page 2 of Ricky Hoyer's changes, can you again restate for us what those changes were?
My understanding is that at line 1, the route crosses 1,294 tracts, and I guess I would ask Mr. Mahmoud for clarification. Is that 1294 or 1274?
I was under the impression it was 1,294. I hope that's not a trick question.
And then the more important part, regardless of the number of tracts, at line 9, the percentage is 75.2 as of yesterday.
75.2. And I think it's 1274. I think I got that. Just my 9 and 7 reversed.
Thank you. Mr. Taylor.
Thank you. Mr. Mahmoud, let's start with page 7 of your reply testimony. And starting at line 23, you say there are also parental guarantees from the parent companies that pledge assets to cover the needs of Dakota Access.
Where are you reading, Mr. Taylor?
Page 7, starting with line 23, and
Okay.
then it goes over to page 8.
Okay.
Okay. Which parent companies are making these guarantees? Let's start with that.
Energy Transfer Partners, as well as Sunoco Logistics and Phillips 66.
Okay. And describe for us what these guarantees actually say and how enforceable they are.
Okay. The guarantees are the parent companies of Dakota Access essentially backstopping the project or the asset from a viability standpoint in the event of an emergency.
Your Honor, sorry to interrupt the witness. I just want to be careful because the guarantees have been filed confidentially, and the board had agreed to the confidentiality of that. So we need to be careful getting into the content of the guarantees in open session.
So I fully anticipate that we will have to go into closed session at some point in time. What I want to make sure, Mr. Dubinsky, is that you're aware that that means that we will go through this once in open, once in closed, and you're prepared for that, correct?
Yes, Your Honor. If that's
Okay.
what we need to do to keep the confidential material confidential, that's
All right, so what that means to all the parties is this. If you have something that gets objected to that's a confidential, you need to make a mark, and then when we go into closed session, we'll take that back up. What I want to avoid is going into closed session for information that should be public, the questions that should be public. So please, I'm going to rely on you to make those decisions. We'll gauge it based on the number of objections. If you think you're going into that area, please let us know ahead of time. You then can confer with Mr. Dubinsky and we can keep moving forward.
Okay.
Are there any objections to that process?
No.
Mr. Paul? Okay. Mr. Taylor, you may continue.
Thank you. But I guess my follow-up question, and Mr. Blinsky can object if I'm going too far here, but how would those guarantees be enforced by a landowner or someone who is damaged by an action of Dakota Access?
You know, and I think I can answer this with concluding my first answer. So the way that the guarantees work is in the event of a situation or an emergency, that as the event or situation is being experienced, the operating company, which is DAPL, has the obligation to, or has the ability to call upon its parents in the event of an emergency. And under that event of the emergency, under our agreement with the LLC, it has some provisions in there that require the parents to step in to fund whatever costs are for the reclamation of whatever that emergency is. So there's not really a mechanism for a landowner to call upon the LLC, to call upon the parent guarantee. It's a matter of the business documents that govern how the LLC works that dictate how that process is going to work in the event of a situation. So there's no action that needs to be taken by a landowner. It's the action of the emergency itself that necessitates the reaction by the partners.
But wouldn't a landowner have to make some claim or some assertion in order to get compensation?
Well, I think we're mixing two things here. The first thing is there's an event, okay?
Sure.
So once the event triggers, that's when the parental guarantee or the action of Dakota Access would come into play. The second step that I think you're alluding to is an actual step that's taken either legally or by the landowner in some mechanism to make a claim to the company. They're mutually exclusive. The parent guarantee triggers upon the incident, not upon a claim by a landowner. Okay?
But no, there's no mechanism that I can see here that would force the parent companies to exercise that guarantee unless there's some sort of claim that's been made.
No, that's not correct. That's not correct. The way that it works, again, it's not the claim by a landowner that triggers the parent guarantee. It's the event itself. So
But
the event itself triggers the parental guarantees backstopping.
I think we're seeing the same thing only in different ways. But a guarantee is basically like an insurance policy, isn't it?
Well, the parent guarantee, I wouldn't call it an insurance policy. I would call it a form of financial backstopping from the parent companies to Dakota Access.
But there's nothing to backstop unless there's a claim that's been made.
No, that's not true. So just because there's an event doesn't mean there's going to be a claim. Now, the likelihood is there, but that's not the trigger. The trigger's the event. I think that's the difference that I'm trying to distinguish between where you're at and what I'm trying to say. Is the event, not the claim. The claim's the result of the event.
But the event by itself doesn't create a financial obligation to Dakota Access or the parent companies unless there's some damage, correct?
Well, no, the event does absolutely necessitate the claim, and from the event causes the parents to take action.
Okay. And if there's an event that causes damage, Dakota Access and the parent companies that guarantee Dakota Access are not going to pay anything unless a claim is made. Correct?
I don't know that I would say it exactly that way. If there was an event, let's just say there was a spill, what would happen in that case is we would respond, and the majority of, and I don't know what the trigger would be, and it's kind of a hypothetical, but the parent guarantee does not necessarily come into play right off the bat anyway. It would have to be an event that would trigger such a reaction that it would necessitate the parent guarantee coming into play. There's other steps that would happen before then. And so what would happen in that event is that the event would occur, whatever that event is. I'm not going to try to guess what the event is. Then Dakota Access would respond, however that response happened, be it a shut down the pipe, we did a cleanup, a reclamation, whatever it would be. And then from there, Dakota Access would work with the landowner, the affected parties, to either compensate them for damages or whatever the impact would be. And only then, if Dakota Access did not cover or take care of or process or whatever the word is, the actual claim or damage to the landowner, that's when the claim would occur. So you're jumping from incident to claim, where you're not taking into account the 30 or 40 steps that happened in between, way before the event or the parent guarantee would ever even come into play.
Okay. I think you just answered my question, and maybe you didn't know it. The point is that the guarantee doesn't come into play until a claim is made.
No, that's not what I said.
On the top of page 8 of your reply testimony, you talk about a sophisticated multi-layered insurance policy. Can you describe those policies for me? What does multi-layered mean?
So you're reading, moreover, Dakota Access will carry sophisticated multi-layered insurance policies as you would expect. That's the line?
Yes.
Okay. So we have, as Dakota Access itself, we have an insurance policy that's a damage policy in the event of an event that's valued at, I don't know, roughly $25 million. That would come into play first. And then in the event that the claim or damage would exceed that, that's when there may be additional policies that would come to bear or some other type of financial backstopping of the claim or coverage of that damage.
And if it's like most insurance policies, it has certain coverage provisions, certain exclusions. Is that right?
In some form.
What does it actually cover? Those well, let me back up just a minute, and maybe you answered this and I missed it, but is there more than one policy? What does the multi-layered mean? That's what I'm trying to figure out.
So the Dakota Access itself has its own insurance policy for third-party
It's
damages.
self-insured?
No, it's a policy that we will actually purchase. And so that's the first layer of insurance that we carry as a company. And then on top of that, then we get into our parents or other affiliates' insurance policies that are multi-layered, multifaceted policies for multiple different causes and events and coverages. So it's very sophisticated. As you would probably imagine, a multi-billion-dollar company has the right insurance in place as being a good operator and protecting itself. So an insurance policy is just like car insurance. You know, you pick what you want. If you want 25, 50, 25 as coverage, that's what you pick. Then you bear the risk from there. Anything, a claim that would be above that. This is a very similar situation here. We buy an insurance policy that we feel is appropriate.
Who's we?
Well, Dakota Access. We buy an insurance policy that we feel is appropriate for this actual company and for the claims that could be, that we could experience. And then on top of that, we have other insurance policies via our parents or affiliates that would cover for larger damages.
Are there any exclusions from coverage in those policies?
Yeah, I couldn't tell you every exclusion. From a third-party claim, a damage claim, there are no exclusions for the individual landowner or person that's impacted. It's covered.
And by third-party claim, you mean?
A landowner.
Would these insurance policies cover the operator of the pipeline, which I understand is a different company than Dakota Access, correct?
The operator, and I know you know the answer to that, it is a different company. It's been set up to operate the pipeline. And it would, in fact, it wouldn't cover Echo Dapple's operating company. It would cover damage that would result to personal property. So there's other insurance policies that could come into play for the operating company should that be necessary.
Have these insurance policies been provided to the board?
No, I don't believe so. We provided a summary at some point. We provided, well, just a generic summary of the insurance policies that we were looking at. I can't remember if it was to the board or to OCA.
Is that something you'd be willing to provide to the board?
Well, if we haven't already, we would probably provide the summary that we've already provided.
To clarify, Your Honor, we have provided to, I believe, and I lose track of which party was asking, I believe Northwest Iowa landowners and the OCA, a summary description of what Mr. Mahmoud has just testified to, the $25 million standalone policy for Dakota Access, and then a package of financial resources beyond that at the parent level. I do not believe, because that was in private party discovery, that the board would have seen that or has asked for it.
And nor would the other parties, right?
Under the wording of the protective order, it allowed the parties to share amongst themselves, but in theory, no. I mean, all we provided it to was the parties that asked.
Right.
Mr. Long?
The only thing we received regarding insurance was included in OCA Hearing Exhibit 2, the confidential version.
In that case, the board does have that summary as well. And was that Mr. Long, was that served on the?
Yes, I believe we've fulfilled our obligations to serve it on the parties.
Ms. Chair,
Yes, Mr. Murray.
with respect to the disclosure to NILA on the insurance information, I see that information was also included in OCA hearing exhibit number 2, which was disclosed to all parties.
That is what I mentioned, Your Honor.
But I don't think those are the policies themselves. It was just kind of a summary, wasn't it?
That's correct. And that is all that we have provided to anybody is the summary that Mr. Mahmoud just described. And the parties and the board do have that summary.
Mr. Taylor, I'm going to take that under advisement. I think I'm clear on what we do have and what we don't have, and if there's any additional, I will bring that back up once we've had a chance to talk about what we thought we had. I don't think we realized we had what Mr. Murray had been provided with
Thank
through the OCA exhibit. You may continue.
Thank you. And I'm assuming that those insurance policies would be like other insurance policies that the insurance company will try to find some way not to pay?
Well,
That's not a fair question.
it's not, is it? That's not very fair at all. So I think you know my answer to that.
But my point is, these are insurance companies. It's not self-insurance by the company, correct?
Well, I mean, here, I have State Farm insurance. I've had an accident. I've never had a problem with my insurance paying. So I don't know what insurance you carry, but that's not been my experience.
You go in some detail in your reply testimony about the oil spill pollution trust fund, or pardon me, oil spill liability trust fund. Is that correct?
Yes, sir.
My understanding is that that fund, first of all, only applies to discharges into navigable waters or adjoining shorelines, correct?
No, that's not correct.
Isn't that what Section 2702A of Title 33 of the U.S. Code says?
I don't have Title 33 in front of me, but I've certainly read all of that, and it does not say that at all.
And in order for a landowner or some third party who was damaged by a spill from your pipeline would have to make a claim first to Dakota Access, and if that isn't successful, then to the fund, correct?
That could be one mechanism, yes, sir.
What's another mechanism?
Wow. They could go to court, district court, and make a claim if they wanted to seek recovery in that mechanism.
Okay. But it would take some effort by a landowner or injured party to collect from this fund, correct?
From the fund itself, yes. So the way that the fund is set up, the fund's not there to backstop Dakota Access's responsibility from a spill right off the bat. We, as the operator, have a responsibility to respond, to pay for, and to remediate whatever that spill is. It's only in the event that we, as the responsible party, would not fulfill those obligations, would the fund step into place and then would provide a mechanism for third parties to make claims or to remediate that claim or the spill.
But for the fund itself, a landowner or a third party would have to make a claim and go through all that process and maybe even go to court, correct?
Well, I don't know what your reference point is. You know, if there was a spill, as I mentioned earlier, you know, making a claim against the fund is towards the end and would be a kind of a status of last resort. There'd be a lot of communication up front if we were to have a spill. Our operations group would work with that landowner first and foremost to isolate, correct, and control, and then remediate. And then only in the event that we couldn't solve or resolve any type of claim, or whatever that remediation or mitigation would be, would there be some form of claim to that fund along the way.
But any payment absent some effort by the landowner or the third party who is injured would depend on the good faith of Dakota Access, correct?
I don't know about good faith or just being responsible.
And it's my understanding also that the oil spill liability trust fund law provides defenses to a company like Dakota Access to avoid responsibility, correct?
No, I don't think we're reading the same oil fund liability trust that I've read. That's not what it says at all.
But there are defenses if the potentially responsible party alleges that it wasn't their fault or somebody else did it or
Well, so let's talk about what those are. An act of God, an act of war, or gross negligence or willful misconduct of a third party. So that's a pretty high standard in itself, by the way, and it's only up to $350 million, and then the fund would come into play. And then anything above $1 billion, then the responsible party again would be liable for. So I think you're misinterpreting or reading what the code actually says, and I would encourage you to reread it.
but if Dakota Access claims that it wasn't your fault or that somebody else caused the incident or there's an intervening cause of some sort, that would be a defense to your liability under the fund, would it not?
I mean, we're getting into some pretty technical areas of liability under a court. And I'll tell you, in my interpretation, not being a lawyer, is that no, that would not. Again, a gross negligence or willful misconduct standard is a pretty high bar to reach. So I don't believe that at all.
You provided to us Exhibit JH1, which is the facility response plan. Is that correct?
Yes, sir.
Can we bring that up, please?
And again, I would just caution that the chair has ruled that the FRP is confidential, and so it can't be brought up in open session.
Okay, I'm sorry, I didn't realize it was confidential. So, I'll save that for the closed session. Now, it's my understanding that Dakota Access would be a common carrier and that you are transporting oil for a customer who we've been calling the shipper. Is that correct?
Yes.
And that the shipper is sending the oil to a refinery or another hub somewhere, correct?
That's their option.
And you would have the customers in Iowa, correct?
No, I don't. I wouldn't say that at all.
Your customer is the shipper, correct?
My customer is the shipper.
And the shippers are not in Iowa, correct?
The shippers, their product gets back to Iowa.
Well, but your direct customer is the shipper.
My customer is the shipper.
Okay.
The customer of the refined product that's made certainly comes back to Iowa.
Okay. But you don't provide any services directly to Iowans or to anybody in Iowa.
Well, I mean, I think we do via our connection to the hubs that then transport that crude oil to the various refiners across the U.S. And those products then come back to Iowa in the form of refined products. I think my testimony speaks pretty clearly to that fact that Iowa simply can't exist without petroleum products that are refined in the other parts of the U.S. and are brought back here until Iowa simply puts in its own refinery to make its own refined products. That's the circumstance Iowans are in, as they're importing their refined fuels and lubricants for consumption in this state. So this pipeline, sure, it may not have a delivery in Iowa because there's no place to deliver it, but it certainly delivers to other refineries in the U.S., which bring those products back to the state of Iowa for consumption.
But there are no direct customers of Dakota Access in Iowa, correct?
I bought fuel last week when I was here. I'm a direct customer of the product that's being produced, that's being refined from the crude oil. So I don't agree with your argument.
But you're not delivering the product to anybody in Iowa directly, correct? You're delivering it to a hub in Illinois and then perhaps down to a refinery in
I
the Gulf
think
of Mexico.
we've made that very clear. We're transporting the crude oil from the Bakken to Illinois, who then gets redistributed to those refineries, and those products then are refined and brought back to Iowa. I haven't minced words on that particular scenario.
Would you recall testifying in the hearing before the South Dakota Public Utility Commission, I think back in September?
I was there, yes, sir.
Okay. And you testified?
Yes, sir, I did.
And do you recall saying that there was no guarantee from shippers that the product that was being transported in the pipeline would return to South Dakota?
Sure. I mean, I can't guarantee that.
Okay. And the same would be true for Iowa.
Well, I was a little bit more unique because the oil that's being transported goes to some of the refineries in Pad 2 and then then from Pad 2 are redistributed back to Iowa. South Dakota was a little bit more unique in that regard, is that there wasn't that direct connectivity from the products. Iowa's a little different, but.
I'm not sure why Iowa's different. I missed that.
Well, Iowa has direct connectivity to some of the refineries in Pad 2.
And South Dakota doesn't?
Not via a pipeline.
But still, there's no guarantee from the shippers that the product will return to Iowa. It could go anywhere.
There's no guarantee. But I think it's, and that also is in my testimony somewhere, it stands to reason that if the Bakken is producing somewhere around 1 million barrels a day, the Bakken proper that we're transporting of, and that's roughly 10% of the production in the U.S. 10% of that production gets refined. There's a pretty high likelihood that refined product is making its way back into Iowa. So I think it's, in my opinion, it's it's a naive thought to think that Iowa is on an island, that it's not being serviced by these refineries that are being supported by crude oil coming from the Bakken. I don't think I think that's a mischaracterization of what's really happening in the world.
Well, South Dakota's not an island either, is it?
No, and I think South Dakota is probably getting refined products. I just think it's an easier connection to Iowa because of a few pipelines than it is to South Dakota.
But Dakota Access would have no duty to provide any kind of service to Iowans, correct?
No, no, we don't have any duty.
And the Dakota Access Pipeline, beyond applying for a permit from the IUB, would have no, would not be under the jurisdiction of the IUB, correct? It would be under the jurisdiction of FERC?
I didn't follow your question, I'm sorry.
Okay. If the pipeline is put into operation, it would not be under the jurisdiction of the IUB, correct?
No, that's incorrect.
Now, one of the arguments that Dakota Access has made in arguing that your service is necessary is that it would reduce the number of oil trains. Is that correct?
Yes.
In fact, it wouldn't reduce the number of oil trains, would it?
You know, that's a pretty complicated question. We've had some experts testify to that. Would there be a reduction of oil trains? I can't tell you. You know, I think the premise is there be a shift of commodities being transported by rail. You know, the simple fact is when we go into operations, 470,000 barrels are going to be shipped via a pipeline that otherwise would have been shipped probably by rail or truck or maybe even another pipeline going somewhere else. But 470,000 barrels, that's a pretty big chunk of the Bakken. That's 40% of the Bakken coming from the Bakken proper. And I'm not talking about all the Bakken because that's about 1.3 million barrels. I'm talking about North Dakota Bakken, where it's about 1 million barrels a day. 40% of that, a little bit over, gets transported by this pipeline. So again, I'm just applying a little bit of reason here that there's going to be a reduction initially in the rail utilization for crude, but probably an uptick in rail utilization for commodity crops or other modes of transport or other commodities being transported by rail. So I think the engines are running. I think the type of cars being towed by those engines are going to shift. But I think it probably stabilizes again because what happens is when the pipeline comes on and the producers have the ability to actually extract the crude oil from the ground that's either in shut-in production and mostly shut-in production, that will quickly equalize again and we'll have an increase in production initially and then it will level out. So what does that mean as far as rail transportation? I don't know, but I don't think it's fair to say that there's going to be a huge reduction. I think there's going to be an impact. I just don't know what the impact is.
Well, do you recall testifying again in the South Dakota hearing?
I do.
And you recall being asked, I think, by Commissioner Hanson of the Public Utility Commission there about this issue of reduction in trains. And do you recall saying that, if anything, the rail will remain constant and instead of crude carrying cars, there'll be grain carrying cars?
I think that's what I just said here.
Yeah. And so there would not be necessarily a net reduction in crude carrying trains because of the pipeline project, correct?
Well, as I just mentioned, I don't know what the actual impact is going to be. I think there's going to be an impact, there's no doubt. I just don't know how great of an impact because I think there's some shut-in production out there that as soon as we start moving this crude by pipe, all of a sudden it's going to open up that production, and so it's going to supplement that flow that otherwise wouldn't flow. How many of that is going on train via this pipeline or another pipe? I can't tell you. I mean, that's not up to us. We're a transporter. We're not in the rail business.
Now, this pipeline, if it's built, will start in North Dakota, correct?
Yes.
Okay. And that's fairly close to the Canadian border, correct?
Well, sure. If as a crow flies, sure it is.
Or as oil flows?
Well, I didn't know. Oil's not flowing north over there. It's flowing south.
Well, that's my next question. How easily would it be to connect this pipeline to tar sands pipelines in Canada?
Your guess is as good as mine. Is it possible? Sure. That's not our proposal.
It would be the same kind of pipeline. It would be the same construction operation, right?
Well, if we were to build a pipeline to go north, we would have to get a siting permit from the Public Service Commission in North Dakota and go through that process and go through what's called a presidential permit with the U.S. government and the Canadian government to connect going across the project. It's a different type of crude oil. There's tar sands oil, whatever you want to characterize it as, is different than Bakken light sweet crude. So no, I don't. I think they're mutually exclusive from each other. I don't agree that it's a very easy proposition to make that happen.
Mr. Taylor, can we take a 5-minute break, please? Thank you. prepared. You may proceed.
Thank you. We've heard a lot of testimony throughout this hearing about the eminent domain and the easements that the landowners, some landowners have been signing. It's true, is it not, that if they go through eminent domain, they will get a lump sum, but would not get any what I would call royalty payments in the ensuing years as the pipeline is in operation? Is that correct?
There's no royalty payments for condemnation proceedings and/or voluntary easements.
Okay. So the voluntary easements would be just a one-time payment as well?
Yes, sir.
Okay. So all of the years, however many it is, that Dakota Access would be pumping oil through this pipeline and getting paid for doing so, the landowners would get nothing beyond that original easement payment, correct?
Well, we get that question quite a bit. When we buy land for easements, we actually are paying the fair market value for the property. That means the full value of the property. Whatever that 50 foot is the 100% of that value. And then 50% for the temporary workspace. So half the value for temporary use. But at the end, unless it's a pump station or our launchers and receiver sites, we actually are just getting an easement. So the landowner is getting compensated for that piece of property or the 50-foot easement in its entirety, plus 50% for temporary use, plus damages. So we believe that we're compensating the landowners to the maximum extent that we can, that they get the land, they own the land, we pay for it, they still have the land to use as they would be before, except for a couple minor exceptions. And then they get compensated for the temporary use or temporal use and damages. So we think it's fair.
Are you familiar with how, in Iowa at least, maybe it's in Texas too, since you have a lot of wind down there, that if a landowner who has wind generators placed by Mid-American or whatever company it is on their land, get a royalty payment in future years for allowing those wind generators to be on their land? Are you aware of that?
No, I'm not in the wind business, so I wouldn't know.
Have any landowners requested an easement that has those kinds of royalty payments?
Sure, and that's what I was just saying is we have that. That's a very common question that we get. And that's one reason we pay the full value of the land and half the value for temporary use and 3 years worth of damages to ensure that that landowner is being compensated fairly for their property. And that's common in industry practice across the whole United States. So that's not unique to Iowa or the landowners here in Iowa.
And so basically, if a landowner asks you about an easement agreement with royalty payments, you would just tell them, no, you don't do that, correct?
That's correct. We do not do royalty payments.
Is there any obligation on Dakota Access to complete this pipeline project by the end of 2016?
Is there, I'm sorry, can you say that one more
Is
time?
there any obligation on Dakota Access to complete this pipeline project by the end of 2016?
We have our internal goals and objectives to have the pipeline in service by the end of 2016. We've made commercial commitments to some of our customers to be ready to flow by that time as well. As an obligation as defined by law, we'd have to talk to the lawyers, and Damon, being the commercial counterpart, he could probably define what those terms mean better than I can, but I know we've made those representations to our customers, and I've made those representations to my board that I would have this pipeline in service by then.
And your customers being the shippers, correct?
Yes, sir.
But you made that commitment before you had even made an application to this board for the pipeline project, correct?
That's correct. When you plan a project to this magnitude, and I kind of take it for granted because I do this for a living, this project's been in the works for multiple years. The planning process, where it starts in concept to where it gets put on paper, to the point where the commercial team markets it to the shippers or customers, to the point where the team then moves into what's called an execution phase, where we do surveys and environmental studies, permit applications. All of that takes years to plan. So as a project delivery type of person, that's what I do for my company. I put together a project schedule. And I say, I know I have to do these 3,000 items. And of those 3,000 items, it's going to take me this long to accomplish this goal. And so I put forth a schedule that shows when we're going to do certain things. And in there, one of those would be the IUB. We came up with a schedule that said we need to gather enough information. We need to get to a point where we have enough data to make an application to the IUB that would be meaningful so they could do their job and to evaluate the project. And then we go through that project. So there's a tremendous amount of risk involved with my company that we expend a lot of resources, time and money, and to prepare for a project like this, that at some point you do make that application for final approval to then build and to go into operations.
Is it your position that the board has an obligation to help you meet your construction schedule?
I believe they have an obligation to evaluate and consider all the facts and make an educated decision that's in the best interest of Iowa.
But do you believe they have an obligation to help you meet your construction schedule?
I just said what I believe. They have an obligation to review, evaluate, and then to determine is it in the best interest of the state of Iowa. I don't think they have any other standard beyond that.
In terms of your construction schedule, I think Mr. Fry testified that the construction would begin sometime in the spring. Do you have any more definite time frame than that?
Well, we want to start as soon as we practically can, weather dependent. So if it's a nice, gentle spring, where we don't have spring blizzards that happen in this part of the world, we'll probably start sooner rather than later. If we have a cold spring and a wet spring, then we'll probably start later than we normally would like to.
You probably haven't been in Iowa in the last few years, but we have had a lot of wet, late springs lately. I would argue it's climate change. So is it fair to say that that would delay the start of the construction period?
So delay is a pretty strong word. You know, we have an end date that we would like to achieve. So we want to be commissioning the pipeline, putting hydrocarbons into the pipeline at the end of 2016. So we make all of our plans to hit that target based upon a progression rate in construction to achieve that date. And so at some point, it becomes too late to meet that goal. Now that goal is pretty late into 2016, but certainly if it's a really wet and cold spring, we probably won't start until the latter part of the spring.
Well, now let's say hypothetically, and really it isn't too hypothetical anymore, that we would have heavy rains through the latter part of June. Could you still complete the pipeline by the end of 2016?
I believe we would. And So the rains certainly are an impediment to progress of construction. Probably the more important factor for us to get started is the ground being frozen or not frozen. And I believe Aaron DeJoya, and I don't know if Mr. Blood mentioned the same thing, but when the ground's frozen, we don't want to start because you can't achieve the topsoil segregation to the finiteness that we've made promises to the landowners. So that's our trigger, is when that soil becomes non-frozen, that we can actually segregate the soil to the point that we're protecting the subsoil or the topsoil from the subsoil.
I think we had discussion with Mr. DeJoy about also if the soil is too wet, it can't be worked because of the heavy equipment and the compaction that would result. Is that correct?
That's correct, but there's techniques that you can employ to offset those impacts. So you can use timber mats that displace the weight of the equipment. You can use wide track equipment, meaning wide track dozer, which has, if you've ever seen a dozer work in a field with wide tracks, where you would think a piece of equipment would sink 2 feet, in fact sinks 1/2 of an inch. So it does not compact that soil. So there's techniques that we can employ for wet conditions, but we cannot employ those for frozen conditions.
There's been some talk about a winter construction plan, and I know you don't have one at this point, but theoretically, what would that entail?
That's a good question, and I know my team has been unwilling to commit to that, and it's not because we're afraid to commit to it. But the winter plan simply is to set forth the conditions for which we would execute the remaining portions of construction into the winter and/or winter stabilization or revegetation or temporary stabilization. So for me to guess and for my team to guess, we're going to do X, Y, and Z would simply be a guess. And so what is more prudent for us is to issue that plan once we know we're not going to achieve an in-service date or be complete with construction by the winter. So say by October 1st or 15th, if we know we're not going to be complete, then we would issue a winter construction plan that would set forth the conditions for the remaining portions of the work in very grave detail for what that would be.
Let's turn that the other way, though. Would that winter construction plan allow you to begin the construction earlier than spring?
No, the couple of items that we may start early, so it's a fair question, are horizontal directional drills or preparation of construction laydown yards. Some of those activities may begin prior to the spring because those simply don't have the type of impacts we're talking about for topsoil segregation or detrimental impacts to the agricultural communities. So horizontal directional drill we may start as soon as we can because it's a fixed location. You build it up with wood mats, you set your equipment up, and then you start your drill. That may occur, but as far as starting the majority of the rest of the construction, we're not going to start until we believe the conditions are good to facilitate continuous construction to finish the job. So a construction spread, just to give you a frame of reference, it may cost, upwards of $1.2 million a day per spread, just for people and equipment. And so that's a pretty big price tag per day to have sitting around idle when you can't work. So we set our construction schedule so those people can work starting day one and progress through the end of construction as unencumbered as possible.
Let me ask you this. It's my understanding, and correct me if I'm wrong, that the pipeline through the 4 states will be constructed in segments, each segment being constructed at the same time?
Yes, sir.
Is that correct?
Yes, sir.
Would you explain how that's done?
We'll have multiple spreads. So we'll have, 3 to 5 contractors. Each of those contractors will have 1 to 3 different construction spreads. So a construction spread includes all equipment, manpower, tools, materials for a particular spread. And that spread can be anywhere from 50 to, say, 150 miles, maybe more, maybe less. So those folks that are building that pipe, they're moving in a sequential manner as they're progressing construction. So in the state of Iowa, we're going to have 3 spreads running concurrently.
Now, where are those spreads going to be? Could you?
I could probably look at a map and get close, but they're going to start at one spot and they're going to go, a couple hundred miles, 150 miles, and then the next spread's going to start, so forth and so on.
Okay. So each spread is about 150 to 200 miles?
It's roughly that.
Okay. And as the trench is dug and the pipe is laid, is that done in sections, or how is that done?
It is. It's if you've ever seen an assembly line working, it's very similar, except for in this case, the assembly line is not fixed in a typical factory assembly line situation. The assembly line is actually moving, so the pipe is fixed. So they'll string the pipe along the ditch, and then as that pipe is laid out, then the different stages of equipment or construction will occur. So first, you go through and you clear and grade. So that's before the pipe shows up, by the way. You clear, grade, you put in your erosion sedimentation control devices. So that's the first, that's the very beginning of the assembly process. So they move through, and then immediately behind them, and it depends on the contractor, you may have your stringing crew, which is who brings the pipe to the right-of-way. And then from there, you may have your ditching crew, who then digs the ditch. And then you have your welding crew. And then you have your coating crew. And then you have your lowering in crew. And after that, you have your backfilling crew, and then your restoration crew. And so that's all happening in sequence as you're moving down the pipeline.
And how long are these sequential sections that are being constructed?
It varies. It varies upon topography. It varies upon dirt. If there's a lot of topsoil, it could be, that length, it could be 1,000 feet long, could be 2,000 feet, could be a mile. I don't know. It's very site specific upon which the progression proceeds.
But how many miles a day do you think will be constructed?
Well, I hope somewhere around 1.5 miles per spread per day. So 5 miles, somewhere around there, 4.5.
We heard some testimony earlier about crossing rivers and streams, and that some of them would be trenched rather than horizontally drilled underneath. From your perspective, what efforts are made to make sure that, for example, canoers and kayakers would be able to use the stream while it's being trenched?
Your Honor, I'm going to object on scope. I understand that a lot of things were passed to Mr. Mahmoud, but I don't think that everything was. And there was an extensive discussion with Ms. Howard, who had actually testified about how we would treat rivers and streams. And I have some concern that we're simply repeating the entire, range of what all the witnesses were asked with Mr. Mahmoud. And I don't think that that's appropriate nor a good use of the board's time.
Mr. Taylor?
Well, I think I've actually lost track, but it seems like so many witnesses referred things to Mr. Mahmoud that I think that in terms of the construction, I think that he certainly is overseeing all of that. And from the testimony of the other witnesses, he's the person to answer a lot of these questions.
Just a moment. Mr. Dubinsky, you're overruled. I appreciate your concern. We are going to allow flexibility for this witness. I agree. I can't remember everything that was asked. I do not recollect any canoes being brought up before in our testimony, and I believe Mr. Taylor should continue, and the witness shall answer the question.
Okay. Without knowing what stream you're talking about, and if it truly is a stream that's utilized for public recreation, such as canoeing or kayaking or boating, in the event that it was an open cut stream and it was in fact utilized for those activities, then we would probably have a partial closure of that stream during the construction activities, which would last 24 to 48 hours. When we do a stream crossing, we try to always do it, well, we always do it in less than 72. We hold our contractors mostly to 24 to 48 hours. And if it's a small stream, less than 10 feet, it's done in 24 hours. So the wider the stream, we give them a little bit more time, but we hold them to those very restricted time windows. So in the event we did have to, in fact, obstruct a stream that's being utilized recreationally, then we would have somebody there, a spotter essentially, that would help those individuals to traverse the construction work area and to move their boating equipment across that right-of-way to get downstream and continue on with the recreational activity.
How was it determined which rivers and streams would be trenched and which ones would be drilled underneath?
Actually, that's a very good question, and there's a lot of thought and effort that goes into that. Anything over 100 feet wide is pretty much assumed will be drilled. Anything from 10 feet wide to 100 feet is individually evaluated by environmental folks like Monica. It's evaluated by construction specialists or by the contractors that we may utilize to actually construct that pipeline. And then on that basis, each of those streams are individually determined. Can we safely cross that stream to protect the environment, to protect people, either the neighbors or the landowners or the joiners, whomever, and to protect the construction workforce? Once that determination is made, if we can cross it safely and meet those three criteria, then we will typically open cut. If we can't meet that criteria, for whatever reason, if the bank height is too steep or too tall, then we may elect to bore or drill that stream because we may simply not be able to put the stream bank back to a manner that is stable to protect the environment in that case. Or it may be too steep that the construction worker can't safely work in those conditions. And then the same, it really is true for 10 feet or less, but in most cases, 10 foot or less are such size that you can cut or cross those with an open cut.
Give me an idea of how much more work and how much more expense it is if it is, to horizontally directional drill underneath than to trench?
You know, it's a hard one to answer. There's definitely a cost by horizontal directionally drilling. Cost is certainly not the singular focus on when you're making that determination to drill or not drill. Typically, it boils down to, can you accurately and safely execute that drill without causing secondary impacts? A lot of people have the impression, oh yeah, I can just drill and it will reduce or eliminate those impacts, where in fact, on a short drill or a shallow drill, you may expose that environment to a frack out or some other type of environmental contamination issue from a frack out primarily that you would otherwise be able to avoid. And if you can control that crossing with an open cut, sometimes and often it's more advantageous to the environment to go ahead and open cut, because you can execute that open cut in a very short period of time.
My understanding is that an open cut or a trench, whatever you want to call it, over the years, the water in the stream or the river will erode away and expose the top of the pipe. Is that correct or not?
Well, I mean, certainly it's possible, and it certainly has happened. You know, when you have scour on a stream that's been excavated, certainly you can have erosion or sedimentation or erosional loss. Sedimentation would actually be the filling of, so that would be a benefit, right? But the erosional potential or scouring could result in that. That happens. One reason we go 5 foot or greater in depth below a stream bank is to ensure or reduce that potential for that pipe to be exposed over time. And that's, I don't want to say it's something new in the past couple years. It's something new probably from the 70s, where instead of doing pipe crossings of rivers in a shallow cover, meaning 3 foot or less, and sometimes less is what they used to be, is now it's always a minimum of 5 foot or greater.
Do you recall in the South Dakota case that we were discussing that you filed rebuttal, pre-filed written testimony?
I believe I did.
And do you recall that in that testimony, you said Dakota Access has proposed an indemnity bond totaling $15 million?
For roads, I believe is what you're referring to.
I'm sorry?
For road crossings? That's what that references to.
So that was just for the road crossings?
Right. In the state of South Dakota, the road crossings are handled at the Public Utility Commission level by statute. So in that case, they actually set the bond amount that's to be set aside for crossing of public roadways. And we entered into an agreement with the state of South Dakota to actually post a bond for $24 million as opposed to the $15 million that you're referencing in my rebuttal testimony.
And so what, in terms of the roads, highways, and bridges, would that $15 million bond cover?
Well, it would cover the backstopping of the reclamation of those roads in the event that our contractors or Dakota Access, I should say, did not fix those roads back to the standards which we agreed to fix those.
Would those issues also be present with the roads, highways, and bridges here in Iowa as a result of your pipeline?
Sure, and we have worked with the various authorities to come up with various bond levels at this point. I can't remember what they all are, but Iowa's done a little bit differently, where that's done at a different level outside of the IUB. But we certainly have been working with those Department of Transportation agencies to work that out.
But you've not proposed a $15 million bond here in Iowa for the roads, highways, and bridges, correct?
Well, it's different statutory requirements. Like I said, in South Dakota, it's by statute, by law. Under the PUC, they have the authority to require a bond. In Iowa, it's not under the IUB. It's underneath the Department of Transportation.
Is there any reason that the Dakota Access could not run this pipeline along highway rights-of-way, section lines, fence lines, in order to avoid impact to landowners and tiling systems?
Yeah, we get that question quite a bit also. And you know, it really, it sounds good, right? Makes a lot of sense. Why wouldn't
Sounds
you?
very good.
Sure. I mean, it does when you look at it at face value. But the fact is, when you route a pipeline, one of the considerations that we go through is to minimize the impact to the human environment, to people, to roads, highways, to uses of public resources. That's the human environment. And so when you put a pipeline next to a road or in a road right-of-way, statistically, you have exponentially increased your interaction between people and that pipeline. And so now what you've done is you've actually created an unsafe condition where people now are exposed greater to that pipeline than they ever would be if it was on private land in the middle of a farm. So you have a farmer or his family, and I'm not belittling any of this, but you have the interaction of one or a few on a very rare occasion versus hundreds of thousands on a daily occasion for an interstate, having the potential for interaction between the pipeline and that person. So statistically, it's a horrible idea to put a pipeline in a road right-of-way as opposed to putting it in an isolated situation in Iowa in the middle of an ag field. That's why we don't do that.
What about section lines and fence lines?
Well, where we can, we certainly would prefer to follow people's property lines, but practically that doesn't work because there's too many bends in the pipe. And so we have to make the pipeline piggable. And so when you put a bunch of 45s or 90s and you add points of inflection in the pipeline, it causes additional operational considerations that may not necessarily be the most advantageous thing to do to protect that pipeline for long term.
Well, in terms of bending in the pipeline, it looked to me like on Exhibit B that's accompanying the application, which is the maps, that there are many places where you're crossing state and federal highways where you have bent the pipe quite dramatically in order to obtain an approximate right angle across the highway, correct?
That's correct.
Okay. So you're bending the pipe there, correct?
Well, I think you're misinterpreting what's happening there. So we're adjusting the approaches to those right angle crossings such that you don't have a hard 90 in the middle of your pipeline approaching that road. So that's not what you want to do. So when we approach a road, I think if you look at the map, you'll observe that as that approach comes, if here's the interstate, you're not going like this and then crossing, you're actually approaching it at a much gentler angle to hit that crossing as close to perpendicular as possible. Again, reducing the number of hard degree bends to allow for efficient pigging and monitoring of the pipe.
So you're saying that maybe a 50 or 60 degree bend like that is okay, but a 90 degree bend is not?
Well, I'm saying they're both okay in their respective positions, and as long as you plan for it properly. But to have an entire pipeline that's 1,168 miles made up of 90-degree bends is not very practical, nor would it be very smart from an engineering perspective.
Is it just more expensive? Is that it?
No, that's not what I said. And we could ask Chuck the engineering stress calculations behind that if we wanted to. But no, it's not about money. It's about operating safely and efficiently to have a pipeline that meets the public safety standards. That's what it's about.
Well, why is a pipeline with bends in it less safe than a straight pipeline?
Objection, Your Honor, asked and answered.
Sustained, Mr. Taylor. I believe he has answered that question.
Do you recall in your South Dakota hearing testimony, your live testimony, you were asked about pipelines being too close to electric transmission lines,
No, I do not.
and you termed it AC mitigation?
Well, we have AC
Does that ring a bell?
mitigation. Well, you're
Your
filling
Honor.
in things that I already said I don't recall. I know what AC mitigation is.
Okay, so let's talk about that a minute. What is AC mitigation?
AC mitigation is the mitigation that you put in place to mitigate stray current from originating from overhead utility lines.
And that AC mitigation or being too close to electric transmission lines can cause corrosion, is that correct?
If not properly mitigated.
And how do you mitigate it?
You put in various techniques for AC mitigation. I'd probably have to get Chuck up here to answer the specifics on that, but essentially you put in, and most often, what's called zinc ribbon, which is a sacrificial, the current will go to the zinc ribbon before it will go to the pipeline. So that's where if there's a stray current at shorts, it would actually go to the ribbon as opposed to hitting the pipeline. So you put that parallel to the pipe.
And has Dakota Access submitted any kind of plan to undertake that AC mitigation?
No, that's typically not a plan that's submitted to anyone. When we say we're going to employ AC mitigation based upon the code, that we have an obligation under PHMSA to properly mitigate the pipeline in accordance with the rules. So we hire various companies that are professional engineers that's what they do for a living, to develop and execute an AC mitigation plan that's in accordance with the federal laws.
We've talked in the past about county inspectors under the Iowa Code. Are you familiar with that?
I am.
And is it true that there is an engineering firm called I&S that is soliciting the counties to be the county inspector for all the counties along the route?
I believe that's correct.
Okay. And is the I&S firm a firm that did work for Dakota Access on this project?
They have done certain work for us on drainage crossings, I believe. They've done some engineering work for us.
And it's correct, is it not, that under the code, if I&S becomes the county inspector for all the counties along the route, that they would ultimately be paid by Dakota Access?
That's correct.
Do you know why I&S is soliciting to be the county inspector for all the counties?
Objection, Your Honor. A, the witness doesn't represent INS and can't speak for INS. And the fact that they're soliciting business for what they do among the counties strikes me as irrelevant to this proceeding.
I just asked if he knew.
Your Honor, it's Mr. Taylor, let's be clear, is making an improper implication that somehow INS, who isn't here to defend themselves, doesn't have the integrity to be out promoting themselves for business to the counties. That's not an appropriate line of questioning.
You're overruled. The witness will answer.
Can you repeat the question?
Sure. I think I can. Do you know why I&S undertook to solicit from all of the counties along the route to be the county inspectors?
I have no idea, but I will kind of, I guess maybe insinuate here that, Dakota Access as a company, as part of this process, is required to pay for a lot of things, including this room and the equipment that we're utilizing today. So does that make it any more prejudicial for this hearing? That's just my opinion. I don't think INS, whoever they are, and I have no affiliation with them, are doing anything other than what a prudent business would do.
I believe you filed an exhibit indicating that Dakota Access has approval from all of the counties along the route to cross the county roads at other than a right angle?
From the Department of Transportation.
Okay. The counties have not agreed to that yet?
I'd have to look at each one. We have negotiated with each of the counties the crossing agreements, and they have given us indication back that as soon as we have our permit from the IUB, they will in fact issue those permits. So the negotiation with them as far as the crossing angles, depth, techniques, conditions have been negotiated. And now we're just in this process, and they're going to wait to issue their agreements until after the IUB makes this decision. That's what we understand.
Have those agreements with the counties been reduced to writing?
They are reduced to writing.
Okay. I think all I've seen is just your summary statement that you have these agreements with the counties, but have you filed with the board or submitted to the board the actual written agreements with the counties?
Well, once they're signed and they're in effect, I believe there'll be a public document, and you're more than welcome to get those from each of the counties.
Would you put Sierra Club Exhibit 1 up on the screen, please?
Brett.
Have you seen this before?
I think I got a glimpse of some of this, yes.
Okay. Basically, the Iowa Rural Water Association is expressing their interest in Dakota Access not impacting the rural water systems. What is your understanding, if anything, that Dakota Access has done to address the concerns of the rural water systems.
But can you scroll back up? I can't remember what the date was on this letter. So November 6th, obviously we got this not too long ago.
Mhm.
And, they voiced their concerns and are willing to and will initiate conversations with them to mitigate any of their concerns.
Um, But at this point, nothing definite has been agreed with the rural water.
No, I mean, they just notified us that they want to we've actually talked to them in the past. So, they sent in this letter and requested that we get into a little bit more detail, which we will obviously do.
There's been some discussion earlier also in this hearing about the drainage districts. Have you dealt with the drainage districts to satisfy any concerns they might have?
We have. We've actually met with all the various drainage districts. We have reached agreement with 3 so far.
Okay.
And those are ongoing.
How many districts are there, do you know, that would be impacted?
Now, is it 18, 13? I can't remember. I mean, it's whatever it is, it may be 13 that we'll deal with them, and we've been in contact with them and are working through those issues.
That's all the questions I have, subject to the confidential matters that we're reserving.
Mr. Murray?
It's
Did I skip-
10:15, and you want
Do
me
you
to
want
just,
a break?
it might be a good time.
Okay, we'll take a 10-minute break.
Thank you. I didn't know I was in charge of the breaks, but I'll take that over if you'd like.
Apparently, I just keep going and forget about that. Are you
You're-
ready?
You're a pretty hard charger. I am ready. Mr. Mahmoud, the pronunciation is Mahmoud, isn't it?
Mahmoud, yes, sir.
Mahmoud.
Yeah.
Okay. I'm going to start with an icebreaker, if you don't mind. Sure. I was speaking with the building attendant earlier today, and her name was Penny. And she said that this building's been here as long as she can remember. And I think you said that your company's paying for the rent on this building. Is that right?
I believe that's right.
And I think, in fact, she said this building might have at one time been used as a barn for livestock. Did you know that?
I can imagine, yeah. This looks like a deck for a 4-H auction going on.
I could see that. And so I suppose you'd agree with me, it's sort of ironic and humorous we're here in this place to discuss this important project. Wouldn't you agree with that?
Well, I think it's a good place to bring it back to the roots of Iowa. Yes, sir.
Well put, I suppose. You gave some information earlier about the number of parcels that were subject to this, affected by the pipeline. I think council tried to help you out that it was previous testimony was given about 1,274 tracts. Is that right?
1274. Yes, I was corrected on that.
Yeah. And Mr. Johnson, I think, had clarified yesterday that there were 316 parcels where easements had not yet been signed. Would you defer to Mr. Johnson's knowledge, or would you have better knowledge than that?
On the exact number, I believe that's right.
Okay. Would you have any idea how many miles of land that would constitute?
The percentage, and I did, but the percentage is roughly the same for the number of parcels. So we're 75.2%. You know, when you take out the actual highway itself or the road center line, we're somewhere around 74% in mileage covered. So it's roughly about the same.
I suppose then if I took 24% of 347 miles, would I catch the approximate correct number of miles?
Yes, you would.
Thank you for that. Well, I'm going to start off with the issue of the financial responsibility issue.
Okay.
It's my understanding that Iowa law has a provision which can require Dakota Access to provide a $250,000 bond. Are you aware of that law?
Yes, I am.
And I know that your company has attached to the petition some exhibit that refers to that bonding. Is that right?
I believe that's correct.
Now, is it your understanding that $250,000 amount, is that an amount that is singular and applied statewide, or can that amount apply to each parcel, $250,000 for each parcel in Iowa?
You know, I'm not familiar with how a claim would be made in that circumstance, how it would pay out. I'm sure in the legal brief that we could probably explain that with our attorneys.
You don't have the information or personal knowledge about that bond to answer any questions in particular?
I would post the bond as being the person within my company to get the bond in place. But as far as claims against the bond, no, sir, I'm not the right person. And I think in the legal briefs that I know we'll be submitting, we could probably articulate our position on that.
Are you aware of any provision under Iowa law concerning the hazardous liquid pipeline law that requires Dakota Access to provide liability insurance?
No, I'm not going to claim to have read the Iowa codified statutes word for word.
Sure. Last night there was some interesting testimony provided by IUB staffer Sturzma in response to questioning by Chairperson Huser. He specifically noted that there was some legislation proposed before the 2015 legislative session which proposed to require a hazardous liquid pipeline such as Dakota Access to carry liability insurance. Are you familiar? Are you familiar with that legislation that was proposed in the last session?
You know, I was, but certainly what's proposed in a legislative session that's closed and failed, I don't see what relevance it has today.
Now, during the, I guess my question in response to your answer is, should the Iowa Utilities Board decide not to grant the permit because of this issue, that there is no insurance requirement, would Dakota Access work together with my organization perhaps to try to craft some law that's going to address sufficient insurance coverage that this board can adopt?
We as a company will abide by and conform to the statutes that are put in place based upon the various legislators of the states we operate in. We certainly will provide our comments on statutes that affect our business. To join with a private organization to lobby for specific legislation is not something that we normally do. We have a group in our company that does various legislative outreach, and so I don't believe that's something that we would do. But I will say, you know, as part of our commitment to the state of Iowa, we've already represented, we have as Dakota Access a liability policy or commercial general liability policy that will be in effect when we go into operation, valued at $25 million. And we've also articulated that as a parent as the responsible party, we have multi-layers of insurance and other financial resources that could come to bear in the event of a situation that would provide that coverage in the event of a spill or release.
We're going to get to those things.
Okay.
Back to the legislative session in 2015, you mentioned that your company has a lobbying arm. Is that right?
We have a group that has a legislative outreach program.
I see.
I
A
don't-
legislative outreach program.
Right.
Was that legislative outreach program utilized in this last session?
Objection, Your Honor. Relevance, whether or not we took a position on the bill in front of the legislature that didn't pass, has absolutely nothing to do with any standard of decision before this board.
Mr. Murray?
Actually, I'm following up on IUB staffer Sturzman's comments last night that he felt that the legislation was pretty good stuff and he liked it. And I wanted to know if the company had lobbied against it.
I, again, don't see the relevance of the connection there, number one. Second, I'm not sure that Mr. Murray has accurately characterized Mr. Sturzman's testimony, which I don't believe had to do with liability insurance per se, but that's it. The real issue here is our position on the legislation just simply isn't relevant to the proceeding.
I'm sustaining. Mr. Murray, you need to move off the 2015 legislation.
Thank you. Let's go to your testimony, the reply testimony, page 8, lines 1 through 3. And this is a sentence that you obviously are well versed with. I think you've already provided some information on this sentence in earlier cross-examination, right?
Yes.
Dakota Access will carry sophisticated multi-layered insurance policies, as you would expect for an investment of this size and with sophisticated investors, is what this says, right?
That's correct.
Now, with respect to securing that insurance, I believe you testified that during Sierra Club's cross, your testimony was that you pick what you want when it comes to the selection of these policies. Do you remember that testimony you gave?
I do.
Now, insurance policies are generally secured on an annual basis, correct?
I'm sure there's many different ways of doing that.
Are you looking at insurance policies right now on this particular $25 million policy?
We are.
And is the term of that policy a year?
We have not concluded that at this time.
Can you give a range for the terms that you're looking at there?
No. Insurance policies, corporate insurance policies of this magnitude and scale are very, one, confidential, and two, they're developed under client-attorney privilege, the terms set forth and negotiated. I'm not at privileged to share that information in an open forum. And to be honest with you, I don't know that I have the answers to answer all the questions on that.
We'll reserve that for the confidential side, okay?
Yes, sir.
Now, there was some other earlier mention about the coverages that are afforded underneath an insurance policy like this. Would you agree that one must look at the language of the actual policy in order to determine the nature of the coverages and the exclusions that are inside that policy?
I think if you're an insurance broker and you have the sophisticated knowledge to understand corporate general liability policies and can read that, sure. I think from a general layman's perspective, I'm up here giving you my corporate commitment that we'll have this insurance policy, and then we will make sure it's enforced and enforce, as well as live up to our obligations in the event of an emergency. So what that insurance policy says is secondary to our corporate commitment to what we're willing to do and what I believe we put forward in the record.
So if a claimant makes a claim against an insurance policy, are you saying that the language in the policy is secondary to that claim, or is that language primary into consideration of that, the coverage for that claim?
Well, the claim would come to my company, and then we would probably, depending on the scale, and I don't, we're talking very hypothetical here, without knowing the extent of the claim, we would probably make the claim to our insurance as opposed to the landowner making a claim directly to the insurance. I think we would probably provide some type of buffer up to a certain point, and depending on the circumstance, would dictate the process how that would work.
So then that brings up my next question. Can landowners make claims to these policies that you have yet to secure?
They can, yes.
Okay. So I'm going to just focus on that claim rather than the claim that goes to your company and your company goes to the insurance
Sure.
policy. When the landowner makes a claim directly to the insurance company, does the landowner have received notice of that insurance company itself and how to make that claim from Dakota Access?
We provide, and I don't want to say this categorically for all landowners because each landowner agreement or voluntary agreement is negotiated, but for landowners that want a copy of our I just forgot the term sheet of our policy. It's a one-page form as an additional insured. We hand those out and provide those to the landowners, which has the basic premise of the insurance policy, the policy number, who to contact to make a claim. So they're offered that information as part of the easement.
And will that also be the case for those landowners being taken by eminent domain?
Mr. Murray, I apologize. You're going to have to hold on a second. Marie, can you give us an update? So we're rebooting, and because the testimony, I believe, is of interest to individuals that may be watching the live streaming, we are going to stand at ease until they've rebooted. For those of you who don't know, our system is down. We are back live streaming.
Good to know. If I could ask permission for the court reporter to read the last question pending before the witness.
And question, and will that also be the case for those landowners being taken by eminent domain?
Okay. Can you hear me?
Do you need Shane? No, that Shane.
How's that?
I can hear him.
All
Is that
right.
all right?
All right.
Can you hear me? Okay. It fell off. I apologize. Is that good? Thank you.
Okay.
Okay.
Mr. Murray, do you need the question restated?
It might help out. Let's go ahead and try it again.
Question, and will that also be the case for those landowners being taken by eminent domain?
So just to refresh what I had said, I believe before, is that if the landowners so choose, we can provide them an insurance certificate as an additional insured. In the event of a eminent domain proceeding, I think it's important to note that we indemnify the landowners 100% no matter what. So having a copy of the insurance certificate or not having a copy of the insurance certificate, the landowners are protected by that indemnification no matter the circumstance. I guess normal practices under an eminent domain case, at least in my experience across the United States, the courts have typically not required the company to provide a insurance certificate as part of the eminent domain proceeding, but the indemnification language does persist or prevail in those hearings.
So how about if this board were to issue a conditional ruling that required Dakota Access to provide those proofs of insurance coverage for landowners taken by eminent domain? Would Dakota Access agree to do that?
Yeah, so practically, I believe I've already said we're willing to give the certificates to whoever asks for them. Legally, can the board do that? I'm not sure. I'm sure our lawyers can provide brief on that if they can or cannot, make that requirement. I'm not sure. As a company, I'm already committing that we would give the certificate to anybody who asks for it. So I don't know that a board condition really adds any value, but I don't know the legal ramification of that.
I'm going to jump around and come back to this subject, okay? There was prior questioning by Mr. Taylor, and it had to do with, I think, in South Dakota, and was it an indemnification bond, indemnity bond concerning roads?
Yes, that was for for public roadway crossings.
And as I recall your testimony, I think, and you better correct me if I'm wrong, but the law in South Dakota, I think you testified, was that there was a requirement for a $15 million indemnity bond, but that the company had agreed to go to $24 million. Was that your testimony?
A little bit different. There's a statute that requires an indemnity bond. It doesn't set a value.
Oh, okay.
It's up to the board or the commissioners in South Dakota to come up with an appropriate value for the bond based upon the project. We proposed a 15. million bond based upon some historical data. One of the staff researchers in South Dakota requested a larger bond, $24 million, and we just agreed to it. So
Thank you for that.
you bet.
Coming back to this issue of insurance, would you agree that with respect to the issue of oil and hazardous liquids, in the insurance industry, there is some special coverages with respect to environmental pollutant coverage? Is that the right terminology?
There could be, yes.
And that's something that there's packages or special policies and coverages for environmental pollutant coverage, if I understand it right. Is that right?
There is.
And so when a landowner makes the claim directly to the insurance company now, would you agree that the primary language that determines whether there is insurance coverage under that policy is the policy language itself? Would you agree with that statement?
I don't know that I followed your question. Sorry.
I'll try it again.
Okay, thank you.
Try it again. I'm talking about the situation where a landowner is not going through the company and the company making the claim, but when a landowner is making a direct claim to the insurance company, okay?
Okay.
When that happens, and when we are trying to find out under that policy if there's coverages or whether there's exclusions from coverage, would you agree that the primary language of the actual insurance policy would control that decision?
I would imagine it would, yes.
Okay. And there has been some reference to, well, let's just talk about CGLs, commercial general liability coverages. You're familiar with that term, right?
I am.
And when you talk about the, to use your word, the multi-layered insurance policies as you would expect, would those policies include commercial general liability insurance coverage?
They do. And before we get too lost in the details of insurance, our easement forms indemnify the landowner. So, I know insurance is an important factor, and it's one of the tools that we have in our tool chest. Insurance simply is not the only tool that we have to remedy a situation. So by indemnifying the landowner for any damages that we may cause to their property, I think you know this as a lawyer, that we are, by effect, taking that responsibility or onerous on, no matter if the insurance provides coverage or not. So the insurance is not the primary base that's providing the coverage. In fact, it's Dakota Access that's backstopping 100% any claim that could be made, and the insurance is just one of the pieces of the pie. We have, $2.2-ish billion of other resources to draw upon, meaning financial assurances from our parents, equity, revenues that we can draw upon, the financial resources of our parents.
Your Honor, I'm sorry, Mr.
Okay.
Mahmoud.
Yeah.
It is, I wanted to let him go, but I'm focusing on the insurance. I appreciate the answer, but it is getting non-responsive and narrative. If I could just ask that the witness focus on the insurance issue for now.
Mr. Mahmoud, I think what he's trying to do is just try to direct your answers to the question he asks and not so much detail. And then if he wants more detail, he'll let me know.
Okay.
We're going to talk about those other things you just mentioned later on. My stream of questions, as you accurately put, is right now just focused on insurance.
Okay.
So if I could hearken back to my last question, we were talking about commercial general liability coverage as part of the coverage that's within those multi-layered policies, right?
Yes.
And would you agree that when it comes to the issue of environmental pollutant coverage and the interrelation of that coverage as it relates to commercial general liability coverage, there's quite a bit of the language of the policy is going to be pretty important here in determining whether there's a coverage for an oil leak, right?
It is, and so this gets into a pretty technical discussion of the difference between environmental pollution coverage versus commercial general liability. Now, I'm going to try to answer your question, and if I'm going off the deep end, just holler.
No,
okay?
you're doing fine right now. You go right ahead, and I'm sure there's going to be questions if you don't fill it out. But why don't you go ahead and just talk about those details?
Sure. So our commercial general liability policy, it covers direct damages that would result from a spill or a release. It could be an immediate spill or release, or it could be a persistent spill or release. So the type of release is somewhat indifferent. The fact of the matter is that if we do have a release that results in damage to the property, one, and I hate to go back to the indemnification, but that's important here, we indemnify the landowner from that damage. Two, our insurance policy actually differentiates between environmental pollution, which would be a sustained pre-existing condition, versus an actual direct impact from a spill or a leak. So if we had a spill or a leak that resulted from our pipeline, it actually would be covered under our CGL policy as opposed to our environmental pollution policy. Environmental pollution policies are for if we uncovered arsenic in the soil of a piece of property that we purchased and all of a sudden we had to remediate. That's an environmental pollution policy, very different than a commercial general liability policy that actually is for direct damages that result from a spill or release.
So
I hope that was explanatory to bridge the gap between the two or show the gap between the two.
It did help. It did help. So in the event of after we have the construction of this pipeline, should the permit be granted, and your pipeline is operating, and if there is a spill or a leak, this would be under your CGL policy. Would I have that right?
Yes, sir. That's correct.
Is that the $25 million policy you're referring to?
That's the Dakota Access standalone policy that we have. That would be layer one.
All right. There are other layers of CGLs behind it?
Yes, sir, there are.
All right. So I'm just going to run through some possible claimants here on that. Would these policies include coverage for claims for damages brought by adjacent landowners for a leak?
If it was directly related to the spill or release, yes, sir.
And would these policies include coverage for claims brought for damages to water bodies?
Absolutely.
Now, referring back to your statement, same page, 8, I think. Line 1, it says, moreover, Dakota Access will carry. Has Dakota Access secured those policies yet?
We're in the process, so they're operational policies. We have a different policy that covers us for construction, which is in fact in place. But the operational policy that we're talking about today has not been procured, but it will be before we start commissioning.
So, as I understand it, Dakota Access was formed back in the beginning of 2014. And what I should probably be very clear about the language there. The applicant, Dakota Access, LLC, that was formed towards the beginning of 2014 as a Delaware corporation. Do I have that right?
I believe that's correct.
Okay. Because there is another, I think, holding company that bears a similar name. Is that right?
Yes.
Yeah. Well, when I refer to Dakota Access, of course, I'm not talking about the holding company, right?
Sure, that's correct.
Okay. So I think you've answered all of my other questions about insurance. Oh, well, and perhaps I can be corrected. in the future then, can Dakota Access make a different decision on its insurance coverages and what it will choose to keep in place?
It could. We do have, in some of our agreements that we have in various forms, the drainage agreements are a good example.
Let's go with that.
Sure.
I'm going to have the tech desk bring up NILA.
Your Honor, can the witness finish answering the question that was previously asked before we change subjects?
I'm okay with that.
Mr. Mahmoud?
Yes, ma'am. What I was going to say is we agreed to certain insurance limits to be provided and an insurance policy to be in place for the duration of the pipeline to be in operations with those districts. And in the event that we, for some reason, decided not to maintain a certain form of insurance policy, and I think they're $5 or $10 million CGLs, if I remember right. Then the boards, drainage district boards, would then have certain recourse that they could take to either enforce us or require us to get a policy and or terminate our agreements. So sure, the possibilities out there, but I believe it's very customary for companies like mine to carry insurance policies to backstop their potential liabilities. It's as being a prudent operator.
Okay. Now we're going to go with NILA Exhibit 23, which is e-filed, and I have a hard copy for everyone here. And by the way, this exhibit has not yet been actually marked NILA Exhibit hearing Exhibit 23, but I would ask that it be so marked. Do you have that in front of you, that hearing Exhibit 23 in front of you?
I do, yes. It doesn't have a 23 on it, by the way, but what you just handed out, I have.
Thank you.
You bet.
May I, just for identification purposes, can I exchange mine for his and he can identify it as Exhibit 23?
Marie? Mr. Murray, when was this filed?
November 30th.
Oh, it's right on there. You may proceed, Mr. Murray.
I think you just had referred to drainage districts in your last answer. Would that be right?
Yes.
And would one of those drainage districts that you're dealing with be the Buena Vista County, the drainage districts that are controlled by Buena Vista County Board of Supervisors?
Yes.
Okay. And I take it you have some personal knowledge about your dealings with the drainage districts and how you're formulating those agreements with those drainage districts?
Yes, sir.
And just for a little background here, these drainage districts, has been testified before, they've got ditches and they've got tile lines, and as you would expect, crossings need to occur there, right?
Yes.
Okay. So with that background, I'm showing you NILA Hearing Exhibit 23. And it appears to be identified at the very top as Board of Supervisor meeting, 52nd meeting, 2015 session, November 17, 2015. And then if I could direct your attention to the third page of this exhibit. And, well, let's see here. Yeah, the third page. There appears to be a resolution that was passed by the supervisors concerning Buena Vista Drainage Districts on construction of a hazardous liquid pipeline over, across, or beneath county drainage districts. Are you familiar with this resolution that appears to be passed by the county board in Buena Vista?
I am.
Okay. And while this document appears to be labeled a draft, I'll note that in the upper right of each of the pages. If I could let you take a look at this document, as long as you like, would you agree that the form of this resolution here is part of the negotiations that your company had?
You know, I'd have to confer with Brett, my attorney, on this, and Keegan. As far as I can tell, it is, and
Yeah.
I know there's been this has passed. So whenever we get the final one, I assume it is the latest and greatest. I'll give you the benefit of that.
And it was passed back in November 17, to your recollection, wasn't it?
That's correct.
Okay. Now, I should probably refer you to page 7. Let's see here, page 17 of the exhibit. And we're going to go down to the section F concerning insurance.
Okay.
Okay. So why don't we, I know you're just not able to look at the rest of this thing to verify, but let's read through this pretty closely here to make sure this conforms with your negotiations you had with Buena Vista. And you may need to go to the next page too.
Mm-hmm.
You ready?
Yeah, I am. Yes.
Okay. At this point, does this appear to accurately summarize at least the insurance provisions of the agreement between Buena Vista County Drainage District and Dakota Access?
It does.
Okay. With that background and foundation, Your Honor, I'd ask to move to enter Exhibit NILA Hearing Exhibit 23 at this time.
No objection.
NILA Hearing Exhibit 23 is admitted.
Thank you. Now, drainage districts, I'm going to back up here. Is Dakota Access seeking voluntary easements with drainage districts, or would it be seeking permits from these drainage districts? Or what is it anyway that you're looking for? And
Easements.
easements?
Yes.
Okay. And I think you said earlier that you've obtained, I think you're dealing with 3 drainage districts, is that right?
We've obtained 3. I just can't remember the total.
Oh.
We were dealing with it on a county basis. I think everybody knows in Iowa there's multiple districts per county. So we're working with the county to get these various resolutions in place that would be utilized for the entire county, for all the drainage districts within that county.
Can these counties, looking at this section here concerning insurance, you would agree this looks to me like a condition of an easement that the pipeline company is agreeing to across the drainage district's resources, right?
It's part of their resolution, yes.
And I should ask you, because this is their resolution, but will Dakota Access later on sign something with Buena Vista to agree to be bound by these terms, at least in this section F?
We will.
Okay. And where in Iowa law does it allow a drainage district to require Dakota Access to have insurance?
Objection, Your Honor. The witness is not an attorney, and asking for a legal conclusion on the authority of drainage districts is beyond the scope of any of his testimony.
Mr. Murray? Sorry.
I think the witness has given, the witness has given, I'll limit my question to his personal knowledge as to the law because he has given previous information about that issue. Would that be suffice?
The witness shall answer based on his personal knowledge.
Based upon your personal knowledge, if any, is there anything in Iowa law that allows drainage districts to place these sort of conditions upon pipeline companies such as yours?
No, I couldn't tell you.
You couldn't tell me?
No.
Okay. But Dakota Access, as I understand your position, with respect to whether the Iowa Utilities Board should take this language in this resolution and say in its order that Dakota Access needs to comply with this language. Can you tell the board what Dakota Access's position would be with respect to that?
When we were negotiating this, so I'll back up a little bit. I believe, in my opinionated way of how to handle these things, I think there's a point in a county passing resolutions that may be overstepping their authority when it contradicts with state law. Now, in this case, we negotiated with the county and agreed to certain provisions in this resolution that were non-detrimental to the project, but beneficial to the county. So in that case, in any fair negotiation, both parties reach a resolution that results in a compromise to each party. So, as I said, we reached a compromise in this and agreed to these limits. Now, what the board can and cannot do as far as a condition of their permit, I have no idea. Should the board want to follow a similar dollar value for insurance coverage, we're agreeing to provide the insurance coverage, and we're voluntarily willing to give a certificate of insurance to landowners, and we're indemnifying every landowner or jurisdictional body against any harm that would come as a result of our project. So in my simplistic way of putting all that together, I don't have a problem with it.
You don't have a problem with the IUB using this sort of language in conditioning its permit?
Again, they're sitting behind me, so we can ask them if they can or cannot do it. I don't know what they can or cannot do. What I can say is that we're okay with the $10 million CGL policy being in effect.
Okay. Why was it at $10 million when you had a $25 million standalone policy and several layers above that?
You'd have to ask them directly. I mean, that's the number they proposed.
I see.
Mr. Murray?
Yes.
Just a moment, just for the record, I would like to know when you're saying we, is we Dakota Access LLC, or is we ELP?
In this instance, it was we as in Dakota Access LLC.
So anytime you're responding, can you state who we is?
Yes, ma'am.
Thank you.
Thank you. Well, I bet you'll be asked about those questions later on.
Okay.
But the language in here, I wanted to point out. In the first paragraph of that section F, and it starts with applicant shall also certify. Go up with the hand if you would, text. Up with the hand and to the left. Oh, no, I mean just move the hand itself on the page, and now over to your right. Keep on going to your right. And now down a little bit. Down, right there. The sentence that starts with applicant shall also. See that?
Yes.
It says there that applicant shall also certify that the insurance does not contain exclusion for environmental pollution, or applicant shall provide an alternative environmental pollution policy that meets the minimum requirements as defined below. And then it goes on to talk about the limits. I'm going to kind of state it a little more plainly to help. You can walk me through this. It goes back to that oil leak on an operating pipeline. We've got an oil leak. Does this language, in your opinion, cover that situation?
I believe it does.
Okay. And going down to the next page on, I think it's page 18 of this document. Going down to that subsection, I think, little Roman numeral 6, where it starts with the word remedies. It says remedies available to the board. Now, that board we're talking about is the Buena Vista County Board of Supervisors, correct?
That's correct.
It does talk in that section about injunctions and lawsuits, right?
Yes.
Would Dakota Access agree to that sort of language for landowners?
So again, I'm gonna go back to the indemnity language in our base form easement, and every easement that we've presented. Our indemnity language provides for indemnification of any impact to that person's property that results from us. It provides for their defense in the base form agreement. So having the policy set forth, or some agreement secondary to the indemnification language really doesn't buy the landowner any specific protection that they may believe they do. If a landowner in good faith negotiations, and I remember when you and I personally met in your office, that we talked about this. And, back then we said, look, we'll be more than willing and happy to work with your landowners or yourself or your mother to work through an insurance certificate that would provide whatever assurances that you all may determine is necessary. That offer stands today. In a condemnation proceeding, I think I've already articulated that insurance certificates typically are not part of an eminent domain proceeding. I just haven't seen it. But the indemnity language stands and prevails. So I believe, in my opinion, that you are getting, when I say you, I'm referencing landowners. I believe that they have better protection in the indemnity language than they do in this insurance policy, because the indemnity is unlimited in dollar value, as opposed to an insurance policy that has a $10 million loss set with it. And that's what we were trying to articulate even way back when we met that time.
And I don't believe my question was answered, so I'll ask it again. Would Dakota Access agree to give landowners this provision concerning injunctions?
You know, probably not. In primarily, and again, it goes back to the indemnity language. And in an eminent domain case, you know, these type of provisions and language simply don't become part of the form easement that are condemned for. So it's not something that we would voluntarily do, no.
Thank you. I'm skipping over some confidential stuff here with the facility response plan. Oh. Yeah, but I wanted to also refer to OCA Hearing Exhibit 2, but that's going to be confidential as well concerning the form of the agreement, guarantees. Okay, let's talk about the Oil Spills Liability Trust Fund.
Okay.
Your testimony on page 8, line 3, I think mentions this, and I think you say there that finally, as an ultimate backstop, there is the Oil Spills Liability Trust Fund that has a $1 billion value limit to cover costs or cleanup and claims, which under the Oil Pollution Act of 1990, and you refer to that as OPA 90, the costs of such would be reimbursable to the fund by the responsible party, which under OPA 90 ties the responsibility back to the owner of the facility or the operator. That's what I'm referring to, okay?
Okay.
My question here is, are you saying that the oil, this is after all the other things that you're talking about concerning the assets of Dakota Access LLC, okay? And after this indemnity provision you've been referring to, okay? And after the insurance provisions that we've just discussed. Are you saying that the OSLTF is a potential source of payment for any type of discharge of oil whatsoever from the pipeline?
I don't know that I can say that because I'm not a legal expert in oil spill trust. The general reading of it and the general explanation is that if there's a claim or a spill that occurs and the responsible party doesn't have some affirmative defense to that spill or claim, that the Oil Spill Liability Trust Fund would kick in, and the federal government would then act as the party that would remediate and reclaim the damage and spill, and then would act as an arbitrator, for lack of better words, in any claims or disputes that result from damage. And then in the end of that, if there were claims paid out of the fund, then the fund operator, which is the U.S. Coast Guard, would then seek relief or repayment of those dollars back from the company or the responsible party to keep the government whole.
Would that also apply to explosions or fire from a pipeline, the OSLTF?
If it was a result of a spill, sure.
How many, to your knowledge, how many valves are on this pipeline project in Iowa?
66.
And I think part of those include the some affiliated facilities such as launcher sites,
Yeah,
right?
62 plus the launchers and receivers and pump station.
So there's 62 valve-only sites.
I believe that's right.
Okay. That's what I'm referring to in these questions.
Okay.
I think we heard testimony from Mr. Caruso about how these valves have a higher potential for targets or acts of terrorism. Were you here for that testimony?
I was not.
Okay. I think during your questioning of Mr. Taylor of you, that you were mentioning 3 exclusions from the application of the Oil Spills Liability Trust Fund. Can you go over those again for us?
Sure. Acts of war, acts of God, and then willful misconduct or gross negligence.
Do you have any idea about whether if a terrorist were to hit one of these valve sites, whether we would have an exclusion applicable under one of those scenarios?
I don't have a clue.
Fair enough. Now, part of your testimony goes into detail about how parent companies of Dakota Access and I say Dakota Access LLC, and its parent companies are responsible parties for oil leaks under the oil OPA. I just read that to you, right?
Yes.
Would the liability upon these responsible parties, I'm going to back up and strike that question. When the term responsible parties is unique underneath the OPA, is it not? That's a defined term, correct?
It is a defined term under Open 90.
So that's how I'm phrasing my question when I refer to that phrase, okay?
Okay.
Would the liability upon a responsible parties under the OPA extend to all potential leaks of oil from this proposed pipeline?
I believe that's right.
Now, as I understand it, the National Pollution Funds Center of the U.S. Coast Guard administers the OSLTF. Is that right?
Yes.
And I believe there's a public database maintained by the National Pollution Funds Center in this regard, correct?
Yes.
And that database does have information about claims that have been made to that fund, correct?
I believe it does.
And I'm going to have the technology chair pull up NILA Exhibit 19. Now, let's this document appears to be headed Claims Summary / Determination Form, and then if I could have the tech chair go down to the second page, onto the bottom there, the page. And keep on going down. As you review this, and if we could keep on going down to the letter that follows. Would you agree with me that this document appears to be something originating from the U.S. Coast Guard National Pollution Funds Center?
I mean, that's what it says.
Okay. Now, I'm going to refer to the claimant on the first page. It appears that the claimant here is Betty Russell from Oliver Springs, Tennessee. Has Dakota Access or any of its affiliated entities had any discussions with Ms. Russell prior to today's hearing at all?
No, I can't even validate the accuracy of this document that you're presenting in front of me. I have no idea where you got it, who it's from.
Okay. Well, on page 1, there appears to be an oil spill incident that's being described here. Okay, right where the hand is. I'm just going to let you read that. starting with the words on March 18, 2008, it goes on to talk about description of that claim, okay? And in the last sentence it says, it is unclear whether the oil actually discharged to a navigable water of the United States. My question for you is, wouldn't you agree that when it comes to holding a party liable as a responsible party under the OPA, the issue of whether oil actually discharging into a navigable water of the U.S. could be a pretty important issue with respect to the determination of claims under the OSLTF?
Objection, Your Honor. Calls for a legal conclusion.
I'm going to sustain it. Do you want to try and restate it, your question?
I'll publish NILA Exhibit 18. And I would like to go to data request number 2. Now, in here, this is a data request from NILA to Dakota Access that asks, please admit the only applicability of the Oil Spill Liability Trust Fund as it relates to real property claims is contingent upon a showing that an oil spill incident constitutes a substantial threat of discharge into navigable waters of the United States. If you deny, please explain fully your denial. In Dakota Access's answer, it does appear to refer to the fact that navigable water is, in fact, an important issue in determining the applicability of the Oil Spills Liability Trust Fund. Wouldn't you agree with that?
Objection, Your Honor. That is misstating the document, which speaks for itself. What Mr. Murray keeps leaving out, he wants to imply that there has to be a direct discharge. As the full text of what's on the screen shows, it simply has to be a threat of a discharge to a navigable water. It can be indirect, and he's misleading the witness by shortcutting and paraphrasing the document, which speaks for itself.
Mr. Murray?
I'm just saying, I'm just asking the question that the issue of whether a navigable water is affected is an important issue under the OSLTF. And I'm asking if the witness would affirm that.
Okay. Restate your question.
As I understand the position of Dakota Access, the Oil Spills Liability Trust Fund covers real property claims attributable to either a discharge of oil or a substantial threat of discharge of oil into or upon the navigable waters of the U.S. as I read your answer to data request number 2. Would I have that right?
I didn't follow along. Did you read it verbatim? I mean, I could read it verbatim. I'm sorry. I mean,
yeah, go ahead if you want to. Why don't you go ahead?
It says the categories of real property claims recoverable from the Oil Spill Liability Trust Fund are broader than those described in this request. Real property claims attributable to either or both a discharge of oil or the substantial threat of a discharge of oil into or upon the navigable waters or adjoining shorelines or the exclusive economic zone are recoverable from the Oil Spill Liability Trust Fund.
Thank you, and I'd like to move to enter NILA Exhibit 18, data 18 into the record.
I'm sorry, 18 is the data request that's on the screen?
Yes.
No objection.
Data request number 2. Is there an exhibit number on that?
Data NILA Exhibit 18.
NILA Exhibit 18 is admitted.
Thank you. Let's go back to the case of Betty Russell, shall we? NILA Exhibit 19, please. I'm going to go down to the second page of this document. Now, under the section Determination of Loss, I'm going to have you take a chance to read that for just a second. Ready?
Sure.
In the case of Betty Russell, she was unsuccessful in making her claim to the oil LTF. Does this paragraph explain why?
This has nothing to do with my writing, my production. I don't even know where this came from. So I'm not going to sit here and interpret and paraphrase what's said in this paragraph. I can read it verbatim, but I'm not going to paraphrase anything in this.
Okay. Would you agree that this document appears to show that Ms. Russell failed to recover on her claim because her damages to her real property were a result of an explosion or a fire rather than a discharge of oil affecting navigable waters? That's what this document says, isn't that right?
Objection, Your Honor. Again, that's only part of what the document says, and this is why the document should speak for itself. The document goes on clearly at the end to say that the claim is moot because there's already been an agreement to resolve the claimant's claim.
If counsel will agree to the admission of NILA Exhibit 19, I'll withdraw the question.
Public document, Your Honor, no objection.
NILA Exhibit number 19 is admitted. And the question is withdrawn.
It is. Okay. I should probably go to NILA Exhibit 18 to the data request number 3 so that the witness can look at that. I don't want to, just take a read at that if you would, Mr. Mahmoud. Would you agree that it is the position of Dakota Access LLC that the phrase, quote, navigable waters has not yet been defined by the federal government or the state of Iowa for waters in Iowa?
I can't say what has or has not. I can tell you, though, that the EPA has defined what waters of the United States are in very clear terms many times, and it's been adjudicated many times. So I don't know that there's any question about what a water of the U.S. or navigable waters are. Now, in the state of Iowa, I don't have a clue, but on the federal level, I think that definition's clearly been tested.
And going back to your testimony, page 8, line 3, recalling that I think you referred to the All Spills Liability Trust Fund as the, quote, ultimate backstop. Wouldn't you agree that this assurance would necessarily require that this board have knowledge about where these navigable waters are located in Iowa?
I don't know. I mean, I can't speak for what the board relies upon or not relies upon. I can tell you we did a little bit of research, and I can put up 4 different cases that show trust fund claims that originate in agricultural areas. So I don't know that my statement here is misleading at all.
Do you have those today?
We certainly can. I don't know if we can get an adequate number of copies by the end of the day, but we do have them, and we can provide those as a late filed exhibit.
At this point, I would suggest it's a good breaking point in my questioning, and we're at 11:45 maybe with the board's timeline and my refereeing of time frames.
Are you ready for a break, Mr. Murray?
Yes.
I do not want you to provide those in paper copies. If you're going to provide for Mr. Murray's request, I simply ask that they be filed in the electronic filing system.
We can, yes, Your Honor, we can file those electronically.
All right. And on the motion apparently made by Mr. Murray, we are going to recess until 12:30. Back in session. Mr. Lashier, will you approach? Good afternoon.
Good afternoon.
Please raise your right arm. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Could you please state your name and address for the record?
Eric Lashier, 422 46th Place, West Des Moines, Iowa.
Did you file with the Iowa Utilities Board prepared written testimony?
Yes, I did.
And do you have any changes to your testimony?
I filed one correction to my direct testimony on November 11th, and then I filed a supplemental to my direct testimony on November 24th.
Do you want the board to adopt your direct, revised, and supplemental?
Yes, ma'am.
Okay. And there's no changes to any of those other than what's in the supplemental
And the correction, yeah.
and the correct.
Okay. Correct.
Do you adopt your prepared testimony?
Yes.
Do you own any of the property, or do you have an interest in any of the property, or are you representing the trust?
I don't own the property. I have an interest in the property. And as far as representing the trust, I'm not an attorney, but for this purpose, I am speaking on behalf of the trust.
Thank you for clarifying. We were having discussions. I assume that you had some interest in the property. I would ask
Correct.
the technology desk if they would pull up either the county land map or what do you have available? Could you please identify the property to which you're referring? As you can see, it says the Richard J. Begg, is it Begg?
Bag, yes.
Begg and Carol Lee Sorensen Begg Revocable Living Trust. Is that the property to which your testimony applies?
Yes, it is.
Could you tell the board your relationship with Mr. Begg and Ms. Sorensen?
Sure, yes. Richard Begg is my father-in-law, or was my father-in-law. He passed away in January of this year after being diagnosed with pancreatic cancer this fall. So he's passed away. Carol Lee Sorensen Begg is my mother-in-law, who is the trustee for the trust.
And for the record, which county is this located?
It's in Story County.
And what is the use of the property?
Presently, it's my mother-in-law's residence, and it is also rented out as farmland.
Have you, as of today's date, entered into any agreements with Dakota Access LLC?
No, we have not.
And have you stated you have a farm tenant, is that correct?
Yes, my mother-in-law rents out a portion of the property to a farmer.
Does any of the portion of the property that is rented out contain the proposed pipeline location?
Yes. Goes right through it diagonally. As you can see, it splits the property into about 3 different triangles. It's the hand is on the property. You can see that the proposed location of the easement basically cuts the property into 3 or 4 different triangles.
And it's cropland?
Yes, all except the most northern part of it. 6 acres up at the northwest corner is the site of my mother-in-law's personal residence.
And how much of the land is rented to the tenant?
I believe it's somewhere between 100 and 114 acres of it. There's a portion that's a little bit of explanation right directly northwest of the hand, you will see that little cutout. My mother-in-law also owns that property. Yeah, correct. That's right where the hand is. And directly, the most northern 6 acres is my mother's residence. And directly south of the property, if you keep going south to the right there, that land is owned by my brother-in-law. So we have, it's actually 4 different deeds are filed. One for my brother-in-law's property, one for the farm ground, and then there's a deed for the 6 acres, personal residence, and then the 2 or 3 acres just northwest, the little notch cut out right there. Yeah, those are all 4 of those properties are owned by members of my family.
And do you know whether your mother-in-law has any plans for a different use of the property in the future?
That is, that is a possibility, yes. Given the nature of the property and its location next to ground that is owned by Iowa State University, it is a possibility. There's the stadium, the Iowa State University football stadium, is 2 miles north of it, and there is quite a bit of new industrial, residential, I think it's multifamilies going into the property about 1.5 miles north of our property, of her property.
So development is not out of the question.
Absolutely not.
Does the property have drainage tile or any other installations upon it currently?
Yes, I talked to my mother-in-law just recently in the last couple of weeks, and there is drainage tile on the property. She does have some maps. I haven't looked at the maps of that tile, but I thought that was a little bit preliminary. But there is drainage tile on the part of the property being used as farmland.
To your knowledge, is the property included in any ag drainage district?
Not to my knowledge. I don't know if Story County has that.
Can you summarize for the board your precise concerns with the proposed crossing?
Be happy to. In the interest of time, I'll try to stick to the
I would appreciate that.
high points. There are several items of concern, all part of my written testimony, objections that I've filed in the past. Let me start with the specific location of the easement. As you can see, it's going diagonally through the property, cutting it into triangles, which dramatically affect the potential value and development possibilities of the land because of the restrictions in the easement. Therefore, so there is certainly that concern, the location of the easement itself, and why it could not be taken along the gravel road. That's a gravel road at this point is a question. It would be a lot less detrimental to the property if it were to go along the road as opposed to diagonally through the property, cutting it into those largely unusable triangles as opposed to a nice big plat of land that could be developed efficiently and to a possible highest and best use. So that is the location of the easement is one concern. Another item of concern is the valuation, the easement itself, the offer of the easement is not reflective of the true value of the property, both before, currently as is, and then if the permit is granted and an easement is obtained, the value after that easement on not only that property but the neighboring properties owned by my family. That is of immense concern. The initial offer that we've received from Dakota Access is woefully inadequate in that regard and not reflective of the method in which an appraisal should be done of the property both before and after the granting of a involuntary easement or voluntary easement, should that ever take place. The third item another item of concern is the terms of the easement. In my day job, I work with commercial real estate and commercial real estate loan documents quite a bit. And in part of that, I get to deal with easements. So I have some expertise in that regard in reviewing the terms of the proposed easements, of which we've got 3 or 4 that have been proposed to us to sign. They are woefully one-sided in favor of the Dakota Access, and I am of the opinion that they would need some significant negotiation before we would consider voluntarily entering into one of those. So that's of concern. And then finally, my ultimate, well, the couple of other concerns. It appears to me that the characterizations in some of the testimony that's been provided, I would disagree with. In my opinion, they've stated that the pipeline company stated that they've negotiated in good faith, and I would, my opinion, that it is not an adequate or description of the negotiations. And finally, it's obvious to me that the vast majority of Iowans do not see that this private pipeline going through private land is beneficial to Iowa. So.
Do you know what the name of your land agent?
I was given, in one of the mailings that we received from Dakota Access, I was given the name of Bonnie. If you'll permit me to look at that real quick, I can answer that for you.
I'm more interested in probably when is the last time you had a conversation with the land agent?
Sure. As far as verbal conversations, I attempted to initiate a verbal conversation with the land grow agent, however you want to term them, in late April, mid to late April, if I recall correctly. I did not write down the exact date. When I contacted them, I had filed an objection on April 1st and had provided Dakota Access, sent the objection to, not only filed it with the Utilities Board, but sent it to Dakota Access on April 1st. I followed that up with a telephone call to the land agent that I was provided in her letter of mid-March of 2015, and said, hey, I've sent this letter, I'm willing to talk. And she said, and I told her I sent it down to the address in Houston that I was given, and I never received any call back from them. The only thing I've received from them is written items.
All I wanted to do was verify that your testimony, that's the last time you had any contact, and that you had no contact with them since that time.
Since April 20th is the last time I've received written communication from them.
Okay. I did not ask, but you just stated you filed objections in this docket. Do you wish to adopt the objections that you filed as well for the record?
Yes, please.
Mr. Lozier,
We have no questions.
Mr. Piazza,
We have no questions.
Mr. Dublinsky,
Just a few, Your Honor. Mr. LaSher, I'm sorry. Are you aware that in early May, James Begg told the land agent that you collectively, speaking for the property, were not interested in negotiating?
There were several times where a land agent came onto our property. They were not invited. They did not make an appointment. And at that point, we declined to just discuss with them. I think that's specifically what my brother-in-law James Begg said. I cannot confirm that.
So you're not aware of the fact that it wasn't just we don't want to talk to you now, that he represented to Dakota Access that they weren't interested, they collectively weren't interested in talking, period, that they might reconsider if we got our eminent domain rights.
I have not spoken with my brother-in-law and he did not convey that specific conversation to me.
But you are aware that he has had separate conversations with land agents from Dakota Access?
I don't know if they were land agents. Somebody showed up at our door uninvited, yeah. So if they were the land agents, yeah. I have in my objection that I filed and what I sent to them, I invited them to contact me, and no one has ever done any of that, sir.
Have you taken any steps towards rezoning or filing any plans for future development on the property?
No.
Nothing further, Your Honor.
Mr. Pauly,
We have no questions, Your Honor.
Ms. Wagner, Mr. Wagner, oops, Ms. Jacobs?
I do have just one or two clarifying questions. Good afternoon, Mr. LaSure.
Good afternoon.
Trying to understand the relationship between you and your brother-in-law in terms of this property. Are you the individual who's been selected by the family to speak on behalf of the family regarding this property? Or kind of following up with Mr. Dubinsky's question, help me understand where the brother-in-law and you and anybody else in the family has been actively involved in this.
Sure. I've got my wife obviously is is involved, as well as I've got three brother-in-laws, their wives. We as a family have talked about this, but this going on for quite some time. And given my experience with real estate, I've kind of been the point person for that, as was expressed in my letter to Dakota Access on April 1st.
Okay, so the potential of the contact that Mr. Dubinsky mentioned in May with one of your brother-in-laws, was he just doing that because he wanted to just talk about it with the land agent, or was somebody on the property when the land agent came? Or
so they just showed up unannounced, like I said, and said, hey, we're here to talk about the pipeline. And my brother-in-law was, of course, with my mother-in-law at the time, I think. I don't, we've had several people show up unannounced, and he wasn't prepared. He's not as fully aware of all the issues involved in this as I am. So I think that's probably, what Mr. Dubinsky, how he characterized that conversation, said that's probably why he responded as he did. We aren't prepared to talk about right there, because I'm kind of the point person for our family on that.
Sure. And then, to the best of your knowledge, was that the last time there was any contact between a member of your family and a representative of Dakota Access?
I didn't know about that date, but I don't think they've come in the last several months to discuss it. But I know they did come and show up at our door, at my mother-in-law's door, a couple times.
Okay. And then you'd mentioned the name of Bonnie, who the first, at least one of the letters in your that you provided, there was a Bonnie Meredith. Then there's also a letter from a Cody Brown. Was that the kind of a new land agent that you ended up talking with?
Yeah, the first one that we got, I think, was I pull it up, but one of the land agents was Bonnie Meredith that you mentioned. I think that was the March 16th 2015 correspondence I received for them. And then there was our detached garages.
Okay.
Okay, I think that answered all my questions. Thank you.
Welcome.
Mr. Lashir, thank you for joining us today. You can now step down and make sure your mic's off. We will have Mr. Mahmoud, if you want to get the mic back on, and we will proceed forward with Mr. Murray. While they are doing that, back to our organizational process for witnesses. I have been asked by Mr. Dale Denherter, who is scheduled to testify on why can't I see it? On December 7th. He is from Sioux City, Iowa, and is a property owner on that parcel. He is asking whether any party intends to ask him any questions, and if he does not need to drive here and we will adopt his testimony, he would like it if we would do the same. Mr. Dublinsky, do you have any questions for this witness, or will we be able to adopt his testimony without his attendance?
Your Honor, I would need to take a look after the conclusion of today's session. I can let the chair know in the morning.
Perfect. Then for any other party, I would ask the same, that you let Cecil know at 8:30 before we start at 8:30 in the morning as to whether or not you will have any questions for that witness. Secondly, if there are any other witnesses on the list, I would again ask if you are wanting to have their testimony admitted without them being in attendance. An offer has been made to accept some of those by Mr. Dublinsky, and therefore I would need to know from the parties whether or not you have anybody you want to admit their testimony in that manner. All right, Mr. Murray, are you ready?
Yes.
You may begin.
Shall we test it out, Mr. Mahmoud, as far as the sound?
Test.
That's pretty good.
All right.
Last night we had an IUB staffer, Mr. Stursma, who testified to the extent that Iowa's never had a pipeline project of this magnitude and expense. Would you be able to agree or disagree with that statement?
In general terms, I think I do agree.
Okay. According to Monica Howard, and I will point out her direct testimony, page 2, lines 7 to 8, which you'll see on the screen. I'm focusing on those last two lines there. It appears that Dakota Access engaged federal and state authorities in June of 2014 in relation to this proposed pipeline. Are you familiar with that testimony?
I am.
Okay. And if we could publish Dakota Access exhibit for Howard MH4. Thank you. I'm going to start with the first item on this this exhibit, okay?
Sure.
It appears one of the federal authorities in which a permit is required is the Corps of Engineers. Would I have that right?
That's correct.
And I gather from Ms. Howard's testimony, I think she said that multiple, well, let me retrace my steps there. Were you here for her testimony?
For most of it, yes, sir.
Okay. I think I used the phrase permits, but she corrected me and said, no, it's verifications that are needed. Were you here for that testimony?
Yes.
Okay, that's what I'm talking about.
Okay.
She testified that multiple verifications are needed on a single nationwide permit 12. as I recall. Would you agree with that?
Yes.
And those have yet to have been obtained from the Corps of Engineers. Is that right?
For the verifications for the PCNs, that is correct.
Okay. Now, as I understand it, Dakota Access cannot put this pipeline in the ground without these verifications from the Corps of Engineers. Do I have this correct?
No, that's not 100% correct. So they can't put it, we, Dakota Access, cannot put it in the ground and dig in what are called Section 404 or Section 10 waterways without prior, or what's called a pre-construction notification, if the crossing in fact triggers what's called a prior construction notification.
And those waterways you referred to, how many waterways are being crossed that would pertain to these verifications in Iowa?
I don't remember. I mean,
It's-
it's quite a few.
Quite a few. In this pipeline, in order to span across Iowa, for it to be functional, you have to have the permit in order to get those crossings, in order for this pipeline to actually be fully functional. You'd agree with that statement?
Not necessarily. Other than a Section 10 waterway, there are other ways to cross underneath what's called a Section 404 waterway that do not require some form of surface disturbance or fill into a water of the U.S., which a wetland, for example, would be one of those.
So
there's methodologies that you can employ, albeit much more expensive and difficult, to avoid triggering a PCN in the event that we wanted to do that to put the pipe in the ground.
well, let me ask it in this way. Without those verifications, can you pump oil in the pipeline as you have proposed?
Yes.
You can put the pipeline in the ground and you can cross these waterways without these verifications. Is that your testimony?
It absolutely is. And I think there's a little bit of a, and maybe I know too much about the process here. Nationwide Permit 12 is part of a nationwide permit program underneath the U.S. Army Corps of Engineers. The EPA has ultimate discretion via Congress to implement protection of waters of the United States in the U.S. They've delegated the permitting authority for those underneath the Corps of Engineers, and the Corps comes out with what are called nationwide permits. And under a nationwide permit, those are automatic authorizations. So there is nothing that says you either, it's not an applicable permit. You either meet the criteria or you don't. There's not a test that you may meet it. It's either you do or you don't. And if you meet the criteria, you go to the second test, which is, does it require a prior construction notification? And there's multiple items that you have to check off to determine if you have a prior construction notification requirement. In the event you do, in theory, you're not supposed to start construction without going through a prior construction notification. But as I mentioned earlier, there's methods in which you can employ that you can avoid triggering a pre-construction notifications. Therefore, you would be able to install the pipeline under the base permit of a Nationwide Permit 12 without triggering a PCN.
Has that process that you just described, avoiding this PCN, has Dakota Access undertaken that process?
No, we're going through some PCNs. Like I mentioned, there's pros and cons. The con of going through that methodology may be an extreme expense that is simply, you can avoid that expense or difficulty by going through a pre-construction notification under the rules as they're written. So in certain cases, it makes more sense to go through the PCN process to obtain coverage under Nationwide Permit 12 than it does to figure out an alternate crossing method.
Well,
But they're both available to you.
Sorry, I thought you were
It's
done.
okay. Sure.
I didn't hear the last part of your answer. I cut it off.
Either of those options are available to you if you in fact meet the conditions of Nationwide Permit 12.
I'm looking at the exhibit again.
Okay.
And under the status of the U.S. Army Corps of Engineers Rock Island District item, which is under the federal permit section, it appears that the status here is that pre-construction notifications for verification under Nationwide Permit 12 were submitted starting in February 2015. I'm going to stop there. Before that, I had pointed out that you had engaged the federal authorities as early as June of 2014, and this status appears to indicate a different date in February of 2015. Can you explain the differential?
So that's the time we start in June is we're developing the packages or information that would go into a pre-construction notification. So we submitted, so we were in contact with the federal agency prior to February of 15, but we actually made the physical submittal of the prior construction notification in February as opposed to June.
Do you agree that Dakota Access LLC could have chosen to suspend these proceedings while we await these pre-construction verifications to come in?
No, I don't understand that line of thought at all. I mean, one, why would we? Two, it's not required by law. And three, it doesn't make any sense to delay the submittal of a permit verification. That's an independent process held by a federal agency that's separate and distinct from the state IUB process. They're exclusive from each other. They're intended to mostly coexist with each other, but they're certainly not dependent upon each. And it makes no sense to delay the submittal of one for the other. I mean, why would we ever do that? That doesn't make any economic or viable sense.
Well, for whatever reason, you have submitted the pre-construction notifications to the U.S. Corps of Engineers. You've chosen that route, correct?
That's correct.
Quite a bit of testimony has been submitted in these proceedings about that, I think, right?
Yes.
And are you saying then that it is now necessary for this board to grant Dakota Access eminent domain rights over agricultural land for which these verifications have not yet been obtained?
Well, I think you're mixing apples and oranges, number one. Like I said, they're exclusive from each other. They're independent processes. The Corps of Engineers does not grant the right of eminent domain for a permit. Under Iowa state law, you get the right of eminent domain, partial, I guess, from the IUB statutes. The Corps does not have that authority to grant eminent domain for a permit. It's a permit to install the project in accordance with the rules and regulations. So it makes a lot of sense to chase those permits concurrently, just like the other 3,000, 4,000 items that we're trying to acquire during this time period. The other part of it is it behooves everybody in the room and all the landowners to simply stay on an efficient scale and time frame to install this pipeline. So the more delay we get into later in the year that pushes us into winter construction, the worse it is for the landowner. So we're trying to start construction at the right time to build the project so we avoid the potentially negative impacts that could occur during the winter. So we're finished by the winter. So when we delay things by pushing permits off or wanting to delay A, B, or C, that's a negative to the landowner. It's a negative to us. I mean, I'm not trying to say it's not, but it's also very much so a negative situation for that landowner to push construction to the less optimal time. And so, you know, that's why we don't agree with the philosophy of deferring one permit to follow after another.
So, as I understand it, what you're proposing is that this board would grant eminent domain, not the Corps, but this board would grant eminent domain rights, and you believe it's necessary for this board to do that without these verifications. Is that your testimony?
No, I believe this board is going to issue their permit, at least we hope, I'll say it from the applicant's side, they're going to issue the permit, that's our desire. And at some point, that will also come with, we hope, the right of eminent domain to close tracts that we've been unsuccessful in negotiating the closure of those. The right of executing the project under Nationwide Permit 12, we already have Nationwide Permit 12. We qualify for that. So it's not that we're waiting for Nationwide Permit 12. We're waiting for the verification of certain aspects of Nationwide Permit 12 for certain crossings. But we already have Nationwide Permit 12, so does everybody in this room if you wanted to install some type of linear crossing within a wetland or water of the United States. It's a permit by rule, if you've ever heard that term. It's not something that they're inventing or creating from scratch. So the suggestion you're making just doesn't really make much sense to me.
Part of your answer, I think, said that with respect to what you're asking from this board, you're saying that they should grant the permit and then sometime later get eminent domain over the land. That's what you said. Are you saying that the eminent domain will come after the verification from the Corps?
No, that's not what I'm saying at all. And I don't really follow how you got that out of what I just said, but that's okay.
Okay.
What I was trying to say is that the board, in their discretion or however the rules work, will issue their certificate or permit, which will have an eminent domain component as part of it. Now, I don't know all the legal statutes and rules behind that. I'm sure they do. And then the Nationwide Permit 12, I have in my hands today because it's an automatic authorization for the majority of the crossings, and only a few or a certain number, I don't know the exact number, do I have to get a PCN to comply with that? Does that clarify?
I think we're done with that point. We're going to
Okay.
move on. Yeah. Going to MH4 exhibit on the screen. Does this document, if we page through it, does it include anything in here about rural water? Let's see.
No, it does not.
Okay. And I think you mentioned that those agreements are not achieved yet. Is that right?
Well, they're not permits. So this is a permit table, not an easement table. We have literally thousands of easements that we're obtaining for this project. So this is simply a list of permits by regulatory statute.
Oh, okay. So then would the rural water issue be an easement?
An easement or some type of off, secondary agreement in principle. It would be a voluntary agreement between us and the rural water groups.
Would it be filed at the courthouse once you have the agreement?
I doubt it.
Okay. Landowners have, they either have easements that they sign voluntarily or they're getting taken by eminent domain, right?
Those are the two choices.
So with respect to rural water, has Dakota Access filed any proposed Exhibit H's concerning rural water?
No.
Has Dakota Access given those entities any notice of any such, any of these proceedings?
So rural water districts, and I'm not going to, I may overgeneralize, and if I do, forgive me, but they're not a permitting authority. So they have pipelines, just like Dakota Access is a pipeline. They have an easement. So just like anybody else with an easement, when we cross that easement, it's an agreement to cross. Very rarely can somebody say, you cannot cross my easement without very strict rights within their easement with that landowner. So you can cross somebody else's easement as long as you don't disrupt the rightful enjoyment or quiet enjoyment, whatever that standard is. As long as you're not impairing that enjoyment of that easement, you can cross that agreement, that easement. And so what we do with the rural water districts, because they're easement holders, they're not landowners, that we get an agreement to cross their easement with predetermined terms to mitigate or minimize impacts to both the easement holder as well as the physical asset in the ground.
Thank you. With respect to drainage districts, I think you gave some testimony earlier about Buena Vista County's drainage district, right?
Yes, sir.
Actually, there's multiple drainage districts in a county, to be clear, right?
That's correct.
I think you mentioned with respect to Iowa, and we've covered this territory, there's been 3 counties that Dakota Access has achieved some sort of understanding with. Is that right?
That's correct.
Do you know how many other counties need to be dealt with in this regard?
I do not. I thought it was 13. It may be less. It may be 7. I'm not really sure. I used to know, but.
Okay. Let's just assume that we have a certain county board of supervisors in the future who refuses to give an easement to Dakota Access LLC, okay?
Yes.
Would that county board of supervisors have received notice of any eminent domain proceedings over those drainage district resources?
Probably not. And again, we're kind of treading on some very legal issues, but from my experience, I'll tell you that, again, it's an easement that's on top of somebody's land. Sometimes the drainage districts actually own the easement, or they own the property where the main drain tile may be placed. Most of the time they don't, though. They're on private property. So it becomes a term of the easement for crossing. And I guess in my experience, the majority of the time, I don't know that they can not grant an easement, and I don't think there's that many laws that can prevent them from doing that. And if there were, I guess we would have to litigate through whatever that situation was.
And I understand there was some litigation in Calhoun County on this subject. Do I have that right?
There was the filing of, but we were able to resolve.
So the court never did actually decide the issue?
They did not.
Right. So it's an unresolved issue?
Well, we don't think so.
Correct. But to the court has not addressed the issue.
I can't speak for the court. In our opinion, we don't think there's any discrepancy in what I just said.
But to be clear, Dakota Access has not submitted before this board a proposed taking by eminent domain for any such drainage districts, correct?
No, because they're not property owners that we cross.
I was going to go back to MH4, and there is a reference, I think, to the U.S. Fish and Wildlife Service there. Over in the status section on the right-hand side, right there, it says anticipate Section 7 consultation to be complete by January 2016, correct?
Yes, sir.
Okay. Is this status still the same?
Yes, it is.
Okay. Were you here when the OCA witness, I think his name is Thomas, was questioned by Chair Lady Huser about these issues of minimization and mitigation measures concerning fish and wildlife?
I was here for a couple of their witnesses. I just do not recall their exact names.
Okay. But the substance of it had to do with the minimization and mitigation measures that would need to be developed with respect to fish and game concerning this permit. Would you agree with that?
Yes.
And I think that Mr. Huser was looking for proof of these efforts or documentation of that nature. Has Dakota Access provided that documentation?
No, not that I'm aware of.
I'm going to go to the agricultural impact mitigation plan now. Thank you. And what I'm going to focus on with my next line of questions has to do the time frames that have to do with this plan. Okay?
Sure.
As I understand it, there was the board initially indicated that it would try to rule in this matter in late December, early January on this particular subject. You would agree with that, right?
I believe that's what was published.
And I think recently there's been an indication, at least press release wise, that perhaps it might be a little later than that.
We hope not.
But, and I have seen the press releases in that regard. But in any event.
Can I say that again? We hope not.
I want to go to section 1 of the AIMP. And we'll go to the last paragraph here, okay? It says there that, starting with the words after the board. See that?
Yes.
After the board has accepted the plan, but prior to construction, Dakota Access, DAPL, will provide copies of the plan to all landowners of property that will be disturbed by the construction and to the county board of supervisors and the county engineer of each affected county, okay?
Yes, sir.
So then, would I then have it right that once this board adopts the final plan, that there's a period of time where that notification process has to occur, correct?
Yes.
And Dakota Access under this plan is the one that is to provide that plan.
Yes.
So how long would it take to make that happen for Dakota Access?
The notices to redistribute the final plan as approved by the IUB?
Yes, to these places.
2 weeks.
2 weeks, okay. Now, each of these parties needs some time to digest this approved plan. Would you agree with that?
Yes.
And wouldn't all the counties need to have in place a designated county inspector to implement this plan?
Well, I think they have the statutory requirement to. I think they have the ability to do it or not do it. It's up to them as the county engineer or division.
That's right. So how long do you think the county would be allowed to designate a county inspector to implement this plan?
I couldn't tell you.
Okay. Now, as I understand it, Iowa law, it has the county inspector as working for the county, right?
Yes.
In this process.
Yes.
Now, that is to be distinguished from, we're going to get into the name of a company, I&S Group, okay?
Yes.
Now, they're a private engineering company that has offices in Iowa, correct?
Yes.
Okay. So that company has worked for Dakota Access directly, as I understand it, concerning locating drainage district resources affected by the pipeline. Would that be a correct statement?
That is correct.
Okay. But I'm not going to talk about that project, okay?
Okay.
As I understand it, the Iowa law has this county inspector who may be I&S Group, in fact, that could work for the county, correct?
Yes.
Now, the law also in Iowa calls for the reasonable expenses incurred by that inspector to be reimbursed by Dakota Access. Do I have that right?
Yes, you do.
Okay. Has Dakota Access worked with all the counties to make sure that Dakota Access has an agreement in place with each county as to these reimbursement of expenses?
I don't know that we have an agreement, signed agreement in place with each one, but by statute, they invoice us for their reasonable costs. we reimburse them. I don't know that it needs to be very explanatory or complicated.
Okay.
If it's a legitimate expense related to the inspection, then we pay for it.
So that's just there's a thing. Is it if it's a legitimate expense? Wanted to follow up on that phrase. What would be an illegitimate expense?
Well, if their office clerk decided to buy a 12-pack of Coke for the office that wasn't in support of the project, I would consider that to be an illegitimate expense.
All right. Would fielding any and all inquiries from landowners, no matter how ridiculous they might be, would those be considered legitimate expenses?
Sure.
Okay. Now, we've already talked about this process now about after the plan is approved by the board and we get this plan out to these affected parties. How much time is Dakota Access, I'm going to phrase that question. Let's say that the board rules February 1st against Dakota Access's desires, okay?
Sure.
How much time would you suggest would be a reasonable time to allow pass before construction can begin to allow these preliminary matters?
Well, as I explained to Mr. Taylor earlier today, the start of construction is going to be where we can physically start construction and move or progress at a rate where we're not having stops and starts, because simply it's just too inefficient to do it that way. It's detrimental to the landowner. It exposes the environment to extended periods of exposure for disturbance and everything else. And simply, I think one of the things as we're talking through this that's kind of been going through my mind, we've closed 75% of land in Iowa. 75%. That's not the minority, that's the majority. By far the majority. So 75% of the people in Iowa have already agreed to this plan, have accepted it, or we've negotiated at some level of modifications. So when the board, again, not putting words in their mouth, but when they approve our project, the majority of the people have already agreed to some type of term for the ag mitigation plan. And whatever agreements that we have in place that may predate the board's acceptance of the plan, if the board elects to change something in the plan, then we will make every landowner that's already signed an easement with us aware of what that change was, and it's their prerogative and their direction based upon the Iowa statute that they can accept what the board says or doesn't say. That's up to them. And so the remaining 24.8% that have not signed a voluntary easement, they have the opportunity right now to negotiate in good faith. When people don't want to come out and talk to us about an easement, there's nothing we can do. But I can give you my personal commitment.
Your Honor, I think this is going off of the scope of my question, and it's getting very narrative. I'd ask to have the witness cease his answer.
Your Honor, I think Mr. Murray has been given a lot of leeway in asking some very narrative questions and doing a fair amount of testifying. I think that, if he's going to get the leeway to ask broad questions, then the witness ought to get some leeway to answer in the way that he sees as fit.
Mr. Murray?
This is not direct testimony, it's cross-examination, and I'm just simply effecting a good cross-examination that has not been objected to. I think the answer has been quite long. I'm just asking that I be allowed to interrupt the witness. I think he's been non-responsive here at the end. My question, by the way, had to do with just simply what time frame, if it was February 1st, what time frame should we wait until, construction begin? And the witness never even answered that question.
Your Honor, I think the witness was explaining that in these cases where there's voluntary easements, it should be no surprise to the landowner that we would come in and start. We already have terms with them. And the premise of the question is there needs to be some delay. And I think Mr. Mahmoud was talking about that situation may be different in a voluntary easement situation than an eminent domain situation, which I think is a legitimate answer.
Mr. Mahmoud,
Yes, ma'am.
you are a very eloquent speaker, and you've provided the board with information that we found helpful, but we would agree that you did not answer the original question that was presented by Mr. Murray. And we would ask that, although some of the information is helpful, that you stick to responding to the direct question.
Okay, I'll try. I don't know the reasonable time because I don't know the circumstance, and I'm going to use your mother as an example, where we do not have an agreement even started. That I think it probably is more beneficial for you and your family member to have a little bit more time to review the final package as opposed to somebody with a voluntary easement. Now, what that reasonable time is probably a couple weeks to 3 weeks to read a document that you have personally reviewed in the past and can help with your mom reviewing that.
Fair enough. I think that covers it.
Okay.
Statewide, that would apply then, a 2 to 3 week period, right?
In case there's changes that the board would apply to what's different than what's been proposed.
There you go. So now I want to turn to the AIMP section 6.11 concerning future drain tile. Okay? All right. Now, in here, I'm going to start with the words, I hope I find it. Oh, yeah, after the prefatory language, it has at locations. You see that? Well, I'll just start at the very beginning.
I see it.
Okay.
Yeah.
At locations where the proposed installation of future drain tile and soil conservation practices and structures are made known to Dakota DAPL in writing prior to securing the easement on the property and have been defined by a qualified technician, the pipeline will be installed at a depth that will permit proper clearance between the pipeline and the proposed tile installation. Okay. What do you believe the phrase, quote, securing the easement on the property, end quote, means?
Well, it's so the structures are made known to DAPL in writing prior to securing the easement on the property. So that what we're saying there is during the negotiations, if somebody has tiles that are proposed to be installed on their property, that as long as they notify us of those ahead of the easement, then we can incorporate those into our design packages so we can design the pipeline properly to provide clearance for the future installation.
I see. So let me ask it a different way. Back to my example that I don't think you liked, but I'm going to use it anyway.
Okay.
The Iowa Utilities Board in my example would rule on February 1st in that example. Would you read that language there, quote, securing the easement on the property, end quote? Would that be February 1st?
No. It could be for voluntary easements whenever they were signed.
Oh, I'm talking about the Exhibit H, eminent domain parcels.
So when the IUB on January 1st rules, just to clarify.
Sure.
17.
When they clarify or vote, that's the starting point where they would have granted us the rights of eminent domains on those individual parcels. We still then have to petition to a court to exercise those rights of eminent domain. And that point at which time that documentation would need to be provided would be, in the example of an Exhibit H, would be at such time that the court would grant us the right of entry, which would also coincide with the right of eminent domain.
Okay, so that court, would that be the county? I think it's referred to as sometimes the County Compensation Commission, or would you know?
You know, I know each state has different names for them. I think that's right.
Okay, but you don't have any personal knowledge as to the language there,
No,
right?
sir, I do not.
But let's just to get back to that testimony. After the Iowa Utilities Board rules, and let's just use Martha Murray for example, since we're picking on Mom. And let's just say the board here grants their ruling on January 1st, okay? Then, just to clarify the process, unless Mom signs something that actually gives the right to Dakota Access still needs to go to a separate entity after Iowa Utilities Board, correct?
Yes, sir, that's correct.
That's what you were referring to earlier, right?
Yes, that is correct.
And so that entity, as you said, is the entity you believe that would grant the entry rights, correct?
I believe that's correct.
Okay. And so would that then, as this plan is put together, is that what Dakota Access means the later time through that other entity? Would that be what is meant by securing the easement on the property for those parcels that never give any, I'll finish my thought, any voluntary permission?
Objection, Your Honor. A, it calls for a legal conclusion, but the way he's wording it, what did Dakota Access mean? Again, and this is a repeated objection, where we're spending time reading a document into the record. I would represent to the board that the language that is being debated here is verbatim from Chapter 9. It's not that Dakota Access had any particular intent. It's what the board's rules say, literally verbatim.
But Mr. Dublinsky, the witness has testified that he believes, or at least this is what I heard, that he believes we have the ability to look at that and make modifications to the same. If we don't have testimony, how does that information become part of the record?
Well, I don't understand this discussion to be about modifications. It's about what was intended by the language that's currently in there. And my point is that it's not a matter of Dakota Access's intent with that language. That is the language of Chapter 9, and actually the entire AIMP tracks as it is required to.
And Mr. Dublinsky, I'm going to stop you, and I will consult with the other board members. But one of the things that we are learning from the testimony are those things that are in our chapter of the rules and what the significance of some wording is. I find this highly beneficial, and I think Mr. Mahmoud is the appropriate person, but because I always want to ensure that I have more than one vote, my own, I will consult with them. Mr. Murray, do you have anything to say?
Heck no.
the witness shall answer the question to the extent he has knowledge. Mr. Murray, please stop reading from the document and just state your question to the witness.
Yeah, I'm going to try to restate the question. I'm lost with what I had, unless I can have the court reporter read it.
I know the court reporter would be happy to read the question back.
Question, okay. And so would that then, as this plan is put together, is that what Dakota Access means? The later time, through that other entity, would that be what is meant by securing the easement on the property for those parcels that never give any, I'll finish my thought, any voluntary permission?
Do you want to restate that?
Absolutely.
Thank you.
John,
I
can answer this.
I don't have a question out there for you, Joey.
Okay.
Sorry, Mr. Mahmoud. The example on the floor is we have a landowner, the rebel Martha Murray, who is not going to sign an easement or to sign anything after the Iowa Utilities Board grants its ruling, by example, okay?
Yes, sir.
And in order to legally proceed, Dakota Access then has to take it to another entity, okay?
Yes, sir.
There's something that happens later on, okay? In that scenario, would you agree that the phrase, quote, securing the easement on the property, end quote, that phrase, shouldn't that be further supplemented to explain exactly what is meant by that phrase?
What I believe this says, and what I'll give you my commitment on, which I think is more important, is that we will comply with this, and as long as we receive that drainage tile plan, future, prior to that easement granted, however granted, eminent domain, voluntary, doesn't matter, that we will accept those plans up until the point where we have that easement. So it doesn't matter what the legal remedy here is. I give you my commitment that if your mother wants to wait until January 29th and we get our permit on the 30th, that I'll accept it when the court gives us right of entry on March 1st.
Oh, okay, so you gave an example there where this board, using the February 1st IUB ruling, and I think you hypothetically said that the condemnation
It'll take a month.
I'm not. It would take a month. Let's just say at the county level. So when would the deadline be to submit the plan, the tile plan? March 1st or February 1st?
March 1st.
March 1st.
Yes.
And just be clear, when you say March 1st, that's the day upon which that other entity, and I'm going to suggest a county entity, issues its ruling concerning condemnation. Would you agree with that, generally speaking?
Yes, I do.
Okay. To be clear, it's not any future appeal to a district court, but rather the time when that entity at the county level initially makes its determination, that board, right?
Yes.
So would you then, restating the question, would you agree that this phrase in this, I'm going to back up and have one more preliminary question and strike that. You understand that this AIMP is meant to be interpreted by the county inspectors, landowners, and Dakota Access in the field, right?
Yes.
It's not by you or by me, by Mr. Dublinsky. It's meant to be interpreted by those guys out there that are engineers and that sort of thing, right?
Yes, sir.
So given that, would you agree that this phrase, quote, securing the easement on the property, could be further supplemented to clarify what you just said?
Well, I personally don't think it has to. I control all of that. You know, that in my position over this project, I am in charge of it all. So ultimately, before an act of condemnation or a court case or something like that is prosecuted on our part, I absolutely 100% make that decision, and nobody else does. So I can say it doesn't matter if they're an engineer or a right-of-way agent or a lawyer. If we're taking that step and this commitment is being made, I 100% can sit here and say that I'll make sure that that is enforced properly.
Okay. I'm going to skip to another section of the AIMP and go there, okay?
Okay.
Let's go to section 4 again. And it's the fourth line down, kind of in the right middle part of that first paragraph. We can put the hand there to the left now to the right. There you are. Okay, that's where I'm at. The primary contact person for the landowner throughout. No, you know what? I have to ask you another thing. We'll withdraw that. We've got to go to the third line down on the far left-hand side, okay? Okay, that sentence there. 2 weeks prior to construction, comma, landowner will be given. Now, would you agree with me that that sentence is not proper grammar?
I would, 100%.
What would a landowner need to be given 2 weeks prior to construction?
What it's trying to articulate, and we can get this corrected, is trying to articulate with 2 weeks prior to construction, the landowner will be given the contact information.
Would the landowner be given anything else, such as plans or technical drawings of the pipeline that's proposed?
I'm sorry to interrupt you. Did you get all that? Okay, I apologize. What this paragraph, section 4, is talking about is just the contact information.
Okay.
So specifically here, we're saying 2 weeks prior to construction, because we do have attrition as a company with our contract workforce. People leave, nothing we can do about it. So to ensure that the most accurate point of contact for the landowner is present or known to the landowner, 2 weeks prior to construction, we will provide that update. It may follow with other plans or information, but at a minimum, it will include the contact information.
And as I understand it, under this AIMP, that's the only notice that is required to be given to the landowner, correct?
I actually believe that's right. I don't remember another one.
I didn't either. So now let's go over to the fourth line on the right-hand side, the primary contact person. The primary contact person for the landowner throughout construction for easement issues is the geographic area representative. Who is the geographic area representative?
That would be the person that's supposed to have been articulated in the previous sentence.
Would that be I've heard one guy refer to a landman.
It could be, we call them construction right-of-way agents.
Okay, so were you here for that testimony?
I don't recall that, but
all right.
I don't
But
remember.
I'm sorry to cut you off there. I'm trying to go a little quicker. And I'm going to stop. I'm not going to do that. So this is a representative for Dakota Access, correct?
Yes.
So where in here does the landowner receive the information about the contact information for the county inspector?
I don't know. I would assume that the county does their mail out. Or if they ask us to do it, we'll do it. I mean, it's not a big deal to make sure everyone's aware of those individuals' contact information, but ultimately it's the county's obligation.
So if we're dealing with landowners who are proposing future tile plans, all right? Let's go down to section 6.11 again. It says here at I'm not going to reread that again, but this future tile plan is to be provided to Dakota Access, it looks like, in this section, right?
Yes.
shouldn't the county inspector be involved in that process?
No, I don't think the county inspector has any rights or abilities or control or influence or any of those buzzwords to affect somebody's personal future tile plans on their property. I think that's above and beyond the scope of what their involvement is. Their involvement is to ensure that we comply with the intent of this plan and construction and restoration for the crossing of those agricultural lands, not to bless or approve or whatever other adjectives I can come up with of the future drainage plans.
Okay, I think I understand you then. These future tile plans, which we've talked about the time frame to provide these tile plans, need to be provided by, I'm going to pick on Mom, need to be bypassing the county inspector and given to our right-of-way agent for Dakota Access, right?
Yes.
And then it is his sole discretion to figure out whether that tile plan is going to be accommodated by Dakota Access. Would that be correct?
Well, I mean, I don't know whose sole discretion you're referring to. If you're referring to mine, sure. And it is my discretion, and we have given to everybody from day one, going back to the original public meetings, we have always represented, if everybody will communicate with us, and again, the vast majority of people have, I'll just state it, 75.2% have either given us these plans or whatever information. So I think it makes a lot of sense that if the landowner has a future tile plan, it's to their benefit to disclose it to us so we can accommodate their request, because we're more than willing to. It's not a we may, it's we will.
In the third sentence there of this section, it says, after the famous words, securing the easement on the property, I'm going to go with the and have been defined by a qualified technician. I don't see that phrased qualified technician defined anywhere in the AIMP. Is it anywhere defined?
I would have to look through the definition section and look up the statute to see, where they define that. But my guess is either a drain tile engineer, planner, some type of professional that works with drain tiles. So the intent of this, and I think I understand where you're going, the intent of this is that it's a legitimate drain tile plan. So that's to protect the landowner as well as the company, that anybody can draw a drain tile plan on a piece of paper that may or may not work. So the intent of this section and the intent of the code here is that it's a legitimate drain tile plan that's been somewhat engineered or at least surveyed to ensure that it works. So the company is not expending a bunch of resources and effort for something that legitimately won't work or ever happen. So it's kind of a mutual negotiation between the two to disclose real information to make accommodations for the future.
I want to go now to section 5, those definitions that you just referred to.
Mr. Murray,
Yes?
is this a good time for a break?
Oh, yes.
All right, I know Ms. Agramante may not want me to have breaks with you to get you through it, but we're going to take a break. 10 minutes.
Thank you.
Murray, before we get back to you, we have some housekeeping issues to address. First of all, we will be providing you with an updated witness list sometime later today. We will be breaking at between 5 and 5:30. There will be a 45-minute break. We will be back in by 6, and we're going to go till 7:45, 8 o'clock. I do not anticipate that we will go into confidential tonight. I do anticipate, Mr. Mahmoud, that you will be the individual that we will rotate in and out with tomorrow, because
Your Honor, Mr. Mahmoud is not available tomorrow. He is on Thursday.
well, that's okay. Okay, we have to work on the witness list then, but we're not going to get done with him tonight. I'm pushing it for 7:30. Mr. Long, do you have another suggestion?
I just hoped we could get through them tonight, but I
So
respect your
realistically,
determination.
thank you. We will work on the witness schedule for tomorrow and Thursday based on that information, and I do recollect that I knew that, I just had forgotten. We will break at 5:15, 5:15. We will come back in before 6. We will go till 7:30, 7:45. Mr. Taylor and Mr. Dublinsky. Mr. Dorshak is scheduled to testify on December 2nd, tomorrow.
Yes.
It's my understanding that we have a correction to his testimony that has been filed in the EFS system as of today's date. It is also my understanding that there will be an objection to that filing. So it is the board's intent to first hear the objection to make sure that we have that on the record, and then I will make a ruling. So Mr. Dublinsky, would you please state your objection?
I will, Your Honor, and we learned about that late this morning, being filed. I don't know that I would refer to it as a correction. In candor, we haven't had a lot of time to look at it because obviously we've been in the hearing at a brief skim. It appears to be essentially additional testimony. The way that the process works is that the applicant goes last on testimony. It would appear to be an inappropriate effort at supplemental direct or surrebuttal. Much of it appears to be double hearsay at best. We aren't going to have any time to prepare on it until at least after 7:30, 8 o'clock tonight. A, we think it's inappropriate and should be stricken. B, in the alternative, if it's not, Ms. Howard should have the opportunity to go last and file supplemental written testimony, although I want to emphasize we would highly oppose anything that drags the hearing out by bringing witnesses back subsequent times. At the very least, we think Mr. Dorshak should be pushed back a day so that we have time, unless of course the board strikes it, to study it, react to it. But because it was filed out of time, there was no opportunity to do any discovery, to do any research, to have it incorporated into what Ms. Howard's reply testimony was or her testimony on the stand. Highly prejudicial to file it at this point, and we would move to strike on that basis.
Mr. Taylor.
Thank you. It was our intent that this would be simply as any other witness being asked to correct or amend their testimony based on either errors in the testimony or supplemental information that has come into the witness's possession since the written testimony was filed. We felt it was more than appropriate to do this as soon as we had the information so that everybody would be aware of it. I don't believe it's supplemental testimony. I think it just updates and clarifies the previously filed testimony.
We will hold off ruling on this until we have the testimony. However, we would like to schedule in the meantime, Mr. Dorshak for a date certain, and I would like to know at this moment what day that should be.
Thursday will work. We just would ask for a 1-day delay on that.
Okay. Then as it relates to Ms. Howard, our expectation is that you just bring her back on the stand and ask her the questions that you wish to, and it needs to be only related to this document. You be prepared for that, should that be the ruling of the board.
We can have whichever is appropriate and works in the board schedule as between Ms. Howard or Mr. Mahmoud to address the limited scope of that if the board decides to allow it to remain in the record.
For my information, are Mr. Mahmoud or Ms. Howard available both on Thursday and Monday?
7. My understanding is that they are both available on Monday the 7th.
Okay, and I just heard him say, Mr. Mahmoud say he's back tomorrow. Is that true?
He believes he'll be back around 2 o'clock.
Well, we'll be here. So,
It really means like 6.
that's helpful.
Yeah, we will tell him to be here as soon as possible, and once you see him, he will know that he is
Available.
amenable. Yeah.
All right. Okay. Mr. Taylor, do you have any questions?
I will see if Mr. Dorschach is available on Thursday.
Is it Dorschach or Shuck?
Dorschach,
Shuck.
yes.
Okay. You'll find out if he's available. Do you not believe he's available?
I don't know for sure. We were planning on tomorrow, of course. But I will find out as soon as I can.
Hey, could you find out as quickly as possible? I'd appreciate that. All right. Mr. Mahmoud?
Your Honor.
Mr. Sandgren?
In an effort to clean up Thursday, I've one witness that Mr. Dublinsky has already indicated he would waive cross-examination of. It's Rhiannon Hansen. I'd move that her testimony be accepted as is, unless there's cross-examination or questioning.
Are there any, and is Hansen the one that has waived under it?
No, it's Hanson. It's the first one listed on December 3.
I'm on the wrong. What's the date of the witness list that you have, Mr. Sandgren?
I'm sorry, I was looking at the 24th list.
Okay,
The second.
but I just asked on that one, and he said it wasn't that Hanson, and I don't see another Hanson.
Yeah, she doesn't appear on this list.
I don't remember. Go off the record for a minute.
Thank you. Just another housekeeping point of order. I'm going to be absent from the hearing tomorrow morning, and I know that the board requested whether any of the parties would potentially be waiving cross-examination for some of the witnesses. Since I won't be here tomorrow morning, I would just like to state that my clients will follow the lead of Dakota Access on that question.
Thank you. Again, just for the information of the parties, it's your responsibility to make sure that if you have a witness that I don't have on the list, that you make the board aware of that.
And Your Honor, while we're on the subject, again, I would reiterate, we have an outstanding offer to waive Sierra witnesses Brorby, Watson, and no Bakken witness Magram.
Thank you.
Your Honor, on the subject of waiver of cross-examination, we have continued to work with our witness, Dawn Carlson, who we had previously indicated would not be available because of her work schedule. And she might be available next week, but if other parties don't have cross-examination for her, we would propose to offer her testimony.
Do any of the other parties have any questions that they were going to ask of Ms. Carlson? Seeing none, if there's no objection, I see no.
Madam Chair, would it be acceptable to give you an answer tomorrow morning at 8:30?
I've allowed other parties that opportunity, so yes.
Thank you.
Madam Chair, Mr. Dubrinsky just said that they would waive cross on our witnesses Brorby, Watson, and Magrum. Can you ask if there's anybody else who wants to cross-examine them? If not, I'll call them off.
And we'll admit that testimony. Is there any objection to admitting the testimony of Sierra Club witness Brobery, Sierra Club witness Watson, and the third one was?
I know Bakken here, witness Magrum.
No Bakken here, Magrum.
Although Mr. Magrum's going to be here, so that's fine.
Okay,
We can just go with him.
we'll just, Brobery and Watson.
Yeah.
Is there any objection?
No objection.
Mr. Piazza? Mr. Long?
No
Mr.
objection.
Dublinsky? Seeing no objection, the testimony of Brobery and Watson are admitted. Do we have any other housekeeping matters?
Madam Chair, just a quick status of documents that are in production. One would be the HCA USA maps with valve overlays, when we would see those.
Mr. Dublinsky?
Your Honor, we've had a couple of different ways that has been requested, and we continue to have concerns that that is normally PHMSA type information that would not be generally available. Even Mr. Murray this morning seemed to express concern about valves and attacks on valves. Part of the advantage of the board getting information from PHMSA is that it then isn't automatically distributed broadly. OCA had requested that we had asked if we could make that, and we had talked to them about it. I don't recall that we'd actually been asked to file that or had committed to file that. Ms. Agramani may remind me differently, but I guess we still have some concern about putting valves and HCAs on a single map and distributing it to anyone other than the board and OCA, government agencies. Obviously, if the board orders us to, we will find a way to do that, but my understanding was that that was not something that had been ordered, and we do have a significant amount of concern about that. And they're not maps we keep in the ordinary course. It's not the easiest thing to create.
Mr. Zakrasik, can you refresh my memory? Did I request that that be provided, or was that just a discussion with it may have been Mr. Sturzma, or I recall talking about it. I can't, give me some additional information.
My recall may not be precise, but I remember Mr. Frey being on the witness stand, being questioned, and it came up, could we have identification of the location of those valves on a map that shows the HCAs and USAs? And the answer was, yes, we can provide that.
Your Honor, if I might interject, Ron Pauly.
Thank you, Mr. Pauly. Can you help the
Yes,
board out here?
Yes, ma'am. I believe that it was during my cross-examination of Mr. Fry, I asked the questions, the question of whether it's possible to show the HCAs and those HCAs, the location of the valves, so we can determine, so the board and the parties can determine whether or not those HCAs are adequately isolated. And my recollection of his responses that that's possible. I don't believe the details of precisely how that map or document was to be provided, but my understanding and recollection is that it would be provided. I have no objection, particularly to having a separate map that can be overlaid with the existing maps if they're to the same dimensions, that shows all that information, but on different pieces of paper. That's fine if that would help allay Mr. Dublinsky's concerns.
Your Honor, that is consistent with my recollection of the process. I don't know that there was ever an actual ask from the board to provide that. And I would, again, I mean, the isolation of the HCA's under PHMSA rules, which is where the requirement comes from, would be audited by PHMSA. All due respect to the board, that isn't necessarily within the board's jurisdiction. What we can say, what we have said, there's a valve every, on average, 5.25 miles. There's 66 of them under the rules. We have to locate them in a way to isolate the HCA's. Obviously, there are many more than that. If the board really wants to know and thinks it has a need to know exactly where, I think we would be willing to share that with the board. I just have some real qualms, and Mr. Murray's questioning this morning confirms why, of distributing that map very widely. And again, it's not just something we have a file of. We have the HCA maps. We know locationally where the valves are, but they're not necessarily on a map. Doing these overlay maps is not an easy task. These, sort of GIS maps take a long time to create. So just be aware it's not an easy ask.
Your Honor, I have some input on the need for the board to have that.
Mr. Murray?
The need for the board to have that was elaborated in Mr. Sturzma's testimony last night concerning Dakota Access, and as he characterized it, the generic request for valves under all the Exhibit H filings, and how that directly affects the board's determination as to necessity for all 316 tracts. So I'm going to have later questioning here today with Mr. Mahmoud about that.
And Your Honor, we would give it to the board and even OCA, but questioning whether or not we need to have some flexibility at this stage for the potential for future valve locations is wholly unrelated to how the HCA's are currently isolated.
It's obvious to me that, I have like 4 questions back to you, Mr. Dublinsky, on this, so that tells me that I need to tell you we're going to take it under advisement at this point and get back to you. But I will tell you that from my perspective, how do the landowners find out about that information if it's going to be on their property if they've entered a generic easement? So I'll get back to you, Mr. Pauly, and to the rest of the parties, Mr. Dublinsky, after I've had a chance to take it up with council.
Madam Chair,
Mr. Taylor?
Dr. Dorshuk can be here by 10 o'clock Thursday morning.
Will that give you sufficient time to prepare?
It will, Your Honor.
Your Honor, Matt McDermott.
Okay, who said it?
Matt McDermott over here. Hi.
Thank you, Mr. McDermott.
One more witness issue. Mr. Kandrak is listed on today's list. This was a witness that we've worked with Ms. Sorensen, and the plan there, she has provided several written questions that we're going to present to the witness and have completed in writing, and then we will file those, and then he will not be appearing here.
Ms. Sorensen?
That's fine. That's what I wanted.
And refresh my memory on this one. Did we admit this test? Do we need to admit the testimony then at this point?
We certainly can, and then we'll supplement with those 3 extra questions.
Do you have any objection to that, Ms. Sorensen?
No, I do not.
All right. The testimony of Kandarak with 60-plus associates is admitted.
Thank you.
Will that be filed, Madam Chair, so the rest of us have access?
It is already filed. The answers will be filed once they get them
Right,
done.
that's what I'm talking about. Yeah.
Yeah, yes. It'll be filed just like any other testimony. Is there anything else?
Madam Chair, there were two other documents, Mr. Zakrasik. The notes from the landowner contacts.
Your Honor,
We already ruled on that, and they were going to
those were filed today in EFS, and obviously being here, I haven't been able to do it, but tonight I will email those to all of the parties that have signed the confidentiality agreement.
And what is the third document, Mr. Zakrasik?
Pumping station capabilities. This was another item that came up with Mr. Fry.
I don't think there was a document associated with that. Yeah.
I think one of the things, Mr. Dublinsky, that I would like to state is because we have some individuals that are pro se litigants, and a response from a question that is simply, well, if you need that, we can provide it. And I think that's where the pumping station questions may have come from. We just need to be cognizant that of that when it's occurring.
Right. I think what happened was when Mr. Fry was on the stand, the question came up and he said, I don't know right now, but that's a number that I could get. I am happy to talk off the record, not right now necessarily, but with Mr. Zakrasik, we would be curious, again, these operational things, what the need is to know that information and try and talk to him about that. But I don't think there was ever intended to be a document on that.
And that's was the board's conversation a moment ago. I would ask that you have that off the record conversation, and Mr. Zakrasik, if you do not receive, or Mr. Dublinsky, if you're not comfortable with that conversation, come back to the board.
Thank you, Madam Chair.
All right. Mr. Pauly, do you have anything? Okay, good. Mr. Murray, are you ready?
Yes, always have been. Mr. Mahmoud, I'm going to go to section 5, and we were about ready to go down to a definition, which is the point of proper notice to the county inspector on the next page. If I could have the tech go down there. Have you been present for the prior testimony concerning this definition, generally speaking?
No, I have not.
Okay. Darn it. Are you familiar with whether this definition is utilized anywhere else in the AIMP?
I would have to look.
Okay. I'm interested in knowing about the language in the definition about DAPL, and it jumps down there after the prefatory language and towards the and. It says, and will provide at least 24 hours written notice before trenching, permanent tile repair, or backfilling. We'll just focus on those words right there. Okay?
Yep, sure.
Would it be too hard for Dakota Access to also give written notice to landowners?
So the 24-hour notice is to the county inspector, and so that's a tough question. You know, as you can imagine, 1,274 landowners out there. 75.2% have agreed to what we're saying. None of them have asked for something like a 24-hour notice. A few have asked for different notice provisions, which we're happy to accommodate. Providing 24-hour notice to everybody is just simply detrimental to the progression of the project, where it's detrimental to the landowner. And of course, it impacts us, but it impacts everybody. The longer it takes to build this pipe, the increased probability of impacts rises dramatically. The longer that dirt's exposed, the more it's exposed to erosion potential. The more the ditch is open, the more incidents of safety concerns come about. All of those things rise when you leave the construction in an open state. So it really is a negative to put onerous conditions on top of a notification. The landowner is going to be out there watching, and I've done this for a long time. I've built thousands and thousands of miles, and I can tell you, without a doubt, we do not ever put these type of conditions inside of our agreements. We may have an off-the-wall 24-hour notice for a particular crossing next to a house, but a generic term in an easement or in a board condition is just simply unheard of. It would be very detrimental to the project and to the environment, in my opinion.
So if I have your testimony correct, you believe that giving an additional notice to landowners, in addition to this written notice to the county inspector, would be an onerous requirement. Is that your testimony?
I do believe that, and I think it's unnecessary because they're already getting 2 weeks' notice of construction.
I remember some testimony given by Mr. Fry. It wasn't my questioning, though. It was Mr. Wagner's questioning. And Mr. Wagner was asking him about how landowners, generally speaking, could go out on the site when construction is happening. And Mr. Fry talked about safety concerns.
Mm-hmm.
Now, would you agree there are some safety concerns with respect to the rig, the equipment that's rolling up and down the construction site?
Yeah, it's a horrible idea to have the untrained public within a construction zone. I think you know that.
Yeah.
I think everybody knows that.
So let me then jump to the next thing. Mr. Fry testified that once the crew is done for the day, he said that landowner can go out in the land when they're not operating it, presumably at night. Would you agree that that's something that landowners can do?
Well, we can't stop them. We certainly discourage it. And we do typically have security patrol on our projects that we can't catch everybody, but we strongly discourage that because of the safety concerns.
Okay, so I'm just being clear. If there's no construction that's active on a parcel, may a landowner go out and look over the trench?
A landowner can do anything they want to do. It's their property. We're a guest on their land. So in the absence of good, and I would say common sense, to stay away from a dangerous situation, I would recommend that landowners simply just don't go next to the ditch so they don't fall in and hurt themselves.
And I so much agree with that. So Mr. Fry suggested that a landowner can go out on his own and perhaps expose himself to peril when in fact he could go out there accompanied by a county inspector in a safe manner. Wouldn't you agree that? I'm getting a little argumentative here, I apologize, but wouldn't that be a good way to go?
No, I don't think so.
Well, I tried. Winter conditions. You mentioned that Dakota Access wants to avoid that because of the mixing of topsoil and subsoil, is that right?
That's the primary concern, yes, sir.
And I think there's been other testimony given that there can be some clumping that can happen with the freeze going down into the soil, correct?
Yes.
Is there any sort of rules in the AIMP that refer to this sort of condition of clumping that would stop that sort of digging?
No.
And I think you gave some interesting testimony from Mr. Taylor's cross. I think here's what you said. You said once hypothetically, we reach a point, perhaps October 1st or October 15, and we know we are not going to be complete by the winter. You remember that answer you gave to him?
Roughly, yes.
Okay. Then you said, well, we're going to have to put together some rules, right? For winter construction, is that right?
For completion of construction, yes.
Okay, so wouldn't those rules be properly put in an AIMP?
Not necessarily. In general terms, sure. But again, as you, the landowner, do you want a general set of terms for how we are generically going to protect your land? Or would you, as a landowner, and I think everybody wants this, to know exactly what we're going to do because for whatever reason, we're not on schedule? We think it's a better way to prosecute the construction to ensure that the land is the most protected. So developing an arbitrary plan, it's simply that, it's arbitrary. Why not take the time to identify the particular circumstance and then develop a plan that meets the site-specific conditions? Because it's going to be different up and down the right-of-way. It may be different in the southern half versus the central versus the northern, just like when we got all the snow the other day. It snowed from Ames north. Well, our construction plan will deal with those particular nuances between the different geographic regions of Iowa, and based upon the timing of construction, we may be almost done where it may be a temporary seed mix being placed on a certain section of right-of-way versus a rough grade in other portions of the right-of-way. As a landowner, which I do own land, but as a landowner in Iowa, I would be interested in knowing exactly what Dakota Access is going to do on my property.
I would agree, and I was wondering about that with respect to the stockpiling of topsoil in section 6.2. Under section 6.2, if I'm a landowner, and I'm not, but if I were to, and that's irrelevant. When a landowner receives the AIMP, the AIMP has no mention as to clumping or winter conditions affecting topsoil separation or replacement, right?
That's correct.
Okay. So would Dakota Access be agreeable to adding some provisions in there about that?
We will, once we are faced with the condition of not being able to complete construction before the winter.
And would that then have to necessarily come back to this board for this board to approve it in the fall?
Well, I think the board would certainly be given the opportunity to review and comment on it, as well as the county inspectors and the landowners for that matter. It's not something that we would do in a vacuum.
Okay, so it would be another process to deal with the secondary AIMP for winter, right?
It would certainly be a supplement to it to deal with the site-specific conditions.
I suppose everybody here would have to get notice of that, right?
We would certainly provide notice.
Okay, we have a full hearing about that, right?
Well, I don't know that I agree with that.
Okay. I think we're the only two that laughing on that one. On the depth issue, would you agree with me that aside from the 48-inch, or excuse me, would you agree with me that the only provision affecting the depth of the pipeline in the AIMP is a 24-inch separation rule in 6.6B?
We're going to have to pull it up.
Sure.
So what that says is, I'm just going to read, starting from the second line, the word permanent tile repair can be installed with at least 24 inches of clearance from the pipeline or as agreed upon with the landowner.
Is there any other rules in the AIMP that affect the depth of the pipeline?
I don't believe so. We're bound by PHMSA DOT 49 CFR 195 that dictates the depth of the pipe. Folks are okay with this, and we've reached that agreement. So the minority that doesn't want to give us the information to properly design to avoid those locations on their specific property, I don't know what else we can do as a company to accommodate that landowner who simply refuses to talk to us. And if a court or the board has to decide, then I think we're all subject to the board or a court making that determination, which in my opinion is simply the wrong avenue to go. I would much rather sit down and negotiate in good faith to make sure that we are accommodating the landowner's request as much as we can.
I don't have any more for that subject, and the AIMP is all done. But I do want to bring up the Exhibit H for track IABU-073.000. I'm going to want the Exhibit H for that. We're going to step through this at the very beginning, okay? If we could just go to page 1 of this document, if we could. Would that be page 1?
Mr. Murray, what are you looking for?
Uh,
We're all confused up here, sorry.
I'm looking for the total Exhibit H filing, starting with the first page of parcel IABU 073.000. Would that be the first page? Okay, we'll go with this. This is a tract concerning the Lenharts in Buena Vista County, proposed for eminent domain. It's been discussed earlier in these proceedings. This appears to be a survey map of what appears to be the proposed pipeline route and the temporary construction easement area. Would that be right?
Yes.
Does that map have on it any additional access easement areas?
Not that I can see.
Okay, let's go to the next page in this Exhibit H filing. Okay. This page is affiliated with the previous page concerning the survey.
That's correct.
Okay, now the tech person is right where she needs to be. And there's some legal descriptions there, correct?
Yes.
And so the first legal description is the pipeline easement description, correct? That's all right.
One more time, please.
The first description is the description for the pipeline easement, correct?
Yes.
And this is a specifically worded, what they call meets and bounds description of a 50-foot wide pipeline easement, right?
Yes.
And if I am right, then you can take a look at that legal and you can tell us exactly where this 50-foot is going to be for the pipeline long-term, correct?
In theory, yes.
And in fact, I think that you're representing that you have professionals that have done this work, and your company certified this is accurate, right?
We had our surveyor certify that it was accurate.
Okay.
We're not a licensed surveyor.
Okay. Now, the next description is another legal description concerning the temporary construction easement, correct?
Yes.
Okay. And below that description, there appears to be a couple of temporary construction easement described for this particular Exhibit H filing, it appears, right?
Yes.
Okay, now let's go on to the next page. This page here appears to be just a generalized drawing of where the pipeline is in connection with section 25 where the parcel is located, right?
Yeah, you're going to have to scroll the whole thing, please. Okay.
All right, let's go to the next page. Okay, now we're going to get into this report here, which gives initially the ownership information for this particular parcel, correct?
Yes.
It gives the name of the owner and whether there's any other parties in possession in that first section, right?
That is correct.
It does give, importantly, in the next section, I wanted you to note that there's a definition for the, quote, property, end quote, right?
The property legal description?
Yes.
Yes.
And would you agree with me that that property legal description is the entire parcel? Would that be right?
I mean, I guess it is.
I suggest it is.
Okay.
And the next section appears to be the same legal description as what the surveyor used for the pipeline easement, right?
I would have to put them side by side, but that's the intent.
Thank you. And would the same be said for the next section concerning the temporary construction easement?
That is correct.
Okay. If we can keep on going down, technician. And then see that last line there? The pipeline easement, temporary construction easement, and access easement, comma, if any, comma, may be referred to collectively as the, quote, easements, end quote. Correct?
Yes.
Okay. So we should continue on and take a look at the next 2 pages. This is a page that spells out easement rights that, if I were to suggest, goes on to the next page. And those are the so-called proposed generic takings clause that we would see attached to all Exhibit H's, right?
They're I don't know about takings is the right word. They're the generic terms.
For the easements that
Yes.
Dakota Access wants, correct?
That's correct.
Okay. So I'm going to have you refer back to the previous page on section little 5, okay? All right. It says here, the right of unimpeded entry and access in, comma, to, comma, through, comma, on, comma, over, comma, under, and across the access easement, comma, if any, comma, and such other portions of the property as may be reasonably necessary to exercise the rights granted to Dakota Access at all times convenient. My question to you is, as you've now reviewed this Exhibit H, does this proposed Exhibit H, is Dakota Access intending to have a taking of anything more than the pipeline easement and the temporary construction easement areas?
You know, in general terms, no. So there are certain circumstances where we may need an access road or we may need a valve site. But in general terms, I think, you know, what you're inferring here is the permanent easement plus the temporary easement to build the pipeline.
So there's been some testimony earlier about the Lenharts, and I'm going to tell you that their parcel is located adjacent to Highway 71, a north-south road, okay? If, assuming that is the case, why would there have to be any access easement necessary when the pipeline and the temporary construction easement intersect Highway 71?
Oh, well, there simply may not be the need for it. But, you know, I'll say, I can't remember when we met with you sometime in the summer. We could simply have had these conversations many times, instead of here in this situation to figure this out, we're not adverse to figuring out the best solution for the landowner. I don't know that we're going to resolve this issue while I'm on the stand and you're asking me questions for this individual landowner. But I can tell you generically, if we don't need additional rights to a person's land, we're not going to seek it. It costs us money. So I'm not going to spend a dollar for something I don't need and encumber that individual landowner.
So to be clear then, with respect to this parcel, can you say you don't need the access easement?
I haven't been there. I haven't been able to talk to the Lenharts. Given that opportunity, I could probably answer that question pretty darn quick.
Okay. Now, let's publish the Exhibit H filing for IA-BU-020.000. Here's Martha Murray, right? Her Exhibit H, right?
Yes, sir.
Now we're going to go down to a couple pages down here. Let's keep on going. This page right here. Back up. Let's take a look at that document. Okay. Now, here's a parcel that is shown depicted in section 34. Okay?
Yes.
And it is it shows a pipeline on this parcel. Strike that. On this parcel, can you tell where the roads are in connection with the pipeline?
The public roads?
Yeah, the public roads.
I think we can see 540th Street, and if we scroll up, you can see the county highway M31. Yes.
Okay. And so you would agree with me that on this particular parcel, the proposed route of the pipeline does not exit or enter the parcel and onto a road. Would that be correct?
As from what I can tell here, that is correct.
Okay. Now, let's go to the first page of this exhibit and see if we can't find an access easement defined. Okay, this is the first page. Let's go down to the next page. Okay, we've looked at the first two pages. I don't see an access easement spelled out here. Do you?
Yeah, so I'm going to kind of refer back to what I said earlier. These individuals, including Mrs. Murray, we would love to have this answer and to be able to tell you the access point into or off of the property and all the details surrounding it. But in an eminent domain situation like this, because we haven't been afforded the opportunity to negotiate in what we consider to be good faith, we can't necessarily get every bit of data onto this Exhibit H because we simply don't have all the facts. If there's an existing road that Mrs. Murray would say, hey, we would rather you stay here and drive down this road instead of creating a new road to access the property, we would do it. But without having that open debate or dialogue, I don't know what else we can do.
So let me just keep on going here and see if we can't find the access easement. On this page here, we have a pipeline easement description and a temporary construction easement description, correct?
That's correct.
And then let's go to the next page. All right, that's the map we were looking at there, and let's go to the next page. Here again is the ownership information, the property description, the pipeline easement, legal. And then on the next page, the temporary construction easement is right there, right?
Yes.
Okay. So see that language in the bottom there? The pipeline easement, the temporary construction easement, and access easement, comma, if any, may be referred to collectively as the, quote, easements, right?
That's correct.
So how is Dakota Access going to access It's pipeline easement and temporary construction easement during construction on this particular parcel.
It could be down the right of way.
It could be.
It could be.
Could it also be somewhere else?
It could be. And if for some reason, and I don't know what the reason is right now, I'm just speaking in hypothetical terms. If we are granted the right of eminent domain on this tract and we get onto the tract and realize that there is a good access point for whatever reason, then we would probably seek to add that access point. But without, again, having an open dialogue to work that out ahead of schedule, you and I debating this without facts is I don't know that we're going to resolve the issue.
When we talk about the definition of the entire property, as it's in this Exhibit H, would Dakota Access be agreeable to some sort of language which clarifies that this eminent domain taking only affects specifically defined areas and not the entire property?
Sure. I mean, in our intent, as I thought I mentioned earlier, we're not interested in getting on people's property where we do not need to be.
So pardon me.
And if we had information to further define where the need would be for an access road or something like that, we could potentially limit this even further. But in no uncertain terms do we expect anyone to grant us full rights to do anything that we want to do on somebody's property. We want access to the construction right of way, to build the pipeline and to restore it and move on. Those are the rights we're seeking. And I think once we go through the process, if we have to during the eminent domain process, I think some of that will get flushed out. Or, which I hope we can do this, that after this hearing we can sit down with the remaining landowners and talk through these things and negotiate the remaining terms of the easements in good faith and be done.
With respect to going up to, excuse me, I think it's down from this perspective. Thank you. In section little number 1, all right, I see the word valve in this section. It's on the, if we can go down right there, it says that valves could be placed on these parcels, these 316 tracts. Is that right?
That's correct.
Why do you think it's necessary for every tract subject to eminent domain to potentially have a valve placed on it?
Well, this really gets back to the inability to reach an agreement. We clearly do not need valves on every piece of property that we cross in the state of Iowa. For the majority, we're working in good faith and have secured those easements where we do need a valve. On the Exhibit H's where we do have a valve identified, we have clearly indicated those. However, the generic terms here indicate, just like the questions that we've received for HCAs and future conditions, and conditions may change that may necessitate a valve to be installed to protect the public or whatever that HCA would be. So instead of us having to go through a second eminent domain hearing, which would be traumatic for somebody like your mother, we want to not encumber a landowner. And if this is a painful process, and eminent domain is very painful, we certainly respect that and do not want to have to subject somebody to that more than once. And that's why we have that in there. It's not that we're going to put valves everywhere. It's just in the event of, if the board so chooses not to grant that and modifies it, then we would have to go through a second eminent domain proceeding if the DOT requirements required us to add a valve at a particular location in the future. I can't answer that. I just am answering why we have that language in there.
And now for the words that everyone wants to hear. No further questions at this time.
Thank you, Mr. Murray.
Thank, Mr. Gray?
Thank you. I do have some questions. I don't think it will take the rest of the day. Mr. Mahmoud, did I pronounce that correctly?
Yes, sir, you did.
Okay. I want to ask you about something I haven't heard discussed at all, and that's other utility lines provide vital services to both Iowans and the United States. In particular, I want to ask a couple of short questions about fiber optic backbone. Iowa has some major fiber optic lines that go through the state that supply a large portion of the internet traffic in the United States. Briefly, can you tell the board what precaution, I mean, first off, are you planning on, do you know what I'm talking about? And second, if you do you know if there are any plans to go under some of those cable fiber optic lines?
And so first, I do understand what you're talking about. When we approach a foreign line of any kind, telephone, electric, there are some buried electric lines, pipelines, water lines, any type of line, our first step, very first step in the construction process, and I'm going to back up just a little bit. Our very first step that we do is when we're communicating with the landowners for survey permission, we try to solicit from the individuals, do you know of any easements, encumbrances on your property that we should be aware of? That's the first question, first time that we're seeking the location of additional utilities on a piece of property, which could include a fiber optic line. The second point that we look at is when we're doing our title research and research on the property to identify any recorded easements that may encumber that property. So typically with a fiber optic line, there's a recorded instrument that has an easement located. In most cases, some don't, most do. So that's the second way we do that. The third is when we're getting ready for construction, we do surveys. So we're surveying, doing civil surveys where our surveyors, and not just the civil surveyors, but all of our surveyors, believe it or not, biologists, archaeologists, anybody that goes on the right-of-way are trained, I'll say trained loosely, but are expected to identify foreign line crossings to help build the data set. After that step, when we're actually getting ready for construction, we call the 811 number. That utilities, if they're a true utility in the state of Iowa, are required by law to register their locations of their utilities. And when you call 811, are required by law to go mark those. And if they don't, that's actually a gross negligence standard that they meet automatically. That's not something I make up. That's what the state law says. So we do the 811, and then we take it one step further. Prior to construction, if all that data set, we actually do run other sophisticated surveys where we're looking for stray currents or voltage, where we may run a magnetometer survey looking for metal. So a magnetometer survey is a survey that actually picks up metal objects in the ground, looking for conduit. If it's a plastic pipe, typically with fiber optic, they'll be encased in some type of protective barrier for stray currents, some type of zinc or something like that. That voltmeter or that voltage indicator will actually pick that up. So we go through all those steps to try to identify those foreign crossings. Even with all that, I'm not going to sit here and tell you we haven't ever hit one, because we have, but it's very rare.
Have you ever worked for a company that did not have the right of eminent domain to build a pipeline, that was seeking to build a pipeline?
Absolutely. My company, Energy Transfer, we have plenty of projects and plenty of pipes that we've built that we do not have the right of eminent domain.
In those situations where a pipeline has no right of eminent domain, would you agree that the pipeline and the landowner are fairly equal bargaining position? Neither can force themselves on the other.
I think you're always in a negotiating position. I don't know that having the right of eminent domain changes that position in my mind.
So if a landowner does not agree to a price or terms with a pipeline that has the power of eminent domain, the option that the pipeline has is to simply condemn its way through the property.
That certainly is the course of last resort.
And you don't agree that that gives the pipeline some leverage in the negotiations?
Well, maybe it does at the end of the day, but I can tell you from personal experience.
Well, I think that answers my question. You say it does at the end of the day.
I think I would like to finish my statement if I can. I've personally built, like I said earlier, thousands of miles of pipe in this country. Most recently, over the past 3 years, about 2,500 miles of pipe. I've condemned no one. And all those projects I've had the right of eminent domain. So it's pretty disappointing on a project of this scale that we're at 24.8% potential condemnations. I suspect that will come down over time as we get through this process, because our company does negotiate in good faith. And if we can simply get in front of the folks that are holdouts at this point, I suspect we can close most of those terms.
So your position that landowners who have not negotiated with Dakota Access are not negotiating in good faith?
I'm sorry, I didn't understand the question.
Is it your position that landowners who have not negotiated with Dakota Access at all are not negotiating in good faith?
I don't know that I would say not in good faith. I would say it's just not negotiating.
I want the Technology Bureau to pull up, I think it's a Chuck Fry CAF Exhibit 4. And I'll ask you to go to page 8 of 43. This was Exhibit CAF-4. I don't see it there. I know we've had it up in the past.
It's an exhibit to Fry's supplemental testimony, I believe.
I think this might be attached. Why don't you pull up that, see if it's attached to the reply. I can probably skip that line of question until, oh, there it is. Okay. Mr. Mahmoud, is this a familiar illustration of the pipe laying process?
Yes, it is.
My question to you is, Where in this process, looks like step one, I can't read it from here, but it looks like they're clearing the land. They're bulldozing it flat on step two, and they kind of go through a series of steps 1 through 12. 12 must be finishing it. I'm wondering at what point during that process does the tile repair contractor for Dakota Access appear on the scene?
Somewhere between steps 9 and 11.
Okay. So
let me back up a second. That's during normal construction.
Okay.
So one of the things that we've offered to the landowners, and I say this because not very many people have taken us up on it, but the offer's out there. We have offered to relocate the drain tiles for the landowners ahead of construction to mitigate any adverse concerns that they may have during construction. And that would include putting in a header system to cut off the drain tile so during construction it reduces that concern of impairing the drainage of the field. That offer's out there. I just wanted to say that actually is the first, so that would be prior to step 1. But in the normal course of construction, it would be between steps 9 and 11.
By a header, you mean perhaps run a lateral along the pipeline to where it can get another outlet?
That's right. So roughly a 200-foot zone in the field would be quartered off with a header system on each side, evenly spaced to capture whatever laterals would be tied into it to carry the water across the right-of-way, and then with some other type of single header instead of individual tiles.
So looking at this colorized version of the exhibit, looks like at step 9 appears that they're rolling the welded pipe into the area.
That's correct. And backfilling.
All right, and then 10 they're backfilling. So would I be correct in, I think your testimony was kind of, it could be any one of those stages, but wouldn't they have to be kind of at the intersection of 9 and 10 at least?
No, it could happen anywhere between 9 and 11. 9 is where it would, the first point during normal construction would occur as a pipe is laid inside the ditch and they would start their ties. But it could also occur up through 11 where you're doing backfilling and restoration, and you put in some type of supplemental. You may have to redig certain areas to do that, but it could occur between 9 and 11.
Well, wouldn't you want the person inspecting tile lines to get there before the trench was filled in?
It depends. That's up to the inspector, of course. But if we, for some reason, had to do it, after the trench was backfilled, we obviously have to redig and expose the area to make the tie-in. And so in that circumstance, I'm more referring to a mainline header as opposed to an individual field drain tile. But we're just using tile as generic terms here.
Well, I'm also thinking about a deeper tile that might be below the level you've already
So a
filled in.
main line, a main drain.
Now, in that case, the inspector repair contractor is relying on the contractor to have flagged those larger, deeper drains.
Typically either them or our survey, one of the two, but we work together.
Because if he gets there at stage 10 and the trench is already filled in with dirt and there's no flag there, he's not going to have a clue that there was a broken tile unless there's water shooting up out of the ground.
Well, I mean, I guess that's in theory could be true, but when we're excavating the ditch for tiles that are not caught prior to construction, we have a survey crew that picks up those tiles. So again, it depends on the type of tile we're talking about. If we're talking about just a regular field tile, they're happening in stage 9. If we're talking about a mainline tile repair for a header system, it may be in stage 10 or 11 because we may elect to backfill and then come re-excavate put in the supported structure on the main, say if it's a 24-inch main line, and have that specialized contractor come in there and do that work independently to get, so they're isolated from the mainline construction. That's an option that we probably will employ.
So let's take a look at phases 8 and 9. The trench is open in 8. In 9, it's being filled with a pipe. If the contractor flags a drain, a larger lateral or some other main collector or main drain line that's at the same level as the pipeline, it will be too late by the time the inspector gets there at stages 10 or 11 to do anything about it, because the tile line is going to be intersecting or cut off by the pipeline.
Well, that's not how it works.
Well,
I'm just telling you, from a construction person who's been a part of this many, many times for years and thousands of miles of pipe, you're wrong. That's not how it works. The construction contractor and the surveyors are surveying. When the contractor's out there, they see a tile, they either flag it or it's been flagged. As part of the restoration, the drain tile is not being relocated. The pipe is being adjusted to account for the drain tile. So as the guy is digging the trench with the backhoe, he's making the accommodation for that drain tile right there on the spot. If he misses it, I'll give you the benefit of the doubt. Then we'll come back in and we'll dig that down a little bit deeper, so the pipe, when it is laid in that ditch, we will be able to place it so that it does not interfere with the tile. That's how it really works during construction. The theoretical, you're going to block the drain tile, simply just isn't true.
The pipe will bend a certain number of inches per a certain number of feet of pipe, correct?
That's correct.
Do you happen to know what that ratio is?
I mean, our typical bend ratio in the field, I think, is 6D. I'd have to ask Chuck to get the specifics, but, for every diameter inch, 6 times the diameter, something like that. So you figure out the inflection of the radius.
6 times the diameter. Is that a linear foot to inches?
Right.
Okay. Is there some reason why Dakota Access does not want the drain tile inspector there at, say, stages 7B or 8 before the pipe is dropped?
Well, I don't think we've ever said that.
Oh, you said that they're going to show up at 10.
Well, I mean, I think the assumption you're making is this is occurring over 2 weeks. The time frame between 7A and B to 10 may be a day. So that's why we're giving that inspector ample notice. I know the plan says 24 hours, but 24 hours is plenty of time in this circumstance for them to have notice to witness that.
Now, when you use the word inspector, you're talking about the county inspector?
That's correct.
I'm talking about Dakota Access's contractor. Maybe we're talking past each other. When Dakota Access is going to retain a drain tile repair company or companies to effect repairs of the drain tile as they're cut, correct?
That's correct.
We'll call that person the Dakota Access drain tile repair guy, all right? Just so we're clear.
Okay.
The Dakota Access drain tile repair guy, will he show up anytime in the usual course of business before step 10?
He'll be out there the entire time.
Okay, that makes more sense to me. So let's say at some previous stage during the excavation, a deep lateral is discovered. Your Dakota Access drain tile guy is going to be there, and he'll note the location of that cut lateral.
That or our survey crew will, or our chief inspector, or our craft inspector. We have probably 20 inspectors in that area, plus the contractor, to flag that situation, to get the data back to our construction manager would take the appropriate action at that time.
So to clarify the past testimony, the county inspector is going to show up no sooner usually than step 10.
They may be out there, I'm guessing, between 9 and 11.
And that's because of the speed at which this is running.
Yeah, this is moving very fast.
So I think, is it your testimony that steps 7B through 10 could happen in a single day? I just don't recall what you said.
I'm guessing a couple days.
Couple
So
days.
our goal, typical goal, is to not have the trench open for more than 14 days. So you can imagine all those steps happening within that time period. And once that trench is dug, the pipe's welded up, we start laying the pipe into the ditch and we're backfilling. 14 is the maximum. And this stuff is happening, at a pace that I think for those that have not seen pipeline construction, most people don't realize how fast it really occurs. It's not like highway construction. That I'm not digging highway construction. It's just different.
The Dakota Access drain tile repair guy has received some training, I assume, in how to work in and around the equipment because, as you've indicated, he's going to be there potentially the whole time.
They are, in this case, they are trained with our safety procedures, their own safety procedures. If they're working around our pipe, they're trained on how to work around that pipe. If they're working with the union contractor, which they will be, the union contractor also trains that tile contractor to work with their workforce. Very much so, they're aligned in their training and to be able to be on that right-of-way in a safe condition. It's our requirement by contract that they have to be trained before they're allowed on that right-of-way, and they have to provide documentation of such.
Has Dakota Access hired these Dakota Access drain tile repair guys?
We just executed our contract with Precision and Michaels. I'm not sure if they've executed the contract with the drainage tile people yet. That's a subcontract to our prime.
All right. Do you know if, or let me ask you this, did Dakota Access provide any scope of work requirements with its contract with Michael that sets out experience requirements dealing with drain tile repair for its subcontractors?
I don't really know what your requirements definition is.
Well, are they hiring people who've done it before?
So our requirement is that they have experience in demonstrating the capability to do this work, and they have to provide their resumes and experience to us.
And Dakota Access has approval to approve or disapprove the subcontractors?
Absolutely.
Is the Dakota Access drain tile repair guy going to keep a record of the drain tile information that's uncovered during the construction, including post-construction location of drain tiles?
Between the contractor and our survey group and our construction group, absolutely.
And Dakota Access will agree to make those records available to landowners as far as the actual location of the drain tiles?
So we've gotten that request from a few landowners. I will say generically, most people have simply just not asked for it. And I can say most because, I know y'all all know we're at 75.2% at this point. The majority of the people have not requested it. But if they do, we probably would make accommodation to give them the location of the drain tiles.
So you would not have any objection if the board entered an order requiring, as a condition of a permit, that Dakota Access agreed to make available to any landowner who requests it a record of drain tile system information developed during the planning and construction, and also including post-construction location of drain tile repairs.
Yeah, I probably would. Why do we need a condition that states the obvious when I just told you that we're willing to do it? And why encumber a landowner that doesn't want the information?
Well,
so you're overextending the condition onto unwilling parties. The board's position is not to negotiate the easements for Dakota Access. And I think what you're embarking on is a negotiating term of the easement as opposed to the board rules.
you'd agree that not everyone's going to negotiate. You'd like us to all negotiate and enter into an agreement, but it may be that there are some people who don't agree to enter into an easement with Dakota Access.
In my career, and I'm almost to 20 years doing this, I've never had to provide that as part of a state certificate or an eminent domain proceeding.
When I asked the question, I asked if the board issued an order. It was limited to only those landowners who requested the information. If that was the limitation, would you agree that Dakota Access would provide that information to requesting landowners?
Again, I'm not one for a bunch of conditions just to have conditions.
So you would not agree?
No, I've already said I would not agree.
Is Dakota Access going to collect location information regarding these tile repairs using what's called sub-meter GPS systems?
We are.
And that information would also be available in your internal records as to where these repairs are taking place?
They will be part of our as-builts.
But you would not agree to provide that information to property owners who requested it if the board ordered you to. Is that what you're saying?
Well, what I said was we would give it to people that required it. I just don't think a condition is very applicable in this case. We're not saying no, but why do we need a condition to state the obvious?
If during the earlier steps we saw in that previous exhibit, number 4, it is necessary for Dakota Access to move or adjust the drain tile line, is Dakota Access willing to work with the landowner to come up with a proper location for that adjustment or change?
That was a long question, I'm sorry, but if I understood what you asked, and maybe you'll let me paraphrase, if a landowner wants us to relocate the drain tile to a different location than what we've encountered in the field, would we do that?
No, I think my question was if Dakota Access during its construction phase finds it's necessary to move it or do a header system or something like that in order to make it work, are they willing to work with the landowner to come up with a reasonable solution so the landowner just doesn't find out that his pipe is going half a mile the wrong some other direction he wasn't expecting it?
Of course, 100%. They would know about it as soon as we had a situation that we couldn't put it back like we anticipated.
I'll make it easy on you and say if you would agree that you wouldn't want the board to order you to do that, but you're saying you will do it.
Well, I think in our ag mitigation plan, I can't remember the exact verbiage, but absolutely.
Will Dakota Access promise landowners to repair or replace all damaged and disturbed drain tile in a manner that maintains the full integrity, function, and original slope of the drain tile?
Did you read that from the AIMP?
Will Dakota Access promise to repair or replace all damaged and disturbed drain tile in a manner that maintains the full integrity, function, and original slope of the drain tile?
I believe that's in our plan, yes.
will Dakota Access agree to allow independent qualified drain tile contractors to be given the same scope of access as its own drain tile repair guys in order to audit and examine the work done on landowner drain tiles during construction, assuming that that independent qualified drain tile contractor has the same level of training and for safety?
Probably not.
And I'll make it easy for you again. You probably don't want the board to order you to do that.
Well, I'll respond to that. We have the county inspector whose sole job is to make sure it's done right. We've hired professionals and experts in the field of construction and replacement. To have an additional requirement to potentially develop controversy on the right-of-way for a construction technique is simply a detrimental step during the construction process and probably leads to more conflict and resolution.
But you've testified you've never actually had that kind of issue come up before.
I don't know that I said that in whatever context you're referring to.
Like you said, you've never had to condemn anybody.
No, you're certainly misrepresenting what I said.
Okay, then I'm misunderstanding what you're saying. So you have had to, for other pipelines, had to condemn landowners.
Yes.
Mr. Taylor asked you about running pipelines along roads. Your response was, and you can correct me if I mischaracterize this, was that putting the pipeline near roads exponentially increases the risk to the public.
In my opinion, it does.
What is the risk that you're worried about?
Third-party damage to pipes is the single greatest threat to a pipeline system. People digging into it is the primary mechanism that we have third-party damage. So to have the Department of Transportation out there having to navigate the public transportation system around a 30-inch crude oil pipeline simply is just not good business. And for the public that would have the potential for accidents, and I can imagine the worst case, certainly is not worth the risk. Now, we operate pipelines, and we have a lot of experience where we have pipelines adjacent to roads, and although we don't route our pipelines next to roads, a lot of highway departments route their roads next to our pipes. And we argue about that quite extensively.
Ms. Howard testified that landowners will be compensated for loss of landscaping and timber, but she deferred to you as to the method of compensation. So I'll ask you, what is the method or measure of compensation for, let's say, timber?
Well, yeah, I mean, it certainly is very site-specific, but if there's timber involved, then we would do a timber survey, and there's methodologies to determine the value of that timber as part of a damage assessment.
What is that methodology?
You know, they do a height versus diameter, have breast height calculation for the actual usable timber, then based upon the actual type of timber that it is and its market value for the sale of that timber into a commercial use is typically the valuation methodology that's utilized.
I have two follow-up questions. One is you used the phrase they. Who is they that's doing this valuation?
A third-party forester appraiser.
And the second question, the timber would be valued for its marketability as lumber?
That's correct. That's the typical methodology.
Your Honor, I don't mean to interrupt Mr. Prey, but he seemed to be gathering his thoughts there. I don't know how much longer he has to go, but I hate to step on Mr. Murray's territory, but if I might suggest it's about time for a break.
All right.
I delegated.
That's why I was wondering when that question was going to come up.
I'm not picking on Miss Agramonte, but I I've been trying not to do the breaks in the middle of testimony because I don't want you to gather more steam. So, but since Mr. Dubinsky is requesting it, we will break for 10 minutes. Ready, Mr. Mahmoud? Edie, are you ready? So I said 5:15. It's probably going to be more like 5:30, 5:45. You may proceed, Mr. Prey.
Okay. Yes, one of the dangers of taking a break is I think of more things. I just want to confirm I got the math right on that pipeline bend.
On the pipeline what? I'm sorry?
Bending a pipeline.
Okay, and we may have to get Chuck to answer the question exactly.
And if you're wrong, Mr. Dublinsky or Ms. Agamonte can do a professional statement. I just want to know the answer.
Okay.
I'm not trying to catch you on anything, but I think you said you multiply the diameter of the pipeline by 6, and that equals the number of feet per inch of bend you can get. So if I take 30 times 6, I get 180 feet. So out of 180 feet, I don't know, maybe about as wide as this building, I can bend that pipeline about 1 inch.
It would be for a sweeping bend, so it's a 60 radius basically to come up or go down. So I think I wasn't here and I didn't hear all of Chuck's testimony, and maybe it's just he and I in conversation, but when we talk about approaches coming up to a valve location, we talk about the rise that you have to come up to bring that valve above ground, and you go back down, and there's why we need such a long area. That's for that sweeping bend. So we allow the contractor, based upon the wall thickness of the pipe and what that pipe can withstand in a field bend situation. They have machines that do it. So we'll allow that contractor to bend up to, I think it's 12 degrees in the field before we say then it has to be what's called an induction bend, which is a prefabricated bend. So I kind of overgeneralized, but that's about what the sweeping rise is.
Next clarification, if the technology folks can bring up, I think it's CAF4, the colored construction drawing we were looking at before. I just want to clarify, since there was some miscommunication between us early in my cross-examination. If I'm talking about the county inspector is generally going to get 24 hours notice and show up somewhere around stage 10, I think you said.
Sometime around stage 9 to 11.
9 through 11, okay. So open trench, actually 9 is the pipe has been
lowering in,
kind of being cantilevered over the open excavation and being dropped. 10 is it's in there, it's being filled. 11 looks like they're applying the clay layer and the topsoil on 12. So it's possible, depending on when the county inspector gets there, that I think in line with your testimony that they may arrive there at 10. We're not saying they always will or they ever will, but they may arrive there at stage 10 when the excavation is partially complete. Is that accurate?
No, I have consistently said 9.
9. Okay. So you're going to say that they're there while the excavation is open before it's filled. This is the county inspector.
That's right. The county inspector, once we start, with the amount of drain tiles that are in this country, there's not really going to be a break. I mean, in all practical sense. There may be in some of the counties closer down to the Mississippi River where there may not be as many tiles. Central Iowa, northern Iowa, where we're just filled with drain tiles, right? The likelihood of that inspector not being on site for most of this construction is really pretty low. But I think in general terms, in the event of we had to call them out because they were not already there, I think it starts in item 9.
Starts.
I think that's when the notice is made to the county inspector to come visually observe that process from 9 through 11, where the most likely opportunity is for the drain tile repairs.
He's gonna, so I'm still all unclear. Notice goes out at 9. How many hours between 9 and say 11? Well, section 10, how many hours is that of
I
construction?
couldn't tell you. It could be a day, it could be 4 days, but probably it's going to be more than a day because we have a 24-hour notice.
All right.
So 9 extends that duration from digging the trench and lowering in. I said the trench is left open for about 14 days. So you can kind of visualize, or maybe you can't visualize what that duration is through that period. So we will call him out there sometime in 9, or her, have them observe whatever we're doing and go on our business.
How is, Mr. Murray covered this, but notice to the county inspector is done by what, email or mail or what?
Email, phone call,
All right, actual notice.
actually, yeah, some type of notice.
So if they get there exactly 24 hours later, they may arrive at stage 10.
They could arrive at some point during stage 10.
Okay, that's my question. Did I hear you right that you said that the excavation would not be open for more than about 14 days or 2 weeks?
That's about right.
And I know it's been asked many times by different witnesses.
Hey, can I take a break real quick and
Sure.
talk to Brett? Do you mind?
Sure.
Mr.
Back on
Gray,
record.
you may continue.
Okay, how fast? I've heard it said that the pipeline is going to be built at the rate of about 1.5 miles per day. Is that true?
Yes, that's correct.
Is that combining all of the different construction groups, or is that any one construction group going 1.5 miles per day?
That's per spread.
All right. So the maximum number of miles that could be opened at any given time by one construction group would be about 20 miles. If I take 1.5 times 14.
Across the 1,168 miles? Is that what you're?
At any
Oh,
one,
for
any
the
one
14.
construction group.
That's probably about right.
Is it possible that an excavation that long, even if it's half that, say 10 miles, will cause problems for farmers during planting season or harvest season to get access to the other side of their farm if it's separated by that long trench?
Well, so theoretically, and we hope that we've dealt with those issues and compensated that landowner for any impacts to them during that period of time, which they may not have access to their fields. That's part of the damage assessment that we do. If they bring it up and make a claim that for whatever reason we can't gain access to our side of the field or wherever they need to be, we'll make an accommodation for them, no doubt.
I forgot to ask this question. Are you aware that when excavation cuts through a drain tile, sometimes it kind of snags it and kind of pulls it a little bit?
I'm sorry?
Are you aware that when an excavator, whether it's a bucket load or whatever, cuts through a drain tile, it can kind of tug it a little bit?
Well, I mean, I guess in theory it could.
Do you know what happens if a drain tile is pulled and it pops its seam upstream somewhere?
Sure.
It kind of creates a cavity, water eventually, big hole in the field.
I mean, I think anything is possible, sure.
Do you know if the Dakota Access drain tile repair guys are going to be checking for that kind of damage when they're on the scene?
They will. Now, how far up and downstream of the actual trench, they'll check for integrity of the drain tile system, make sure it's a functioning system. Now, exactly how far up and down, I don't know.
Are you aware of concerns expressed to the board by my client, Laverne Johnson, regarding what I'd call his nest of multi-level drain tiles?
I've seen a picture that was provided.
Are you aware that one of those drains is what's called I'll probably get this wrong, it's basically a community drain. It's not a county drainage system, but multiple farmers use that particular drain.
I've heard that.
Does Dakota Access have any backup plan to route its pipeline around the nest of multi-level drain tiles on Vern Johnson's land?
Well, I don't know that one's necessary.
Well, I didn't ask you that. I said, do you have one?
Well, I'm going to answer the question. I don't think it's necessary. I think if we could get out there and work with your client to develop a detailed plan to cross that, I don't think it's going to be an issue at all. But as I've mentioned with Mr. Murray, negotiating in this forum, sitting right here, is probably not very productive, and I don't know that we'll ever get to a resolution. But I'll tell you, if we can sit down and go over it, I believe that we can come to a resolution, because what I've seen on those drawings, we can deal with. I mean, that's not something it may be unique to him, but it's certainly not unique to other things that we've dealt with in pipeline crossings.
So my question was whether Dakota Access has a backup plan.
The backup plan, the plan is to cross his crossing. I don't know what type of backup plan you're trying to figure out.
I'm just asking. I mean, so the answer is no. You're just going to go through the tiles.
We're going to go through the tiles.
All right. I take it that Dakota Access did not do any kind of economic analysis to compare the long-term damage to farm drain tiles versus the extra cost to Dakota Access if it were to attempt to go down through section lines and fence roads instead of diagonally across the entire state of Iowa.
Well, did we go through a detailed analysis for that particular question? No. But if you can imagine, if we followed every road and section line, the length that it would add to the pipe, we would disturb significantly more land. Significantly more. I don't know on a percentage basis, but I bet it's almost a third or more. And by doing that, we're exposing not only drain tile systems, because I don't believe anybody would sit here and say there's not a drain tile on a section line or near a road, because the simple fact is some of the mains run kind of parallel to some of these roads. It's how they get into the ditches. I think that we would run into the same circumstance. So I think the hypothetical is actually, it would result in more damage, and I don't think there's a benefit. An economic analysis, I don't think really proves anything. Plus, it adds to too many bends into a pipe where it just simply makes it less operationally efficient and or safe for the public. So I don't think that that was a viable option or alternative in our analysis.
So the answer is no, you didn't do any
That's what I just said.
economic analysis. All right. The investor members of Dakota Access made a decision to invest in Dakota Access after they had determined that they could recover their capital investment, operating costs, and other expenses and still make a profit.
I think that's without trying to be smart, I think that's any business person makes that decision.
So the answer is yes.
Sure.
Profit is a determining factor in any kind of smart business decision.
Well, in a for-profit company, yes, that is a true statement.
If the investor members of Dakota Access found that the project would not make a profit, would I be correct in surmising that they would not have invested in the project?
I believe that's correct.
Am I correct in surmising that the investor members of Dakota Access would not be willing to forego a profit just to help America achieve greater energy security?
Well, I don't want to be a smart aleck here, but I think that's pretty ludicrous thought to really think that we as a company that are investing billions of dollars into an infrastructure project that no one else has been able to lift in this country because we're doing it at a sustainable but reduced margin that does provide for energy independence in this country. It's a fact with the Bakken and other oil plays, we're 26% reduced in foreign imports. So I think it's pretty naive to think that our investors in our energy companies in North America don't have a vested interest in the energy security of this country. I think that's a pretty bad statement.
Well, I simply asked I'll be a little smart alecky back. Dakota Access has been wrapping itself in the flag during these hearings, saying that this is going to achieve energy security. My point is that unless you're making a profit, it ain't going to happen.
Objection, Your Honor. Asked and answered, argumentative, and frankly, it's not a binary. You can both have a patriotic motive and a profit motive.
I think it is binary. You just said it. I'm trying to get him to actually admit, understand.
So I'm sustaining both of you because you need, and the witness, because you need to answer the question. You need to not do, you're antagonizing each other.
Oh,
So let's,
I don't have anything against this gentleman.
I understand that. That's just our nature as attorneys, isn't it?
Yeah. Let me see if I'll give it one more shot here.
Okay.
You're not doing this project for energy security. The decision point in a business sense is it has to make a profit. Doesn't make a profit, we're not going to do it just because it helps America achieve energy security.
Well, and you may not believe it, that's okay, but we certainly have a twofold standard that we certainly want to make a profit, but we also strongly believe in energy independence.
Sure, but you're not going to do this project for energy security only if you can't have a profit.
Asked and answered, Your Honor.
He hasn't answered that question.
He has asked this 4 or 5 times. He's just being argumentative. The chair has cracked down on how the witness answers things. I would appreciate if the chair would equally crack down on how they ask their questions.
I understand your point, Mr. Dublinsky. Mr. Prey, could you please restate the question? And Mr. Prey, just a moment. Mr. Lashir, it is not appropriate to be mouthing words to the witness, and it appears that you are making faces at the witness in some way. If I have imagined that, that is fine. I don't want to see it anymore. Mr. Prey, you need to ask the question specifically without all the antagonizing adjectives.
If Dakota Access was not going to make a profit on this project, it would not go ahead with the project just to help America achieve energy security. Is that a true statement?
That's a question for my CEO.
You don't know the answer to that question?
I think I've answered it. Now, I'll tell you, we're a very patriotic company. We do a lot of things. We're doing this project at a reduced margin. That's why we're able to lift the project in its first place, and no one else has been able to. And I believe that part of our willingness to do this project is to, in fact, contribute to America's energy independence. Now, would we do it for zero
I
profit?
guess I'm objecting. The witness has said it's a question that has to be answered by the CEO. The CEO has not been listed as a witness in this case. This gentleman's been speaking on behalf of Dakota Access. Apparently there is an answer, but the CEO has to provide it. I am asking that the board order the witness to answer my question if he knows.
Your Honor, Mr. Prey is not entitled to the answer he wants. He's entitled to the answer the witness has given 3 or 4 times, and to move this on, finally said, look, if you want a different answer, only the CEO can give it. Mr. Mahmoud has said, yes, we're looking for a profit. It also factors in that it helps America's energy security. We can walk and chew gum at the same time, whether Mr. Prey thinks so or not. He is antagonizing and badgering the witness.
Mr. Prey?
I'd like to have my question asked by the court reporter. It's a very simple question.
For the 5th time.
He's not, he can, look, if the witness doesn't answer the question.
That's enough. The court reporter
I would ask that we read back the last 4 or 5 questions.
It wouldn't make the problem is that the witness is not answering the question 4 or 5 times.
The witness is not giving the answer you want.
No, it's a yes or no.
Mr. Prey?
Yes.
Just a moment. The objection is sustained. Mr. Prey, you need to move on.
I'd like to turn to your testimony, page 14, line 22. And that, you see that in front of you? On
I
page
do.
on page 14, line 22, you state, without access to crude oil or some other alternative fuel that can sustain Iowa's economy, and you have parentheses, that can fuel the tractors, equipment, trucking, and trains, end parens, Iowa's economy simply fails. Now, I'm going to ask you, well, I think it's a simple question. Iowa is not currently lacking access to crude oil or some other alternative fuel that can sustain Iowa's economy today, is it?
That's not what this says.
I know. I'm just asking you yes or no to my question. We have energy in Iowa now, don't we?
You do.
One of the benefits that you mentioned multiple times in your testimony is that, correct me if I'm wrong, but I think you're saying that your project will make petroleum products more affordable.
I think what I say in here multiple times, and we could probably all read it together, is that this pipeline brings crude oil from the Bakken to Patoka and expands the refiner's ability to tap into an alternate source for crude oil. And with that alternate source of crude oil into the refineries, as Mr. Daniels pointed out, Pad 2 and Pad 3, which I know you guys all heard that, it provides Iowa with a more direct supply of crude oil that we simply, or Iowans simply do not benefit from today because they're dependent upon foreign sourced oil that's being brought into these refineries and then shipped to Iowa via refined products. So the facts are the facts. 26% reduction in crude oil consumption from foreign sourced oil. 1 million barrels a day being transported from the Bakken, 1.3 Bakken proper. That is helping to sustain or reduce, more appropriately, the dependency upon foreign sourced oil, which Iowans benefit directly from by having that displaced barrel coming from the Bakken rather than Saudi Arabia or Venezuela or anywhere else. So me, and I'm going to put my patriotic hat on, I'd much rather, as an American, and for the people of Iowa, have access to a stable source of domestic supply of oil to reduce our dependency upon a foreign country. That's what this articulates.
So when you say affordable, you're not saying it's going to be less expensive?
Well, it is affordable. And so, no, I'm not saying less expensive.
You testified at length, I'm not going to try to get into it very deeply, that Dakota Access has multi-layered insurance policies to provide itself with insurance against various perils. If I generally characterize that testimony, you have to say yes or no.
Yes.
Is any member or investor or corporate affiliate of Dakota Access sharing the risk with the insurance company through underwriting?
I couldn't answer that.
I don't think you were here yesterday, but we talked, I think it was yesterday, at length about the form easement that was attached to Mr. Hoyer's testimony. I believe it's RLH2. I don't think I need to have it up on the screen to ask you these questions, but why does the form easement allow or give Dakota Access the option to transport natural gas or liquid natural gas in this pipeline?
It's a very fair question. It's a starting point. It's a generic easement that is for a voluntary form where we are negotiating It's not to say we're going to have anything other than crude oil in it. As a matter of fact, we readily strike anything but crude oil. It's a generic form. It means, really doesn't mean much, because in the state of Iowa, if we change the use of the pipe for some reason, which I don't think that's ever going to happen, we would have to go back to the Iowa Utilities Board to seek permission to do that and to change the use of the pipeline. So it's just some residual terms that probably could be stricken out of there pretty easily and have been so very readily.
Have some landowners actually asked to have it stricken?
Yeah, many have.
Is there a reason that the easement form used by Dakota Access does not have a minimum depth of the pipeline?
No, we've committed to 48 inches. I think we would be willing to put that in. As a matter of fact, we have put that in many easements. You know, we've committed to 48 inches generically across all the state of Iowa. As a matter of fact, in all ag areas across 1,168 miles. Now, that's a generic statement. So in certain circumstances, we may not be able to be 48 inches. So we may be 36 inches because of a drain tile that is at a certain, maybe it's at 40 inches, or I don't know what the right depth would be. I'm not doing the math as I'm sitting here talking, but it would obstruct where that pipeline would be to give 48 inches of clearance. So we may actually be shallower for whatever reason. And so we would not necessarily be 100% 48 inches. Now that would be a rare case, but that is certainly a possibility. But generically, we're 48 inches, and we'll put it in writing just about anywhere. And if we can't meet that 48 inches, then we would have an exception in an easement.
I probably have about 10 more minutes of questions. You want me to keep going? All right.
Yes.
I'd like the technology folks to bring up Exhibit JM-1. For the record, this is the facility response plan draft.
That is a confidential document, so they cannot bring that up. Do you want to bring that up in,
Wonder
and if we go
how did
in-
I get a copy of it?
because you've signed a confidentiality agreement.
Okay. I don't need to talk about it now then.
Do you still have 10 more minutes of questions?
Let me check.
Mr. Prey, I would also suggest you mark that document confidential.
You know, I think I was going to ask that question because I think my assistant put this in here, so I don't know how she got it. In fact, I'm sure she did because I did not create this document.
I can explain. Mr. Prey may have not been here when we went through this, but that was inadvertently filed as a public document. And once we got talking about it in the room, it became clear that that needed to be confidential because it has the maps and the response, the spill issues. And so the chair granted a motion orally to deem that confidential. They pulled it off of EFS, and it was refiled as a confidential document.
All right, that's how I got it.
So thank you for clarifying.
I think that all of my remaining questions would deal with that, so I don't have any more questions.
Mr. Sandgren?
Yeah, I have a few questions. Mr. Mahmoud, first I wanted to, I guess, clean up a couple things that Mr. Prey's cross brought to my mind. you said you were operating this project at a reduced margin. I guess that brings to my mind, what's the usual margin for your projects?
I don't think I'm going to get into that discussion. You know, I think the information that we filed with Mr. Daniels was confidential during that session.
Is it substantially greater?
Again, I'm not going to answer that question.
We can come back to it in a closed session. So one of the last things you mentioned was a change in use of the pipeline to natural gas or some other substance. You mentioned that correct me if I'm wrong. You mentioned that Iowa law would require you to come back before the Iowa Utilities Board to change the use.
I believe that's correct.
Can you point me to where that's at in the code?
I don't want to be a smart aleck, but I mean, I'm sure our attorney can help you.
Mr. Sandgren, we know, and we will provide you with that information.
Sure. Would that also require new eminent domain proceedings?
Again, I can't answer, but I think you and Brett could probably have that conversation about the legality of the situation.
Sure. So we're going back. Talked about timber valuation. I guess my question. Do you recall talking about timber valuation a little while ago with Mr. Prey?
I do.
My question is, what's the process when there's a disagreement on valuation of damage payments?
Well, you know, and I'm glad you asked that question, because when I answered it very technically on how we do timber valuations from a technical standpoint in an appraisal situation. The simple fact is the majority of the land, as a matter of fact, all of the property in the 75.2% that we've closed to date, we've been able to work with the landowner to value their timber without going through a timber evaluation. So we've worked in good faith with the landowner. We've said, how much is your timber worth to you? What's the value to you as the landowner? And we've settled on those terms every time.
And is it your testimony then that you will work in good faith with those parcels you're proposing to take by eminent domain?
We would in that case, because it's a legal proceeding and under a compensation scenario under the Iowa eminent domain laws, we would actually, in fact, go through a formal timber valuation procedure to set the valuation for the court. So it's a different scenario when two parties can mutually agree upon a valuation. It's totally different in an eminent domain court proceeding, where we're obligated to provide the court the data for the valuation of that timber.
Sure. Can you remind me again how the valuation of the easements, how you came to the flat one-time payment?
We started out as required by the Iowa Utility Board's rules. We did a market, well, I don't know that the market study is the requirement, whatever the requirement was that led up to it, but we had to post what the low, average, and high valuation of the properties are within the counties that we cross. The way we handled that to determine the valuation is we hired some certified professionals in real estate to develop a real estate valuation of the properties that we're crossing to determine those 3 market points. And then we posted those in the paper, and those are the basis of the offers that we're making.
What direction did you provide those real estate professionals in coming up with their estimate as to the value?
I gave them our route map. Well, I didn't, but I had our folks, my right-of-way team, give them the route maps and ask them to do an independent market evaluation.
As part of their evaluations, did they consider the limitations towards future use imposed by the easements?
In the event there would be a future use limitation, they certainly did. Now, this was a generic market study, and the market study provided an average cost per acre without taking into consideration necessarily site-specific. Those would be individual property appraisals. But I will tell you, since we started, when we first had the market study done in 2014 to where it is now, the valuation of properties actually decreased about 10 to 12% in the state of Iowa. So the market value that we're actually paying above market by 10 to 12% based upon if we did the study today.
And markets are cyclical, correct?
Well, they are, and that's why we haven't changed the valuation. We're actually paying the peak price per acre of land in the state of Iowa in its recorded tracking of those type of market rates.
And if that price of land were to increase, are you going to increase your offers?
Well, I don't think it's going to increase. Like I said, it just, we're paying the peak that it ever had been. The most value per acre that the state of Iowa has ever experienced in real estate appraisals. That we just, our bad luck, we happened to do our market appraisal at that time.
Terrible timing.
Terrible timing for us, good timing for the landowners. So they're actually getting paid 10 to 12% above current market rates today for land.
Would you agree that real estate values over time trend upwards?
I think in a normal real estate market, and I'm not going to sit here and debate real estate marketing and trends analysis in the U.S. I'm sure we can all do some research, but I think the general premise is in fact that. But Iowa experienced a decrease in land value. How do you explain that in the normal trending over the cycle of a 20-year term? There's peaks and valleys. We just happen to be in a valley right now. Do I think it will go up? I mean, my personal opinion is I hope for the people of Iowa.
Do you believe that the presence of a pipeline diminishes the value of that property to a future owner?
Not at all.
So the inability to build any buildings or the other limitations of use do not diminish the value of land?
They don't. And there's been study after study after study on pipelines that have demonstrated that that point just simply is not true. Those studies are out there on the internet. I think we may have even filed one. And maybe I'm wrong there, but we certainly have access to it. The trend has shown that somebody buying that property, they're buying the property, and the pipeline is not leading to a decision to buy or not buy. And when the person buys it, or the person that sold us that easement, the person that sold us the easement, they're compensated for that property first and foremost. If there's a devaluation for some reason, and I'm not saying always there's not a devaluation, because in certain circumstances there may be. somebody that has 5 acres and cuts it into a couple of, tracts of land, 2.5 acres a piece to sell for 2 houses, obviously has a higher market value. And if they show us that and demonstrate it, then we pay the higher fee for that land. So there's circumstances where we would compensate somebody for a devaluation if we're aware of the devaluation. But long term, once that deal is done, it's just been shown in more market studies than I can count that trend is not true.
All right. I guess now we'll jump into my questions. So, and this is stuff we kind of had already covered earlier in the day, but I just want to go back and touch on a few points. On your reply testimony, page 3, line 10. It's correct to say that one of the purposes of your testimony is about providing ample financial protection for state subdivisions and individuals. Is that correct?
Let me read, I think, what you're looking at.
Sure.
Starting on line
It's number
10.
2 there.
Yeah. Dakota Access and the industry-funded oil spill liability trust fund provide ample financial protection such that the state subdivisions, and individuals would not bear the cost even in the unlikely event of any kind of discharge.
So, are you aware that the Iowa Constitution contains a provision prohibiting the state from becoming a creditor?
I'm not.
You rely on the oil spill liability trust fund. I believe later in your testimony you characterize it as the ultimate backstop. Is that correct?
We read it earlier today. It backstops. It certainly provides some additional protection.
Sure. Let's go to page 8, line 3. Now your testimony here on line 3, finally as an ultimate backstop, that wasn't my characterization. That's your characterization, correct?
Well, yeah, now that we're reading it, I didn't deny it wasn't in there.
So, I guess let's talk about the liability trust fund in the OPA 90. That's administered by the Coast Guard, correct?
Open 90, or the oil.
Sorry, the trust fund itself is administered by the Coast Guard.
Yes, it is.
Correct. And if I could have the technology desk pull up Exhibit 2. And then distribute. Thank you.
Mr. Sandgren, is this a witness or is this an exhibit we have?
I've given paper copies to be distributed.
So is it Sandgren Exhibit 2?
It is
Cross
Sane Cross Exhibit 2. No, just 2. Correct.
Could you please repeat that for me?
Yeah, it's Sane Cross 2. SEHN Cross 2.
Thank you. Sorry.
Mr. Mahmoud, have you seen this document before? It's an excerpt of a larger document.
I'm sorry, my mic was off. I said no.
Thank you.
You bet.
From the cover sheet, would you agree that it appears to be published by the U.S. Coast Guard?
You know, I'm not going to verify that. I mean, it says it on here, but unless I did the research, no.
Sure. Let's go to page 2. Now, I believe you had testified earlier that you're familiar with OPA 90, correct?
I'm pretty familiar with it, yes.
Okay. So I just want to walk through what a qualifying claim to the liability trust fund would look like.
Okay.
There at the top of the page, there's 4 bullet points, and it states, the following must be true. With your knowledge of OPA 90 and the trust fund, the incident has to occur on or after August 18th, 1990. Is that true to your knowledge?
If I pull up Open 90 and have the regulation in front of me, then I'll verify that. Looking at this piece of paper, you can read it as well as I can.
Sure. So as far as reading it, would you read the last sentence of bullet point 3?
Spill that impacts or potentially impacts groundwater, but not the navigable waters of the U.S. is not an OPA spill.
So if something's characterized as not an OPA spill, would people be able to make claims to the liability trust fund?
I believe they would, and I mentioned earlier that there have been claims made, and I know I'm overgeneralizing what you just asked, but that have originated in agricultural fields. So I think, just reading this, I think what they're distinguishing here is groundwater versus navigable waters of the U.S., which are not the same.
So a spill into groundwater would not be covered under the trust fund.
That's exactly what this says. A spill that impacts or potentially impacts groundwater, I'm just going to skip the but, is not an OPA spill.
Okay. Are you familiar with the navigable waters of Iowa?
I'm not enough to talk intelligently about it.
Would you agree that there are areas in this state that a spill could infiltrate groundwater but not navigable waters?
No, I like I just said, I'm not familiar with their definition.
I believe your testimony earlier was that you're pretty familiar with OPA 90.
I'm familiar with OPA 90. I'm not familiar with Iowa state law in regards to navigable waters.
My understanding is that navigable waters would be a defined term under OPA 90. Is that correct?
That's a good question, and I don't know what your understanding is, but I can tell you under Open 90, the reference is back to the Clean Water Act for navigable water, and I think there's some litigation that's pending upon what a navigable water definition is in the United States. It's different from what's inside what's called the Rivers and Harbors Act versus what's in 33 CFR, I think it's 128, for the reference to the Clean Water Act that defines a water of the U.S., something like that. But I'm not sure what the legal definition is in the state of Iowa.
Sure. I'm done with that exhibit, if you'd like to pull it. So I want to talk in general terms about oil spill response. My understanding through testimony presented earlier at this hearing is that local officials would be responsible for securing a perimeter around any incident. Is that a correct statement?
That's generally the first responders' primary role in responding to an emergency with a pipeline is to secure the perimeter to protect the public and private property.
Sure. And throughout this process, I've noticed there's much interaction between Dakota Access with all levels of government, federal, state, local. Is that correct?
Yes, sir.
And would you agree that oftentimes local authorities have a better understanding of their specific area than the Dakota Access would?
I don't know what your reference is.
Just in general.
I don't think I would generalize it that way, no.
Would you agree that local authorities have specific knowledge as to their capabilities?
Yes.
And that specific knowledge is better informed than Dakota Access, the company's knowledge of their capabilities may be?
Objection, Your Honor.
Please state your objection.
And I understand your point earlier about with Mr. Mahmoud, you were going to give some leeway. But again, this line of questioning was explored at some length with Mr. Stam, who had talked about the local response capabilities and their role. And I don't recall anything in that discussion being kicked over to Mr. Mahmoud. So I sort of asked and answered in the broad sense of that we've already gone through this with the appropriate witness on it.
You're better than me on knowing what all wasn't passed over to Mr. Mahmoud. Mr. Sandgren, do you believe this issue was kicked over to Mr. Mahmoud?
I believe it.
Mr. Sandgren, do you want to attempt to rephrase your question and see if we get an objection in the next manner?
No, I believe this goes towards the FRP, which is an exhibit sponsored by Mr. Mahmoud, is it not?
Yes. Which then leads to the question of whether or not
I'm not going into specifics.
I'm going to overrule you. You may proceed.
Would the court reporter read back the last question?
And we've provided you with a mic of your own. You're going to have to. Yeah.
The question was, and that specific knowledge is better informed than Dakota, the company's knowledge of their capabilities may be?
Would you like to rephrase that question?
The specific knowledge of the local government units is better informed than Dakota Access's general knowledge, correct?
Mr. Sandgren, try one more time.
Sure. Local governments may have specific knowledge of their circumstances that would be better informed than the company's knowledge in a general sense.
Yes.
Sure. So I want to go back to what we talked about earlier as far as fire and police, EMS, the first responders' primary role as a securing a perimeter for public safety and property. My understanding is that Dakota Access has committed to providing some sort of training for these first responder organizations. Is that correct?
We have.
How frequent is that training?
Depends on the need of the first responder organization. Some need more, some need less, but probably no more than once a year.
Is Dakota Access providing any equipment to these first responders?
I am unaware of any commitments in the state of Iowa. In other states, we have.
What are those instances?
One of them's in North Dakota, where we cross a Native American tribe that has no emergency response equipment, and we're providing 100% of the emergency response equipment.
Sure. I'd like to bring up, it's labeled SEHN Cross 1. Please distribute it as well.
Thank you.
We're actually only going to be looking at the first 2 pages. I just included the last 6, so it was a complete document. Have you seen this document before, Mr. Mahmoud?
No.
Does it appear to be minutes from the October 21st meeting of the Boone County Board of Supervisors?
I don't have a clue what this is.
Have you had any interaction with the Boone County Board of Supervisors?
I don't believe I personally have.
Why not?
Well, because I have people that do that.
Okay. So, on page 2, beginning middle of the page, starts with resolution number 2015-33.
Yes.
Are you familiar with this resolution by the Boone County Board of Supervisors?
No. I've heard of it, but I've never read it.
Sure. So, the, let's see, it would be the 5th whereas there. Line, whereas Boone County, they talk about that they do not have resources sufficient for first responders. Are you aware that is a concern that's been raised by Boone County supervisors?
Well, I can read that here, but I can also tell you that I sent our operational team into Boone County and met with the first responders who did not say this. So somebody, whoever drafted this, making a statement like this, we went to the source of the first responders who didn't indicate this. So I think I would lean more upon them than I would some resolution that I'm not sure what the validity of this is.
A resolution from the body that gives the budget to the sheriff's office?
Again, you're asking me questions about something I don't have any knowledge of.
Sure. Are you aware that the Jefferson County Board of Supervisors passed a similar resolution?
No.
Are you aware of any resolutions from Board of Supervisors in support of this access, this pipeline rather?
No.
But you still agree that local government may have better information as to their specific circumstances.
Well,
Objection, Your
now,
Honor,
now I understand.
asked and answered.
Do you want to answer?
I can, yes, ma'am. Sorry
Far
about
be
it.
it for me to object to my witness's answer.
It makes it easier for me. Thank you, Mr. Mahmoud.
What I was going to say is now I understand where you were trying to get to, and we set out on a mission, and we met with every emergency responder in every county that this entire project crosses. And I'm not talking about just going to meet with the local fire department chief and saying, "Hey, bud, how are you doing?" We met with every one of them: police, fire, ambulance, first responders, emergency preparedness. We had those meetings. It took us 3.5 months to do that.
Sure.
And every one of them, we asked the question, what kind of information and what kind of materials or what kind of data, what kind of equipment do you need to support a project like this in the event that it goes through? And would you guess how many of them requested something? None. So you know that. Nobody did. Now, we've made the offer, and we stand behind that offer. If Boone County needs something, we're going to redo those communications again, by the way. We're going to do those this summer, summer 2016, prior to operations as part of our outreach, because we do that outreach on an annual basis. If there is a circumstance where a community is just like the 3 affiliated tribes in North Dakota, was unable to protect property and the public from a response or from a spill, then we as corporate citizens will absolutely ensure that that equipment and training is in place. That's a fact, a guarantee, and a promise. So do I think that a county has better knowledge about what they can do and not do in the circumstance of a crude oil pipeline? No, I don't, because most of them simply are not educated about a crude oil pipeline enough to understand what they need until we have that active dialogue. So I think you misled me in your questioning. Do they have better knowledge than we do? Because simply they most of the time simply do not. So I retract my previous answer to no.
I believe earlier you said that it would, I believe your words were it would behoove everyone to stay on track, or I'm sorry. What were you talking about then?
Well, it's to everybody's benefit to stay on the schedule that we've outlined to ensure construction occurs during the best conditions of a given year. And in Iowa, I think most of us know this, the most opportune time for construction outside of the winter in the wet spring is from late spring through fall. That's our target, to take advantage of the best weather conditions to minimize impacts to the environment.
So the benefit to, I'm sorry, strike that. I believe we talked about it earlier. Does Dakota Access have firm commitments to enter operation in 2016?
I don't understand the question.
Do you have commercial obligations to commence shipping oil through your pipeline in 2016?
Well, I think Damon answered those questions, and we have an obligation or an internal desire to start those to start those shipping contracts with those shippers to meet their, whatever their needs are. You know, and that kind of gets back to what I just said about the, minimizing impacts to the environment. The other thing I haven't really said, and I probably should have, is we've made a commitment to all the landowners, as best we can commit, that we're only going to impact them for one growing season. We don't want to extend construction into 2 growing seasons to impact these folks' livelihood or lives more than we have to. So that's a commitment we made, and that's probably more important to us at this point to live up to that obligation, because we do have some flexibility on the backside of the contracts.
Sure. I'm glad you brought that up. So, if construction could not be completed entirely in the 2016 growing season, Dakota Access would postpone construction to 2017 when they could complete it all during one growing season?
No, I'm not saying that. We will commit to doing what we can do. So there's a lot of factors that go into that decision. But we have given our commitment that if we can make this happen, we will start and finish in the same growing season. So we have to work with the IUB to get the permit, have to get our permit from the Corps of Engineers. Everything's on target to accomplish that. Without predicting the future or putting words into regulators' mouths, I can't guarantee that. But what I have committed to is that if all those things line up and all of our planning lines up, that we will not drag out construction beyond one growing season at will.
So if they do not line up, if you do not receive your permits, which my understanding is there's several pending permits, is that correct?
There are.
Would you then forego construction during the 2016 crop season and build only during 2017?
No.
Why not?
Well, I think it would change our construction plan, number one. We would probably have to develop a winter construction plan to contemplate those conditions. I mean, we would move on and construct during that period of whatever period that we were given to work within.
So the best for Dakota Access is that this permit be granted with all due expediency, correct?
I think that's best for Dakota Access, and I think that's best for your clients and everybody involved in this process.
What about the 24.8% of people that are subject to eminent domain grant?
Well, I mean, I certainly hope we close. A lot of those folks have indicated as soon as you get your permit, we'll sign an easement. For whatever reason, they don't believe the some of the board rules that they have for negotiation. That's fine. A lot of folks will close. Are we going to have 0 condemnations? As I previously mentioned, we don't like to use eminent domain as a company. The fact is, on a project of this scale, to build a project 1,168 miles, it's impossible to do without eminent domain. Now, I would like to think in a perfect world that we could negotiate our way through for every landowner to make everybody whole and happy along the way. We've been able to be very successful in other parts of the country of negotiating easements voluntarily where we have not had to use the right of eminent domain, although we had it. So in this case, although I would like to say we're going to settle with everyone, I think certain folks have made it pretty clear that we're not going to be able to do that.
I think Mr. Murray asked you earlier, so that 24.8% of tracts that are not under a voluntary easement, what sort of mileage does that entail?
It's about the same.
Proportionate.
It is.
So it's about 86 miles across Iowa.
I don't have my calculator in front of me, and I hate to get it wrong on the record.
It's the total tract through Iowa is 347
I believe that's right. I mean, if you give me a second offline, we can get the exact number, but I'm not going to do it on the stand.
I'd be happy to give you a second.
Your Honor, are we really going to slow this down just to do a mathematical calculation? The numbers are in the record to brief it if he has a point for it. And it's asked and answered. We've talked about the percentages. We've talked about the mileage.
Mr. Sandegren, I'm sustaining. You need to move on. But I would also ask Mr. Mahmoud, when we're on dinner, if he would provide Mr. Sandegren with the number. Thank you.
Sure. I believe the rest of my questions will need to be done in closed session.
That works well then. We're going to recess. We're going to work to come back by 6, and we'll continue from there. We are recessed. right.
a joke about that, but I think we all know he's here.
Yes, we definitely do know that. Everyone should have received, we're still off the record. Everyone should have received a witness list that includes through December 7th. Mr. Sandegren.
Yes, Your Honor. I'd like to offer what have been previously marked as SEHN Cross 1 and SEHN Cross 2 into the record.
Are there any objections?
No, Your Honor.
Hearing no objections, they are admitted. Mr. Puntney.
Thank you. I'll try and make this as painless as we can. I've got a number of questions and a number of exhibits to flip back and forth through, but I think they're all pretty straightforward. At page 2 of your document, I'm sorry, page 9 of your document, line 5 and 6, you refer to the OSLF trust fund. And my question is, and I think I know the answer already, at page 10, the following page, line 14 through 18, it appears from those documents that we actually are talking about the backstopping part being a large amount, and then there's an additional $350 million that's attributable to DAPL before any backstopping by OSLF occurs. Is that a correct restatement?
That's generally true, yes.
Okay. In terms of the, and I think again, I've got two different reference points here, but when you're dealing with landowners and I'm talking both on a voluntary and involuntary basis, future use of the property or as development, I think initially when it was discussed, future use was not an issue, but if I heard you right on the notes I just took, in some cases, future use of the property may be an issue for fair market value. Is that a correct restatement?
I think, yes, what you're referring to, and so the context of the two conversations was, the first context was, does the pipeline devalue property? And my general answer to that is no.
And do you have studies you can produce to that effect?
There's some on, it's actually for a gas pipeline. It's called INGA, Interstate Natural Gas Association, has actually a couple publications. I believe the AGA also does. They're readily available on the internet. If you just do a search, you can get to it pretty quick.
How about for oil pipelines?
You know, I don't know for sure, but I know the FERC one, I'm sorry, the INGA one, and I can't remember about the, I think the AGA, I don't know if they contemplate all pipes or not. I know INGA is coming out with a new study that I believe covers all types of pipes. I haven't seen the final study yet, so I can't say. That was the first context. The second context was in the event that the property owner does have real development plans, and I'm not saying, you know, that happens. I can think of a couple circumstances on this project that has happened, and we certainly will compensate that landowner for that lost development opportunity if we were not able to move that pipe. We may buy the property or pay for, recover for the individual's loss of that potential development.
Okay, so that's case by case, property by property is what your statement is?
Yes, sir.
Okay, thank you. I think you stated, and this may be a slight exaggeration, but you had 3,000 items to get done for the project. Was one of them coming to each of the states and talking to the landowners who potentially were going to be affected by this?
Absolutely.
You did have a meeting with landowners in the state once you determined a probable route?
Yes, sir.
When was that, and how was that announced?
We actually, in Iowa, it's required. We had a host of meetings that we published in the newspaper that were actually led by the Iowa Utilities Board.
Okay, you're talking about the informational meetings.
Yes, sir.
Okay, I'm not talking about the informational meetings.
Correct. In the absence of informational meetings that are required by statute, in the other states, in Illinois, South Dakota was actually required, in North Dakota, we did have open houses for individuals. In Iowa, it's prescriptive on what we have to do. So simply, we weren't allowed to have just an ad hoc open house meeting outside of the Iowa Utilities Board process.
Why
We
not?
said,
Why
well,
not?
it's their rule.
Oh, are you aware that other acquiring agencies, I'm speaking of railroads and DOTs and things like that, often pre-announce their projects and hold meetings with potentially affected landowners to get some input?
No, I'm not. I don't work for those industries.
Okay.
I can tell you what we did here and what the rules stated.
All right, but you did not come to Iowa prior to that informational meeting in December or whenever it was held?
Well, we did. We consulted with the various state agencies, not with the landowners. I will agree to that.
Okay.
But we did even have a pre-meeting with the IUB to solicit their advice and opinion on how we needed to move forward. And they spelled out their rules very clearly and gave them to us. And so these are the rules you have to follow them, and tell us how you're adhering to these things as you go through them. And that's in fact what we did.
Can you pull up RLH number 1 as an exhibit? I have trouble reading this with my glasses because I can't read all this, but I believe this is a copy of the standard easement agreement that you have been presenting to people. Does that look like that is correct?
Yes, sir.
Okay. Can you show me on that document anywhere where there is notice to the landlord to terminate tenants because of the route or the easement agreements?
No, there's no such thing.
Okay. Do you know that tenants in Iowa under landlord-tenant law have to be terminated before September 1st of every year, or else they hold over on the same terms as the previous year?
I don't know why anybody would terminate a tenant arrangement because of our activity.
You don't think your activity affects tenants?
Well, I don't think it negates an easement.
You don't think your activity changes the use of tenants that tenants have of the farmland?
I'm not privy to their contracts. In general terms, I would say no.
Okay. Have any landlords, to your knowledge, terminated their tenants because of the easements they've signed?
I'm not aware of that, no, sir.
Okay. Do you know that under Iowa law, landlords only have a right to inspect and repair after 9/1? They do not have a right to dictate how the land is used?
Objection, Your Honor.
I'm asking a
Hey,
question.
Calls for a legal conclusion, and the witness has said that he's not familiar with Iowa tenant landlord law. He's not, that's not in the scope of his testimony.
He's the right-of-way person, isn't he?
He is adopting parts of Hoyer's testimony pertaining to easements. The right-of-way person was Mr. Johnson, but neither of them are professed to be an expert on, a lawyer in tenant landlord law.
Okay. Do you know that 80% of Iowa land is rented to tenants?
No, sir.
Okay.
There's
Do you know if the easement, if anywhere on the easement form that we have here states that the IUB permit is granted for 25 years?
No, I don't believe it does.
Is that information given to people who sign the documents?
They were provided a packet, information packet, in the mail out, when we first did our mail outs. that had the board rules, which did in fact disclose the limit of the term of the approval.
Can you explain how it did that? Was it just a reference to the rules, or was it an actual explanation that said this permit is only for 25 years?
We printed the rules and gave them to everybody. We mailed them, and we also had them at our information meetings.
Do you have, can you explain why there are two different easement forms or documents out there?
Sure. We had been working with the base form for, I don't know, maybe half the year. We had a conversation with Mr. Murray. I guess it was mid-year. I don't remember the exact date. Maybe it was early mid-year. And we had talked to him about certain things that his landowner group was looking for. I personally went and met with Mr. Murray. And we developed some recommendations. So he and our attorney, Mr. Dublinsky, and Keegan Piper, they worked to create the modified form.
Okay.
And then we had so, you know, as I shouldn't have said, we didn't have any open houses. We had up in Storm Lake, we had an informational meeting with Mr. Murray's group, specifically to go over the terms of the easement at the suggestion of Mr. Murray. Unfortunately, not as many people attended as we hoped, but we did in fact try to make that outreach. So we developed those terms for his group in an attempt to negotiate in good faith for some of the provisions that they were looking for. So that generated the second base form easement. We're happy to start with that form with anybody. You know, we've again signed 75.2%. That's hundreds and hundreds of easements.
Can you explain the difference between the two forms?
The basic difference is, and I'm probably going to get it wrong, I'd have to ask Lisa some of the, I just forgot what they were, and I knew this, but I probably knew it this morning before I just spent the whole day up here.
For the board's information, can you tell us where the other easement is? Is that in Nyla's? Do you?
Your Honor, it is not in the evidentiary record that I am aware of. It was attached to a comment or an objection, and I don't recall off the top of my head whose, but for the board's convenience.
So it's not part of the records, which is why I wouldn't be able to find it.
Correct.
All right. Thank you.
There's very minor differences. One of them is an insurance provision. I'm trying to think through what the other ones are, but I think there's 4 differences, and we can figure those out maybe at the next break, and we can get back to it.
Okay.
But where I was going is we can use either form as the base form. As we've negotiated hundreds off of those forms, where that's a starting point. We created the form for the Storm Lake group because those were the terms that were important to them. I think the other thing was a signature page. They're starting to come to me. So we agreed to do that, and some people prefer those provisions, some people don't. So, but we're very open to either form.
So since we have 2 different sets of easement forms out there, are you going to make any attempt to unify all of the easements prior to starting construction or as part of this operation?
No, we're not.
Okay. I'm just going to ask a general question first. Under the AIMP, it's been stated that landowners will be able to bank more than 24 inches of topsoil where, you know, there's more than 24 inches of topsoil there to segregate the various profiles.
Yes, sir.
Is that something that is going to be directed by DAPL with the operational folks to ask questions about that, or how is that process going to operate between landowners and the operational folks?
The operational folks are not involved in construction, so they come in after it's constructed.
Okay, I'm talking about the pipeline builders.
The-
When I say
the-
operational
The
people.
contractor then.
The contractor,
Okay.
yes, yes.
So on our alignment sheets, we hired Aaron and his company. There's actually two companies that we're working with from a soil standpoint. We've hired them to identify and delineate zones of significant topsoil depth. And in those areas where there is topsoil that's more than 12, 14, 18 inches, then we've actually had a lot of those conversations with the landowners. And if we need to topsoil segregate deeper than that standard depth, then we will,
How will those decisions be made on a property-by-property basis?
by communication.
With
The landowner.
landowners?
Yes, sir.
So before you construct, once you send notices out, before you start the construction process, there's going to be some kind of a meeting between the landowner and who?
It's already occurred in 3/4 of the land. So the majority of the landowners have already had those communications. It's the remaining quarter that we would love to have those conversations so we can get that into our plan right now. And we would love to do it.
But once you get through the Exhibit H process, there will be some kind of a meeting between the landowners and whoever your construction person is to discuss those kinds of issues? Is that what you anticipate?
No, Mr. Putney. Unfortunately, that's the negative part of an eminent domain proceeding. If you go through eminent domain, the landowner, unfortunately, foregoes certain rights that they would normally have the ability to negotiate. Then it's up to the courts to resolve those decisions.
Okay. When you fly the route, do you have the capability to use infrared to check on the pipeline?
Oh, yes, we do.
Okay. Would that infrared flight be able to peer through trees or forest to see if there's some kind of a leak underneath there?
So the infrared technology is really meant more for natural gas pipelines, by the way. I'm not aware of anybody that's using that for crude oil pipelines, and there may be. I know we're not as a company. We do definitely use that for natural gas pipelines as a pretty common tool.
So you're not using it to fly the oil pipelines, you are using it to fly the natural gas pipeline?
That's correct. It's
Okay.
not as effective for crude oil pipelines at this time.
But would that be available to fly over a route such as a forested area where a pipeline was underneath that?
That's correct. It happens today. It's looking for a specific heat signature.
Right, okay. So it would be possible to use that in a forested area and not necessarily disturb that forested area if the pipeline was underneath it?
No, that's not accurate. It can penetrate certain amounts of canopy, but to use that in lieu of the visual observation that you get is certainly something that I would not recommend or agree to.
Okay. You mentioned a term called frack out. What was that in reference to? Do you remember?
Yes, that's for a horizontal directional drill. So when you're drilling, and I don't know how much you know about directional drilling, so forgive me if I become too basic when I explain this, but as you drill, you're asserting a certain hydraulic pressure. As you're pumping fluid, the bentonite clay and water mix into the hole, and as that hole is being cut, that bentonite clay mix is under, again, a certain pressure that sometimes there will be a release because it follows through a crack or, say, a gravel zone or something like that. Typically, the bentonite clay forms a seal inside the hole, but not necessarily in all cases, and that's when you get a frack out.
And what is the result of a frack out?
Nothing. I mean, it's bentonite clay. It's a natural substance, and bentonite clay is the most pure form of clay. I don't know what the percentage is. It's 99.9 something percent. So it's a very fine clay particle. It's very slick. So if you've ever felt bentonite clay, people use bentonite clay in pottery when they're making pottery, because it has a good structural base. It holds together very well. It's very slick and very fine, and same stuff that we use.
If your route could be changed to not cut through thousands of tile, would you, especially in the prairie pothole area, would you consider a change?
If there is a route through the Midwest part of the United States that doesn't cut through tile, of course. Unfortunately, there's not.
I'm not saying all tile, but if it could avoid the major portions of the tile issues, would you consider that?
Well, unfortunately, I think I probably know that there's more tile out there than what's assumed to be just along this route. There's tile all over the state, all over this country. So I don't think that's a fair assessment, because moving from one area to the next, you're transferring impacts from one to the next. The arguments will still be the same.
In the case where you have tenants, as I mentioned, farming, and they now have crop loss claims or other issues relative to repairs to the line that you guys just, worked on, how are those to be handled?
And I may get part of this messed up, but I believe in Chapter 9, is it Chapter 9? Well, I guess I can't ask the question. In our AIMP, there is tenant language. The tenants are specifically protected. If there's an agreement in place, we deal with the landowner directly. But if there's a contract in place between a landowner and a tenant, then that tenant has certain rights, and we'll compensate that tenant for damages, basically. The damages would go to the tenant as opposed to the landowner.
So would the tenant file the claims directly to and through your contact person, or would they have to go through the landowner?
Again, it depends upon the contract they have with the landowner, but they certainly can make direct claims if they have a legitimate claim to it.
There's a lot of discussion in the AIMP about Section 6.11, and in the course of that discussion, my understanding was, and this had to do with the filing of tile plans, especially with the eminent domain folks. My understanding from that discussion was up until the time that a compensation committee or some other body made a determination on the Exhibit H, you were going to allow the tile plans to be filed. Is that a correct recitation?
It is, and I don't think it's that I'm going to allow. I believe that's required by statute, so I don't think we have a choice in the matter.
Okay. Well, here's my question. Assuming that's the process, and I don't know that's correct, but assuming that that's the process that we go through, isn't it likely that notice is going to come out either in letter form or electronic form or something to the landowners? That I doubt the decision is going to be made the day of the notice or day that the hearing is held for that sort of thing. So isn't it likely there's going to be some time period before that notice comes out to tell both you and that eminent domain party what the results of that commission is?
I guess I'm lost on what notice. I'm sorry.
The notice that they're going to agree with you to do eminent domain on that property.
Well, so I assume, and I apologize for not following your entire chain of thoughts. You're talking about the board?
Yes, the board, the compensation board.
Well, okay, the compensation board is secondary to the IUB board.
Okay.
So we will get the grant of eminent domain from the IUB board.
Right, but
the compensation board grants the compensation.
I understand that. Well, which is the time period for the tile plans to be submitted? Is it when the IUB grants it, or is it when the compensation committee ends their deliberation about compensation, and therefore, the parties then have a choice to accept the compensation or go to court? Which is the time frame for submitting the plan that you were talking about?
In my opinion, and I have not had this conversation with Brett or Keegan. In my review and quick read and understanding, the easement becomes effective once the compensation board certifies the damages or payment.
Okay.
That's when the easement would then initiate. And I believe that that's what the code requires. I'm kind of putting myself out there on a limb. That's probably a better question for a real estate attorney to answer that question directly.
No, I understand that's what your position was. That's why I was asking the question is, once the compensation committee has determined the value, which is when you say the easement then starts, okay? Assuming there's some kind of a notice requirement then that goes to the party, the landowner in that particular case, shouldn't they have some time then to submit the plans to you?
I would say no. They've already had close to a year and a half to give us those plans. I don't know what a further delay benefits anybody.
In terms of the language that is in the voluntary or involuntary easements, the eminent domain easements, either one, doesn't it become permanent against the land in terms of an easement that's a perpetual easement?
Permanent in the sense of?
The language that's contained in those easements?
It is a permanent easement,
Okay.
yes.
So assuming somewhere down the line you were to sell or transfer or do something with the pipeline to someone else, if there is language in there that grants the right to put in valves or the right to have access or some other, rights that were not exercised by you, isn't that a detriment to the landowner given the fact that somebody else can then come in and use those same terms to change the route and make some changes?
The rights are the rights. So I think ownership is sort of irregardless of the right. So as long as the right prevails, it doesn't matter who the owner is, then anybody that has ownership or control over that easement would be able to exercise that right. So that the way, I think I explained it earlier, taking up land for a valve that's unnecessary is not going to happen. We just don't go put valves out, or nobody else just goes and puts a valve on somebody's property just for fun. So
Right.
I think there would have to be an actual need to do that, and then I think in that case, then there would be a valve that would be placed. It doesn't matter if it's Dakota Access or somebody 100 years from now that may be called, Iowa Access. I don't know.
Would that require them to go back through the IUB?
I don't think so.
Okay. You stated your goal is to not have the trench open more than 14 days, and I think Mr. Frey has amplified that 20 miles or whatever it might be during that time period. Mr. Frey testified that this could actually extend as much as 3 months. Can you narrow that scope somewhat?
Sure. So that's our goal, is 14 days. The construction period from the time we start clearing the right-of-way, where we may start the topsoil segregation, to the time that we're, in fact, executing restoration, could be as long as 3 or so months. The time that the ditch is open is significantly less than that time period. We try to have the ditch open 14 or so days. If it gets much more than that, then we start to push onto the contractor, hey, you need to start closing that ditch, just because we don't want the exposure of that ditch being open.
So if a tenant needs to get through to a bisected part of that property, will he be able to do so once the ditch is closed, or will he have to wait until the entire project is done?
No, if he has the landowner or tenant, whomever, has a need to cross over that pipeline, it's just a simple communication, and we can create a crossing for that purpose.
Okay. At page 15 of your reply, lines 1 to 3, again, we've covered this somewhat, but are you aware that ethanol is being made from more than corn?
I am.
Okay. So you've heard of sugar cane being used?
I'm not too sure how much sugar cane is being produced in Iowa, certainly in Louisiana and Florida.
Are you aware that Brazil uses sugar cane to
Sure.
produce it?
We're
And
talking about Iowa, though.
I understand that, but I'm just talking about fuel and that sort of thing. Okay. Are you aware that compressed natural gas and liquefied natural gas is now making its way into the truck fleets and the bus fleets and cars and those kinds of things?
Well, I think there's certainly a use of CNG, and there's more CNG applications than there are LNG applications. So I worked for an LNG company for 3 years full-time, 3 years as a contract person. So I'm actually pretty familiar with the LNG industry. And I would say no, that's simply not true. It's been tried and failed. Houston, Texas, where I'm from, attempted to use LNG for its Metro bus system, and it failed, and they went to CNG and or back to diesel. That's a common theme for LNG fleets.
Okay, but you're aware that the 3 major truck manufacturers all offer, natural gas as an option in their light pickup trucks?
Which ones are you talking about?
Ford, Chevy, Chrysler.
For CNG,
Yes, they
Yes.
all offer it as an option.
they do, but I don't think that's it's a very prevalent or sustainable use at this current time.
I'd like to ask you a general question that actually came up as part of an objection that was filed by another landowner. This had to do with land that was terraced. And there was a question that was raised about the depth of the pipeline going through terraced land. Do you have a stated preference in terms of how deep that pipe will be buried for land that is not terraced but will be terraced soon, as opposed to land that is terraced? Is there a difference in how you would deal with those two properties?
There certainly is. I think I'm familiar with the piece of property you're talking about that has the terracing, and I know I've talked to my construction manager about it. For future terracing, we would like to know the depth of cut the individual is going to make to build the terraces, so we can ensure that our pipe is buried deep enough to maintain that 48 inches of cover.
Sure.
So that's something that's very important. And in that case, it's interesting, when you start talking about terracing in Iowa and the protection of topsoil, who's protecting the topsoil in that case? It becomes an interesting dynamic between a company like ours and a landowner that's terracing, who's stockpiling topsoil for terraces, but wants a topsoil segregation when they're in fact destroying the topsoil profile. So we have a lot of those internal debates on how to handle that. That's something we actively are communicating about. And as long as people communicate with us where those terracing plans are going to be, we believe our plan is going to be, we will meet a depth requirement at least 48 inches below their proposed cut for the terrace.
So if somebody had asked you for at least a 7-foot depth and was told that they were only going to be allowed a 5-foot depth where terracing occurred, you would accommodate the 7-foot depth?
If that was in fact a true statement.
Okay. And if they'd presented you a terracing plan and which showed how their proposal, again, that was enough to give you an idea of what they wanted so that you would accommodate that?
Again, and not to belittle somebody's plans, because that's not what I'm intending to do. It's a lot different to receive an engineered cut and fill plan versus a hand-drawn plan that has not had proper elevations applied to it. So if somebody, a landowner, will work with us to present a plan that has proper cut and fill to show the terracing, we certainly will design our pipeline to avoid interference with that.
So would this plan have to be produced by the Soil Conservation Service or somebody you consider reputable, as opposed to being somebody else who has a bulldozer? Is that what you're asking for?
Well, I think what I'm asking for, and certainly that would be a nice touch. I think that's something we could design against. It's really the elevation profile that we're after to understand, building terraces that are a foot high versus 3 foot high on a concept when you don't, or the landowner doesn't know the elevation of their property, has a lot different significance to us than an engineered plan that we can design against.
Okay. I think several times in your testimony today, you've stated that the navigable waters of the U.S. are related to the Clean Water Act, and that the Environmental Protection Agency was the main proponent that you were looking at under the Clean Water Act. Is that correct?
So the Clean Water Act defines what's called waters of the U.S.
Okay.
Under the waters of the U.S., there's a definition for navigable waterway as a reference point. Navigable waters were initially delineated under what's called the Rivers and Harbors Act of 1890 or 99, something like that. That's managed by the Corps of Engineers. So the definition of waters of the United States has been in recent court cases that is still being tried. And I believe, I can't remember if it's a circuit court or what, but the actual definition and how it carries across more than just the Rivers and Harbors Act. Does it apply to all federal legislation? Does it apply just to the Rivers and Harbors Act? Is there a broader standard, a lesser standard? That's still to be determined. So, but under the Clean Water Act, it makes a reference to it. So that, I know that's not a straightforward answer, but that's kind of where we're at on that particular issue as a country.
So let me see if I can clear this up so I understand it better. The Environmental Protection Agency and the Corps of Engineers have a new law that went into effect on August 28th called WOTUS, Waters of the U.S.
Objection, Your Honor.
I'm asked just that.
We've been through this with numerous witnesses, and it has been established that those rules that Mr. Putney keeps referring to have been stayed by both the District Court of North Dakota and the Sixth Circuit. And I believe that on that basis, the chair asked him to move on away from that with a prior witness.
Your Honor, the Sixth Circuit has stated only pending a determination as to whether or not they have nationwide jurisdiction. I believe they do not. They're not a court of original jurisdiction. I believe they have effect in the Sixth Circuit, just like all of the circuit courts have effect in their own circuit areas. But the law itself has been promulgated through the federal APA, and there was just an attempt to override that law that went through both the House and Senate and did not have the ability to get enough votes to pass. So the effect of the law, the waters of the U.S., is there. What has been stayed is the enforcement of the law in those jurisdictions, namely the Sixth Circuit at the moment, and temporarily, the South Dakota Circuit, and then temporarily in the Sixth Circuit, while they determine whether or not they have jurisdiction to enforce that throughout the entire United States. It is, in fact, the law of the land by virtue of the way it has been done.
Your Honor, Mr. Putney's legal opinion notwithstanding, the Sixth Circuit stay is...
Mr. Dubinsky, I'm sustaining you.
Would you pull up IA?
Sorry.
Can you pull up IA-WE-078.000?
Mr. Puntney, can you please restate that for us?
Yes. IA-WE-078.000.
Is that your property, Mr.
That is my
Punt-
property.
You already got it up.
Very good.
You may proceed.
Thank you. When you've had a chance to look at that, let me know. Okay. Can you see that the proposed pipeline bisects and that 40 acres and renders about an acre and a half unusable?
I see that it crosses in the southwest corner.
Yeah.
I don't know that it renders it unusable.
How would anybody farm that or get to use that while your pipeline is being constructed?
Well, so that's a two-part question. During construction, if that was being farmed in that area, there's two ways we can handle it. One, we can put an access point across the right-of-way to continue to farm it. Or two, we can compensate you for the loss of that acreage.
Okay.
And we would be happy to have that negotiation with you, by the way.
Okay. Are you aware that I filed an objection and asked that that be moved off the property?
Asked what? I'm sorry?
Asked that it be moved off the property?
Yes, sir.
Okay. Are you aware that I filed a tile plan and a future use plan for that property?
I'm not aware, no, sir.
Okay. And just to follow up from the questions that Mr. Murray asked, that's an inside 40. So access, again, would be from neighboring properties? Is that probable as to how you would get to that property?
It's looking at this without walking it with you to understand every facet of it. Looking at this, I would concur that would be the access points.
Okay. That's all the questions I have. Thank you.
Mr. LaShear. Oh, I'm sorry. I
That's all right, no problem.
apologize. We had your mic.
Yeah, no problem. Good evening. I'll try to make this fairly quick. I've only got a few questions. I want to get to the Iowa State basketball game, so I'll try to make this quick. And my first question is in regard to easements. Do landowners sometimes get loans from financial institutions where their property is collateral? Those loans?
Sure.
Before obtaining the voluntary easements, did Dakota Access or the company that they hired, CLS, review the mortgages that are filed as securities against these properties to ensure that they obtain the lender's consent to the filing of the easement?
We definitely try to identify lenders or mortgage restrictions on property. It's typically not an issue to overcome with a lender on a mortgage.
And how many instances or how often are you able to get those consents for the lenders?
Always.
Always.
Always. I've never not gotten one.
Okay. Interesting. In the business I'm in, the lenders would negotiate that. So do you have to negotiate those then with the lenders?
Sometimes.
Yeah. Okay, good. If yes, do sometimes the lenders, because the mortgage requires the lender's consent before an easement's filed, are there sometimes conditions that the lenders put in order to allow that easement to become a prior lien to the mortgage?
Very rarely, but I suspect that's possible.
I know in my business, we would, if I was the lender, and I do represent lenders, that we would require the landowner to pay down the loan in that amount. But does that ever happen? Did you ever experience that in your instance?
No.
Okay. Would you agree that that the indemnification that you've mentioned in the past and talking about guarantees and indemnifications in the easements, that language is different than being insured?
I think it's stronger.
You believe the indemnification language is stronger than being
Very
insured?
much, a lot stronger.
Would you agree that being a certificate holder is different than being an additional insured?
I don't know that there's a difference for what we're giving out. We're giving a certificate of insurance that we are the insurer or insured party, and we name the landowner or whomever it is as the additional insured, which means that they have rights and access to the limits of that policy that we are prescribing on that certificate.
I'm confused. In my business, I work in commercial real estate. Either we're offered a certificate holder, or we require the lender, to be an additional insured party, knowing that the difference is you don't think there's any differences between being a certificate holder and being a named insured party?
Honestly, I don't.
Okay. In my opinion, there is, having worked in that business. I was just wondering if you knew.
Okay.
That's all the questions I have.
Thank you, Mr. Lashier. Mr. Zakrasik?
Would you please pass out the exhibits? I have a Zakrasik Cross 1, and would you please put Zakrasik Cross 1 up on the display?
Have you seen it? Mr. Dublinsky needs a copy first before you put it up. Mr. Dublinsky, may we proceed?
Sure.
All right. Mr. Zakrasik?
The Zakrasik Cross 1 is for demonstration purposes. and the reason that I've put this together is because I wanted to try to get to how various situations that might occur where there was a release would actually be covered. So the first one is, so if I can just briefly explain this and then indicate how I'll use it, I think it'll be helpful to Mr. Mahmoud as I ask you questions about it.
All right. Mr. Dublinsky, recognizing that Mr. Zakrasik will be able to take the stand, I believe, testify to the fact that he created this document, are you going to have any objections to him using the same?
It depends on the questions.
I understand that,
Yeah.
but
Yeah, I mean, I think if
All
he
right.
wants to use this to start down a line of questioning with Mr. Mahmoud, I have no objections to that.
all right, proceed.
So the first column is the root cause of a release, and we'll go through those. And then the idea is that these are layers of individuals who would have responsibility for covering damages due to a release. And I'd like to try to use this to understand how those various insurance and assets would be used to cover a release. Okay? So let's just take the first one.
I'm just going to say, I'm not going to be able to do this. I mean, you can ask me the questions, but as far as filling out this table, I'm sorry. We would have to do that offline in some form of, so I can understand it. I don't want to answer something like this wrong.
Okay. So let's just try a few of the questions. They're pretty straightforward. The first one is, and if you look at it at Zachrasic Cross 2, you'll see that that is Iowa Code 480. And if you go to the very last page, it basically says that a farmer, his employees, or a tenant or family member are not responsible if they're following 480 and there's an inadvertent destruction of the pipeline causes a leak.
Your Honor, I am going to object.
I thought we'd get further, but
Yeah.
may I assist Mr. Zachrasic? I'm going to assist Mr. Zachrasic. Mr. Zachrasic, so set aside your document and ask the questions straight out that you're wanting to know. I'm familiar enough now with your questions that I think that if you ask Mr. Mahmoud and he knows the answer, he can answer it. So what is the question that you want to ask him?
In the case where there's an inadvertent damage to a pipeline by a farmer, what liability would the farmer have?
None.
In such a case, there were damages as a result of this spill. What liability would Dakota Access have for paying those damages?
100%.
100%. Okay? And in the case a farmer, through recklessness or wanton disregard, damaged the pipeline and they had some assets, would they have responsibility for damages up to the point of their assets or insurance?
I think what you're getting at is if they willfully damaged the pipeline, purposefully went out of their way to intentionally cause harm to that pipeline and create a release. If that was the case, then that is a standard that you, assuming it's you, I don't mean to put you on the spot, but I'm using you as a reference. Assuming you or somebody on your property did do that, you would be liable under law for that act.
Would, in such a case, would Dakota Access have liability of any sort?
We would, and there's a, if you get into the OPA, there's that $350 million limit of liability before the OPA kicks in, or the spill kicks in. However, we would have a pretty affirmative action against you as the landowner to seek recovery of our damages.
In the case where I, since we're using me as an example, would have insufficient assets, covered the damages, who would then be responsible for paying those damages?
The company would initially pay, and then if it exceeded $350 million, then the company would have the ability to seek relief from the oil spill trust fund. And again, then we would make a claim back to the landowner, and what that recovery would be, I don't know.
Okay. Would the situation be basically the same in the case of a tiling contractor or terracing contractor who damaged the pipeline?
If they were under the normal course of business and they followed the one-call laws, which most tiling contractors would, and there was an inadvertent strike, normally I would say no, that they would not be liable. However, they could be subject to some liability if they failed to follow the one-call markings.
Okay. In the case of an act of God, so this is something flood, earthquake, landslides, who has liability?
Again, the company would have up to $350 million, and then beyond that, we could seek recovery from the government.
Would the same be true for a wanton destruction by a random party?
I would say I don't think so. I don't think that a random party. Now, if it was an intentional act, then maybe. If it was an unintentional act, I would say no. But if somebody went out of their way to damage our pipeline, then certainly there would be some liability to whoever that person if they were ever caught.
But if I'm understanding you correctly, and pardon me, I'm being a little bit repetitive just so I remember, you're saying that even in such a case, Dakota Access would cover damages up to $350 million and then move forward. You would seek to recover those, obviously, from the individual, but you would cover those. Those wouldn't fall to the state.
We would cover the cost no matter how much it was. It's just once we hit $350 million, that triggers an ability for my company to then seek recovery from the oil spill trust fund.
Your operator, who was referred to as DEOM, in the case that there's an operator error, DEOM makes an error, it results in a release. Does DEOM have an initial liability?
The operating company is automatically covered by Dakota Access and its parents as the responsible parties.
Okay. And then in the case of gross negligence or willful misconduct by an employee of Dakota Access, how would that liability be covered?
The company is liable. We would then treat it just like any other party, and we may seek damages against that employee. But the landowner certainly wouldn't have any liability.
And in such a case, does it change what Dakota Access can claim from the Oil Pollution Act, from the pipeline spill fund?
For a employee cause gross negligent or willful misconduct act, that I do not know.
Right. You, and I mean Dakota Access, would be willing to supply the board annually with proof of $25 million of Dakota Access insurance and specific amounts of multi-layered insurance that meets standards that the board may set for coverage and carve-outs.
I don't know. It's a tough question. I don't know what the board's rights are to require that. They have a bond of $250,000. I don't know what their ability is to require anything more. Now, I don't think we are against sharing what our policy is in its generic form. But as a condition to, I'm not sure if the board can do that or not.
You would be willing to supply the board annually with proof of direct and legally enforceable liability of the organizations backing Dakota Access, obligating their assets to at least a specified level to pay for damages due to a release.
The parent guarantee that's in place doesn't expire. Once it's in place, it's in place. So as the company is viable and in business, those guarantees survive.
Would the board need to know, and I believe they do have this, well, let me just back up, make it simpler. In the case of a reorganization, restructuring, or acquisition or merger, then in those cases, do those guarantees need to be revisited by the board in order to ensure that they're still in place and viable?
Yeah, that's a very fair question. So, and I think as the permit would renew after 25 years, I think that's a question that the board would have every right to request documentation of to prove it's operating in good standing. Now, I don't know what the legal obligation is prior to that, and maybe our attorneys or maybe somebody can figure out, or the board knows what their ability is to require that during the sale or acquisition. I just simply don't know.
In previous testimony, this was, it was indicated that DEOM will be controlling the pipeline remotely from Sugar Land, Texas, using satellite and telecommunication links. So just wanted to state that as, is that your understanding?
It is.
Okay. And then Mr. Stam and Mr. Fry, I asked the same question and they just simply didn't know. So I'd like to see if you know the answer, Mr. Mahmoud. The satellite and telecommunication links and associated network devices have been reviewed to determine if they warrant protection as critical information assets.
Yes.
Okay. Thank you. And then these questions have to do with horizontal directional drilling. The first is, how do you ensure the integrity of the pipe, the welds, its coating, and the pipeline protections applied to the pipe when you're inserting it through 7,250 feet of the bore underneath the Mississippi River?
And I'm gonna walk you through the drill, and I hope this answers your question. So when we approach a drill, we set up our drill equipment and we lay the drill pipe out in sections. We weld that pipe in a long section called a pull string. That section is the coats, or the weld joints are then x-rayed or tested with ultrasonic testing, some type of non-destructive testing to validate the integrity of the weld. Once that's done, we will coat those joints for cathodic protection. We will also then do a pre-test of that pull string, pre-hydrostatic test of that pull string. So we will literally put it under a hydrostatic test that we would normally do for the entire pipe for that individual directional drill. So we've taken 3 steps at that point to ensure that the integrity of that section is intact well before it ever gets pulled into the ground. As it's being pulled into the ground, based upon the engineering design and the type of pipe and the type of coating that we use, there is strength or pull pressure that's applied to that pipe. And as long as the driller does not exceed that pulling strength on that pipe, the engineering calculations determine or demonstrate that the integrity of that string is intact. On the coating, when the pipe comes out, you can see the end of the pipe. Typically 1 to 3 joints, sometimes 4 joints, are exposed as that drill string comes out of the ground. So that's, just say 160 feet of pipe is exposed. So we evaluate that 120, 160 feet of pipe for visual observations of damage that could occur to the coating. So the assumption is if there's damage there, then there's likely damage somewhere else. So that's how we test, or we validate that we think it was a good pull. Once we tie the directional drill into the remainder of the pipe, we do another hydrostatic test of that pipe section with the other pipe that we're putting it under the hydro test. So if it meets and passes that hydro, it's assumed to be good. And then as a last stop, we run what's called a caliper pig that looks for dents or mostly dents for new pipeline. And we run that through that drill section to ensure that the integrity of that pipe is good. So we've taken every step and every prudent step, as a matter of fact, above and beyond, because the pre-test and the caliper run with the dent tool are not required elements of construction, but we do that anyway.
Thank you.
You bet.
In your testimony on page 4, lines 19 through 20, and then there's another place, Mr. Mahmoud, on page 15, lines 10 and 11, if you can kind of hold your place there and look at the other one at the same time.
I'm sorry, what was the second
The
reference?
second one was page 15, lines 10 and 11. So I'll wait till you get there. You see both places?
Yes.
And you make the statement, Iowa is the 5th largest consumer of energy there.
Yes.
And if you look at did they hand you the Jurassic Cross 3? It just shows, yeah, that's it. And if you go to the back of that, unfortunately, this is the best document I could get, Mr. Mahmoud, but this is the Energy Information Associates site. And you can see that's in reverse order. It shows the smallest energy consumers down to the largest. And, you know, if you count it up from the bottom, you'd see that Iowa's actually the 24th largest consumer of energy in the United States. Your statistic was for per capita, I believe.
Per capita.
Yes. So would it be okay if we corrected your testimony to say that
Sure.
it was per capita?
I probably should have put that in there.
All right. Thank you. Bear with me on these last 2 questions, Mr. Mahmoud. The product that you will be transporting when burned produces waste products that include carbon dioxide, correct?
Yes.
The detrimental effects of carbon dioxide and other petroleum waste products, whatever those detrimental effects may be to our health and the climate on which our farm economy depends, will also accrue to the people of Iowa, correct?
Can you restate that, please?
Surely. The detrimental effects of carbon dioxide and other petroleum waste products, whatever those detrimental effects may be to our health and the climate on which our farm economy depends, will also accrue to the people of Iowa, correct?
Yes, they will.
I have no further questions, Mr. Mahmoud. Thank you for your patient testimony today.
Thank you.
Ms. Sorensen.
Yes, Mr. Mahmoud, on the first page of your testimony, you say that you're responsible for the day-to-day management of the technical professionals. And I was wondering, Mr. Fry mentioned that there would be a Jack Edwards who would be the project manager for Iowa. And I was wondering if you could tell us a little bit about why he was chosen or his credentials or qualifications, just, you know, something about his background since he's going to be dealing with our state.
Sure. Jack is a seasoned professional. He's actually somebody that I've worked with my entire career.
Could you be more specific as to his educational background or his experience in the industry?
He's got, I don't know his exact educational background, I'm sorry, but I know he's got 35, 36 years of experience building pipelines in this country.
So is he more of an engineer or more of a manager? You know, could you just give a little more?
Well, and I will answer the question if I can.
Okay, sure.
His experience, I can't remember how many exact years, 35, 37, as building pipelines in this country. I've known him my entire career. I actually worked for him when I first got out of college, doing routing studies while he was over the execution of the project. His role in the project is to organize, mobilize, and manage the day-to-day people that are going to be doing the surveying and the actual construction execution of this project. So he is a manager of construction and a project manager in the sense as for what my company defines. We appoint to him certain financial responsibility to track and to manage the budget for the portion of the project under his control.
Okay, and in the past, when you were working for him, was it on crude oil pipelines or natural gas or both?
He's worked on, as a matter of fact, it was on a couple of crude lines way back then, but he's worked on all pipes, refined products, crude, gas. He built one of the largest crude oil pipelines in North America that comes in from the Gulf of Mexico, called the Cameron Highway, which is a 30-inch pipeline that originates offshore and comes into Nederland, Texas.
Okay. And I believe that you stated that there's still 2 outstanding railroad easements, and I wondered if either one of them was at the Mississippi River HDD crossing?
I don't
Or if
believe
you
so.
know?
I'm not 100% sure, but I don't think that's right.
Okay, I just wanted to know. And now you mentioned that if the permit is granted by the board, that the HDD process would begin at the Mississippi River in the winter. Can I assume that that would be could be as early as February or March?
That's possible, yes, ma'am.
And at that time, obviously, the river would be frozen. Would the boring process in any way impact the river as far as like cracking or in any, would there be any other observable things to a layperson to know that boring was going on?
No.
And you have a timeline on almost everything that you do. Is there a timeline? And I know it's site specific and I know it's a little unpredictable, but is there a ballpark idea of how long you anticipate that the boring process at the river will take?
My minimum estimate is 4 months, the maximum is 8 months.
Oh. And excuse me a minute, I lost my place. Are you at all familiar with resonance waves?
Sure. I mean, not as an engineer.
Well, what I'm getting at is, and I'm believe me, it's been a long time since what minimal physics I had. I'm wondering whether there's any possibility when you're boring through limestone and along the Mississippi River bluffs, that's pretty much all it is, whether, you know, the 24/7 process would send out any waves that could be detrimental to the surrounding area.
No, I don't think that's accurate. The harmonics of a directional drill, there's been a lot of studies out there that have talked or looked at the harmonics of a drill. I'm actually familiar with one case where the harmonics or something resulted in, there was a shallow karst feature that actually, the karst feature did collapse. Was that from the resonance of the sound wave? I don't know. However, in a normal circumstance, the drill is moving at a very slow rate. It's like a corkscrew. And it's just drilling very slowly, making its way through the ground. And it's cutting and chipping away at whatever it is there. And so the likelihood of that being an issue is probably not as great as it hitting the drilling acid. The actual drilling part creates a problem in a situation where you hit a gravel section within your drill hole and the drill collapses as opposed to the harmonics of the drill.
Okay. So it sounds like it's highly unlikely, but not impossible. Would that be a fair?
Sure, I would agree with that.
And then, can you tell me where the pump station is to be on the Illinois side? And the reason I'm asking is, you know, when you're on one side of the river, the proximity of being, say, on the Iowa side of the river and the Illinois side of the river is about like being from Boone to Ames. So, you know, the questions I'm asking in regard to Illinois are actually germane to that area of Iowa.
You will never know there's a pump station on the Illinois side with that river in between you.
And, but even though I wouldn't know, can you tell me roughly how many miles inland it might be?
I believe, no, I can't. I mean, I can.
Oh, no, that you know, if you don't know, that's, you don't know.
I don't know.
Okay. And now, can you tell me, there was recently an article in the Keokuk paper, and I haven't had time to read it thoroughly beyond the headline, but it was in regard to a 500-foot easement on the Illinois side of the river that was supposed to go to Patoka. Do you know anything about that? It's in regard to the Dakota Access pipeline.
Well, I think I would know about that because I would have to approve the money for it. So no, I don't think that's accurate at all.
So it has nothing to do with like hooking up with another pipeline or
No,
anything of that sort?
absolutely not.
Okay. And was there an alternate route to cross the Mississippi considered below the Keokuk Dam so that there would be absolutely no threat whatsoever to the water supply of the town?
Well, when we looked at the crossing of the Mississippi River, and actually we have a map. Can we bring the map up? Is that appropriate?
If it can assist us.
I think so. Yes, ma'am.
Marie.
Yes, I had a suspicion we were going to talk about the river.
So, Mr. Mahmoud, this is a Dakota Access map that has the river, and then tell us what the green shades are.
Okay. The green shades are parcels of land where we have secured a voluntary easement. The yellow outlines are individual parcel numbers. The blue line, and it's got some mix orange, is the center line of the pipeline.
Can I infer from that that the final segment is not, is under threat of eminent domain?
On the
Iowa side,
on the
yeah.
Iowa side, I believe that is that a Exhibit H? I'm having to ask. I'm sorry.
Then that's.
And
I'd rather have the correct information.
And I believe the chair asked this yesterday, but yes, there is an Exhibit H filed to the best of my knowledge on that parcel.
And I know it doesn't show the dam, but what this does show in your property, if you can move the pin straight north, keep on going. Keep on going. This forested area is your property. Is that right?
I think we're a little bit lower, but we are forested area. I think we're more. Well, that's probably part of our property.
Yeah, I mean, based on the records, ma'am, it shows to be yours. And when we looked at this crossing, we did in fact consider the best crossing that would impact the least amount of resources as possible. And even before we had met each other at this hearing, the decision to avoid the significant forested area north of our current crossing was made to move the crossing into these pasture areas on each side of the river in Iowa as well as in Illinois.
But, sir, my concern is also for the city of Keokuk, which draws all of its water from the Mississippi and is only about 7-8 miles downstream. And if there were any kind of an incident, there's a lot more people than me that would be in peril.
So when we came up with our crossing, we looked at HCAs, and this river is an HCA, as part of our design to ensure that we took into account water sources and public waterways, navigable waterways such as the Mississippi. We did a balance. We looked at not only the forested cover type on each side of the river, which I know it's a little bit fuzzy, but on the left-hand side, you can clearly see we're within an open pasture. On the right-hand side, the orange drill box is actually covered in green, but it is pasture underneath. And we also added valves on each side of the river to isolate this because of its HCA to minimize impacts to drinking water sources or to navigable waterways.
Now, are there security cameras on those valves?
No, ma'am, there's not. And so we believe that when we were routing the pipeline, that we did in fact take into consideration trees, the habitats, cultural resources, excuse me, wetlands, the water body itself, and to have a lineup of the river that would be straight to create the pull string, which is actually on the Illinois side, to have an effective drill of the river. That's a very long drill, a very technical drill, that you want to make sure you get it done right the first time. As far as safety goes to the drinking water source or to the navigable waterway, this pipe is very deep. I don't know the exact depth, but it's probably 75 foot below the water line at that point. Maybe it's 50 to 75, I can't remember exactly. So the likelihood of oil, even if there was a problem, originating in this location are very low.
Okay, and now shifting gears slightly, I'd like to know about the fixed wing aircraft that will be flying over. At what height will the aircraft be flying?
Our typical height that we train our pilots to is 500 feet.
And in the process of going across the state, has Dakota Access run into any wells on individual landowners' properties? I mean, does the pipeline cross personal or landowner wells?
I'm sure we did. I don't know exactly, but we do identify all wells within 150 feet of the center line of our pipe. And if we do have a well, then we will take measures to avoid the well and monitor it pre and post construction.
Okay. And then earlier, when you were having a conversation with Mr. Sandegren, I only got part of it written down. You said that you'd had emergency meetings with emergency personnel throughout the state, and it took about 3.5 months, but I didn't catch the number of actual organizations that you had met with, such as fire departments, et cetera.
I didn't give you a number.
I thought there was okay.
No.
Was it just county by county, or was it
was
community by community, or?
It was mostly county by county. We had initially started out with the emergency response organization of the various counties, and they helped us organize the meetings with the local emergency responders within the counties where we were going to traverse them.
So what I'm getting at is I'm thinking of like Webster County, and that would be, Fort Dodge. You're probably not familiar with these areas, but there would be various surrounding little towns. And so are you telling me that the little towns would have been invited then, to the major meeting in the county, or would, I'm still not totally clear on just how many, because like in Webster, in the case I'm thinking of, the pipeline goes about a mile north of the town of Gowrie. And in that, and Gowrie has a volunteer fire department, and we're in Webster County. But So I'm just wondering whether they, or examples of situations like them, would have been included in these meetings that you had.
Yes.
And I think I only have one more question. I have to back up to find it. Oh, actually, I have two. The bentonite clay is a natural product, but is the one that you use patented or not?
No, bentonite clay is bentonite clay. It's
Okay.
just dehydrated.
Yeah, okay, let's see. Oh, yes, on page 9, I don't think you probably need to look this up, but on page 9, lines 6 and 7, you speak of the oil spill fund, which is $1 billion fund, or the balance of the fund, whichever is less. And I was wondering, is the fund currently at $1 billion, or is it below $1 billion? And do you know how much that figure might be?
I do not. I'm sure it's on their website, though.
Okay. All right, I have to throw this in for my daughter. On on page 13, line 22, you mentioned that there will be personnel being staged at Meredosia, Illinois, and this is kind of in reference when you're talking about in Iowa, in the northern part, you might require people in South Dakota to be of assistance, and in the southern part, you might require people from Illinois to be of assistance. And my concern was that in Meredosia, Illinois, there's a national wildlife refuge, and I wondered if that comes into play at all.
No, we don't cross it.
Okay, thank you, that's all.
Yes, ma'am.
Your Honor, Dakota Access would move admission of JM4, which is the Mississippi crossing map.
Is there any objection to the admission of JM4? Seeing none, it is admitted.
Madam Chair, Mr. Zakrasik would move to admit Zakrasik Cross 3.
Is that this one?
No.
It's this
No
one.
objection.
Seeing no objection, so admitted. Mr. Wells, I'm thinking about, how many questions do you think you have?
Oh, 5 or 6. I don't think they'll take very long.
Proceed, Mr. Wells.
Thank you. Mr. Mahmoud, do you recall in your exchange with Mr. Taylor that you suggested that the proposed pipeline would spur an increase in production in the Bakken oil field?
I don't think I said spur an increase in production. What I do think it will untap wells that are shut in. There's a difference. So the well's already been drilled and waiting to be connected to an outlet. And so right now there's wells that are shut in that don't have a home because of either a lack of transportation, or it could be depressed pricing, just for whatever reason. So I think once the pipeline goes into service, I believe that there will be a release of that product that is sitting in the ground as opposed to being flown out to be transported.
Okay. So another way of saying that is that the proposed pipeline would facilitate an increase in fossil fuel extraction in the Bakken oil field?
No, I don't think I would say that. I think the extraction is going to happen regardless of the pipeline. I think what it does is it facilitates the transport of that produced oil at a different pace than maybe it otherwise would be.
Okay. In your testimony on page 15, line 11, it starts, the sentence is, let's see if we can read it. Therefore, it becomes even more paramount to Iowa that the U.S. have a strong network of reliable and affordable sources of crude oil to sustain Iowa's basic necessities of fuel. You testified earlier in your exchange with Mr. Prey that we're not really having any difficulty in Iowa in obtaining petroleum products, correct?
Well, I think what I would say to that is today Iowa's dependency upon sources outside of Iowa are 100%.
But you said to Mr. Prey, right, that we're not having any difficulty at this time.
I think the state of Iowa, being a dependent user of refined products in the U.S., has a dependency and a need to have a sustainable source of crude oil to fulfill their needs.
You're not answering my question. Question is, did you say that we're not having any trouble getting crude oil? Getting petroleum products now.
We could go back to what I answered. I don't recall. I don't think I said that in the terms that you're using it. That's why I'm answering the question the way I am.
Okay. You're aware that, I'm sure, that petroleum products are bought and sold internationally.
I am.
Are you aware that the United States exports millions of barrels of petroleum products every day?
I am.
Okay. Would you expect that some of the oil that would be transported through the proposed pipeline would be exported in the form of petroleum products?
I have no idea. They're originating in Patoka, Illinois, to be redistributed from there. It's about 4 million barrels that gets exported on a daily basis. I think the likelihood may be there.
So you have, okay. On a different subject, is it your understanding that the Army Corps of Engineers has the responsibility of oversight of the construction across waterways?
They have jurisdictional responsibility for the crossing of waters of the United States. And as part of their jurisdictional responsibilities, they actually do have what are called best management practices. And those BMPs are pretty standard form as part of the Clean Water Act under 402 of the Clean Water Act and 404, which 402 is stormwater, 404 are the waters of the U.S. for nationwide permits and individual permits. So the Corps issues standards for which we have to employ to cross those waters of the U.S. in accordance with the conditions of the permit. It's actually a standard condition that we have to employ the published best management practices. They have the ability to monitor and enforce our compliance with those conditions.
Thank you. Do you know if they have the staff and resources to oversee all the crossings in Iowa?
I do not, no, sir.
One last subject. In regard to the people that have signed the easements, would it surprise you that many of them would prefer that the project not go forward?
Well, what that tells me is 75.2% of the people want the project to occur because they've signed voluntary easements.
What I'm asking is, of the ones that signed the voluntary easements, would it surprise you that many of them would prefer that the project not go forward?
And I'll restate what I just said. 75.2% have signed voluntary easements, and that number is growing. So that indicates to me that they're okay with the pipeline. So the assumption that you're trying to infer is strictly that, an assumption, where I believe my numerical data demonstrates that they have voluntarily signed an easement that allows this pipeline to come through.
If the project were not to go forward, isn't it true that they would still be paid for their easement?
Well, they have been paid for their easements.
Or they have been paid? Okay. No more questions. Thank you.
Thank you, sir.
I know you really want me to come to you, Mr. Long, but I am done. I have, Mr. Sandegren, did you get your answer to the mathematical question? Mr.
I have it.
Can you provide that to him?
I will. You want me to just do it now?
Yeah.
So it's 85.7 miles.
And I thank you.
Yes, ma'am.
And I don't know if I cut you off earlier on that, but if I did, let me know. Or let Cecil know, he'll tell me. We are going to recess until 9 a.m. tomorrow morning. When we come in, we have a full day, and Mr. Mahmoud has promised he will be back by sometime around 2. And are there any, I'm kind of scared to ask, are there any other matters? Seeing none, we're recessed until 9 a.m.